They should have a little green light.
All right, we're calling the Board of Review to order. It is September 4th at 10:01 a.m. And I believe this meeting is being recorded. Anything I need to say, or that's
video recorded and audio recorded?
okay? All right, we will go with the roll call. Oh, first, yes, thank you. We have the Pledge of Allegiance. Let's all rise and stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. We will do our roll call. We have Cindy Schmier.
Here.
Gary Boisitz.
Here.
Mara Spring.
Here.
Henry Passbrigg.
Here.
And Jeremy Kyle is here. All right, we have all 5 of us. Good. We've got a statement of public notice from the clerk.
This meeting was noticed in accordance with the open meeting law on Tuesday, September 2nd, 2025.
All right. And then we've got minutes from our last meeting, June 5th, 2025.
Sorry,
Yes.
August 22nd, right?
This meeting was noticed in accordance with the open meeting law on Tuesday, September 2nd, 2025.
Okay.
We did post it 2 days ago.
She's saying was the first meeting June 5th?
Yeah.
Yes.
Okay, then we're okay.
I heard September 22nd, so I
Oh,
was,
September 22nd. Gotcha.
but it was
Okay.
September 2nd. We got it.
Yes, September 2nd was noticed. September 4th is today. But June 5th, 2025, we had our last meeting. And we've got our minutes and the binder. And we'll review those and approve. Or if anyone... All right, I'll take a motion for approval from anyone.
I'll move for approval.
I'll second.
All right, Gary Boisitz moved and Mara Spring seconded. All in favor, say aye.
Aye.
All opposed? All right, the minutes are approved. Now we've got next, we need to verify the training requirements pursuant to Wisconsin Statute 70.46.4.
Board members who have attended the required training were Jeremy Kyle, Mara Spring, and Cindy Schmier.
All right, and we just needed 1. We've got 3.
Yeah.
So there we go. Review new assessment laws, if any, which I don't believe there are already.
No,
but
nothing's
Jeff.
come through.
Okay, all right, perfect. Then we'll take the annual assessment report by the assessor's office.
There's a button on the bottom, or we're in the middle, yeah.
Thank you.
Okay. See if it was,
Good morning.
there you go.
Nick is passing out a copy of the annual assessment report for the board's review.
Thank you.
My name is Sam Monroe. I am the assessor for the city of Muskego. I work for Tyler Technologies. I'm currently certified as a Wisconsin Assessor 3, and my certification expiration date is June 30th, 2028. I've been the primary assessor here in Muskego since November 1st of 2023. The assessment information for this year, the assessment type was an interim market update, and the estimated level of assessment is 100%. We currently are utilizing the IAS World CAMA system. The Board of Review's final adjournment date, we have listed as 9/5/2025. Historically, 2024 was a maintenance year, 2023 was a maintenance year, 2022 was a maintenance year, and the last market update before 2025 occurred in 2021. Besides myself as the assessor, assessment work was completed by Nicholas DePalma, who is an Assessor 2. His certification expires May 12th, 2026. The assessor's oath of office was taken on January 24th, 2024. This year, we mailed out the notices of changed assessment on July 30th of 2025. I have signed the assessor's affidavit and attached the assessment roll today, 9/4/2025. The municipal assessment report, the estimated, was filed with the Department of Revenue on June 9th, 2025. Corrections and omissions discovery, we had no corrections or admitted omissions of property this year. Open book information, the date of the first open book was August 4th, 2025. We reviewed 310 parcels through the open book process, and there were 237 changes of those parcels that were reviewed. Revised notices were sent out. The date of the first board of review with the complete assessment roll was today, 9/4/2025. No need to reschedule, and the assessor is here to defend the assessments. We also had no palpable errors or omitted parcels to correct this year. The summary of the requirements, property inspections, there were a total of 370 properties that were inspected. Property sales for this year, there were 667 sales. Total sales reviewed for validity were 231. Number that was determined to be valid sales were 228. The building permits, there were 824 building permits that initiated 370 field inspections. New construction, the number of new construction permits filed this year was 44. We did analyze new construction and adjust for value changes. Between the residential, those permits, the residential side, we had an increase of $58,400,400 on the residential permits. And we had one new construction parcel for the commercial, which was $1.21 million. Agricultural parcels, total number of parcels is 320 agricultural parcels. Total number of inspections were 20. We did make determinations on the agricultural use by drive-by and use of online maps. We did update the agricultural land values using the Department of Revenue's use value rates and adjusted the overall assessment level for the current year. We did conduct a ratio study for the previous year and the current assessment year. Under the work activity, there's currently 9,112 residential parcels. There are 373 commercial parcels, 320 agricultural parcels, 76 undeveloped, 0 agricultural forest, 52 productive forests, and 61 other parcels. All parcels were reviewed and values were adjusted through the interim market update. The current and previous year ratio studies for 2025, there were 209 valid sales. The total assessed value of the valid sales parcels was $73,291,300. The total sales price of the valid sales parcels was $105,029,800. The aggregate ratio was 69.78. The mean was 70.94. The median was 70.95. The coefficient of dispersion was 9.95. The coefficient of concentration was 78. The price-related differential was 1.02. For 2024 residential, there was a total number of valid sales of 205. The total assessed value of the valid sales parcels was $74,400,700. The total sales prices of the valid sales parcels was $97,997,104. The aggregate ratio was 75.92. The mean was 76.70. The median was 76.37. The coefficient of dispersion was 7.50. The coefficient of concentration was 87.30. The price-related differential was 1.01. For the commercial ratio study in 2025, there were 7 valid sales. The total assessed value of the valid sales parcels was $7,324,900. The total sales price of the valid sale parcels was $10,925,000. The aggregate ratio was 67.21. The mean was 71.38. The median was 71.97. The coefficient of dispersion was 15.31. The coefficient of concentration was 42.9. The price-related differential was 1.06. For the 2024 commercial ratio study, there were a total of 8 valid sales. The assessed value of the valid sales was $4,010,100. The total sales price for the valid sales were $5,640,000. The aggregate ratio was 71.10. The mean was 71.90. The median was 71.25. The coefficient of dispersion was 10.94. The coefficient of concentration was 75. And the price-related differential was 1.01. In the notes at the bottom, we do see that the above is based on the improved sales only, as vacant land sales are insufficient to determine overall economics. There were 12 residential vacant land sales with a total assessment of $1,420,400 and a total sales price of $2,118,200, an aggregate ratio of 67%, a mean ratio of 66%. There was one commercial land sale with a total assessment of $129,400 and the total sales price of $265,000. The aggregate ratio was 49 and the mean ratio was 49. And that completes the assessor's annual report for 2025.
All right, thank you. Next, we'll have you, the assessor, submit the assessment roll to the city clerk.
We actually already have it, and it is right here.
All right.
And it's 3 books, so they're labeled on the front where they get that. And then I will now give it to you.
All right, thank you. You've got the assessment roll.
Skip to the next one. And I also received the affidavit. We've already signed the affidavit and sworn.
The sworn statements?
Yep, for the roll.
Okay, so that's the assessor affidavit. So that's the next thing saying city clerk to present assessment roll and sworn statements to the board. That's the affidavit that is presented. Next, we'll establish procedures of operation and deliberations.
So this is for the record, and this is just so that everybody knows how you're going to go about hearing the objections. So you just kind of go through the process, you know, who goes first, who goes second, how you guys are going to do your determination, all of that.
You got that, which I've
I
got
think you have a script.
written down here.
Yeah.
Yep. Got a lot of pages to go through.
No matter how hard you try to organize.
That's right. All right, where do we have that order?
You can kind of paraphrase some of it.
Yep, I will do that, that's for sure. All right, so the clerk is going to introduce the case for the hearing, and then she will swear in all the witnesses, including the property owner and the assessor. Then we'll go through the hearing procedures, which is the person filing the objection will testify and present their evidence first. The assessor can then ask the property owner or objector questions. Then the Board of Review members may ask additional questions to the property owner. After the owner testifies, any other witnesses present in support of the owner will testify. And then each witness will be subject to questions from the assessor and the Board of Review. Then after the owner and all their witnesses have testified, the assessor presents their case in support of the assessment. The property owner can then ask the assessor questions, followed by the Board of Review can ask the assessor questions as well. After the assessor testifies, any other witnesses in support of the assessor can testify. The property owner can ask that witness questions. The Board of Review can ask that witness questions. Then the property owner can respond to the assessor's testimony by perhaps presenting other evidence, and then there can be additional questioning from the assessor and the Board of Review members. The assessor may then present any other evidence in support of the assessment, again, able to be questioned from the owner and the Board of Review members. After all the evidence has been submitted under oath, the property owner may make a brief summary of their case to the Board of Review. The assessor can then make a brief summary of their case to the Board of Review. And after each summary has been presented, we will close testimony. Then we, as the Board of Review, will deliberate on the testimony in an open session, either immediately following testimony or at a later date to be announced, and I believe we're doing it immediately. So we're going through each case at a time. After we've deliberated, then we tell the property owner that we are required, the Board of Review is required to uphold the assessor's valuation as being correct unless the owner by testimony has shown that the assessor's valuation is incorrect and that the burden of proof is upon the taxpayer. We want them to understand that. Then we will begin the hearing with having people present their name and address. Oh, that's kind of like going back and forth. There we go. Then we will, after all the evidence has been presented and everyone's made their final case summaries, we will ask if anyone on the Board of Review thinks that the evidence is insufficient to proceed to a decision. Then we'll close testimony. I feel like these two things are kind of out of place.
Yeah.
I will reorder those. And then we will have our findings of fact, determinations, and decision form. We will go through that and make a ruling based on the best evidence that we find.
And just for notice to the public, evidence normally closes at the end of both testimony. That summary settlement you're talking about, when they make their, that's usually just, nobody asks questions or anything. That's normally just their chance to present to you what they feel they've proven.
Yep.
Normally, it's not a question and answer period, just so the public knows.
Perfect.
And then you make your decision.
Thank you. So that's how we proceed with that. Let's go back here. All right, then we get to review the assessment role, perform our statutory duties. I'm going to hold on that because I'm curious, there's no corrections of error under the state law. So that's on there, but we don't need to do that. And a question to the assessor is, are any open book changes, all the open book changes, they are included in the assessment role?
Yes, all open book changes are in the current assessment role.
Perfect. We've got that. I think we're going to do then reviewing notices of intent to file objection. Sound good to you,
Sure,
Jeff?
that's fine, yeah.
All right. Now, is that basically saying that we've got the schedule
So,
here?
Everybody has filed their notice of intent to object. So everything that you have on that schedule there, yes, we have received their notice of intent.
You had one,
Now, those are on the next page when we get into, because we're saying that we're going to proceed to hear the objections, that's what we have on there, on the
Yep.
agenda. And then so it gets a little kind of confusing, because during the
Yes.
first 2 hours, we do have to talk about the waivers. So
Yep.
and the waivers and the requests to appeal to court and testify, so we could actually do that, like, right around noon, like
Yeah.
right before or
That
after
sounds
noon,
right.
Which would be the piece of paper I gave you right there. We just
Okay.
have to make sure we note that. Does that make sense?
yes, and this
Just came in.
this one that just came in,
That's what Jenny was doing here.
that's not on the 19
No,
listed.
no, just the objection came in.
Okay,
Sometimes they're submitting their notice of intent, and then they're not giving us the objection right away. So actually, the first 2 hearings we have, we don't even have their objections yet. So if
Gotcha.
you look at the first column on your schedule where it says objection, the first 2 for number 1 and number 2, he hasn't submitted that yet.
okay. Got
And
it.
then there's, and number 5 has not, and on the second page, 18 has not, and 19 just submitted it. So,
Okay, that's what you're saying, yes, so they noticed their intent to file.
They all have done
They
that.
hadn't yet, but somebody just gave in.
Yes.
That was the person
And
listed
we
last.
do have one that his intent was filed after the 48-hour period.
Okay.
And he has submitted good cause. So, but that is on your actual agenda.
And we'll get that to that
Yeah,
one.
so we'll
Okay.
get to that, but we'll do that.
Okay,
Just as it comes up, we'll do it.
right, okay, perfect.
So, but Carrie, on the ones that they filed the intent but no objection, could they have till, what is it, noon today?
Noon.
Okay.
Unless they're making a finding of good cause or something. But let's just wait till noon.
Right.
And see if those come.
But yeah, I haven't had anything new. So everybody that's in the book, we've gotten an intent.
Okay, perfect. Good. Well, we can allow taxpayers to examine assessment data, which is here, if any taxpayers would like to do that. Review notices of intent to file objection, I think we have covered that. We've got the listing of the people who have intended to file objection. And then proceed to hear objections if any, and if proper notice, waivers are given unless scheduled for another date. I think that's just kind of open book for anyone to object right now,
Correct.
which.
We don't have anybody here. so-
Objecting, yep, okay. And we've got till noon
2
for that,
hours.
2 hours for that.
And then even if they don't do that, we'll get into that then. You guys
Yep.
can do a good cause or an extraordinary circumstance. But
Right.
let's just wait till noon before we get into that.
Yep, perfect.
So with that being said, our first hearing, we scheduled for 10:30. And that would be number 1 in the little teal colored, page that you have in your book. And, I did send an email to everybody letting them know if they wanted to arrive a little bit early, they could. He's by telephone, so I would think we can certainly give him a call. If he's not available, then we'll call him back at 10:30. Yes?
Right, and then it's up to the board. You know, normally in court, a judge would allow 10, 15 minutes. So it's up to the board if you want to allow a little time if somebody's late or we can't get somebody on the phone right away. You know, what's reasonable, 10 minutes or so before you declare it that they're not coming here.
Should we do that, or should we go to maybe this, there's
Well, I think we don't want to do that last part until noon.
the waiver of good cause? This
Yes,
part?
because,
in case
am I
there's other
right?
ones.
Right, because people have these 2 hours.
Yeah.
Okay,
So at noon, we'll do that.
all right.
And that's kind of when that time frame closes.
That makes sense. So we'll wait to do the ones that have already done.
So you're kind of right now stuck at the 10:30
In a
one.
way.
So if, like Carrie, if you want to call early, you can try. If you guys want to wait till 10:30, you can do that.
Well, and real quick, you said that, well, we've already got our findings of facts determination decision.
And so number 1 and number 2 are the same property
Individual.
owner for 2 properties.
Yep.
Why don't you ask that on the record for Jeff?
Does there have to be a vote to allow people to testify by phone? Do we have to do that right away?
Yes.
Okay.
Yes.
Is it a roll call vote?
No, only the determination is a roll call vote. Everything else is just,
Okay. So in your binders, you've got the findings of fact, which are 3 pieces of paper, but 6 pages long. You have the notice of intent, and behind that, in front of you, you have your request to testify by telephone. And that is for the first hearing, sorry. Jeff, can they do that at the same time for number 1 and number 2, since it's the same property owner?
correct, but I would now look at the request to testify by telephone and make a decision on that
Okay.
before you make the call. Because if you decide not to, you'll make the call and say, we're not allowing it.
Yeah.
If you decide to, you'll make the call and allow it.
Yep.
Thank you, Mara.
All right, so I'm seeing the request to testify by telephone. It is signed on September 2nd. And I'm just looking at number 1 and number 2 together.
Yeah.
Same person. So they're both the same. They state they will not be available to testify in person because they will be out of state at their home and business in Clearwater, Florida.
And
that's
so
their
there's no
request.
real criteria. The board just looks at what they feel is reasonable. So if a person says, I'm out of state or town, that's reasonable. But if a person says, I didn't feel like coming because I'm going to Walmart today, so that would be your decision.
All right. So we've reviewed the request to testify by telephone. I'll take a motion to approve or deny the request.
I'll move to approve.
All right, Mara moves to approve. Second. Henry Pottsberg seconds. I'll take, you said not roll call, so all in favor, say aye.
Aye.
Aye. All opposed? All right, motion approved. So then Jeffrey Kierleber can testify by telephone, and they've got the 2 properties, which we want to focus on one property at a time.
Yes, do one at a time.
But we're going to do the motions for both, correct?
Yes,
Okay,
yes,
thank
they're
you.
going to allow, you mean the telephone?
Yes.
Yeah, that counts for both.
Okay, thank
Yep.
you.
Yep.
So if you want now, Carrie, it's already 25, you can make a call if you want.
I know.
All right.
There's a long story behind that. Oh, okay. Well, you can actually leave it up there.
All
'Cause
right.
if he is available, like I said, we're gonna have to gather around the phone. And then it does say, which I don't think we've done this in the past, it says I have to notify him, would you mind dialing?
And you're sure you tried we do the microphone thing in it, you've tried it and there's too much reverberation?
Yeah, we
You've
tried
tried
it,
it?
yeah,
Okay.
Sam and Jake and I
Because we do
tried
it for court but they must have done something. We do it for court and it works, but that's fine. We can,
Okay, do you know how it's done?
you're talking to a guy who has nothing, no, we could get Jake real fast and see.
Jake didn't
Oh,
know.
oh.
This is all I'm-
She
this is all
just
being recorded.
takes the mic and does one of these and maybe puts the phone on low and it's fine. It all comes through fine. You could try it and see if it works. If not, we can,
9,
yeah, so let's just try it.
1,
Do we have an extra mic?
262, 893, 8228, and I'll talk first because I'll let him know that he's been approved but he hasn't filed his objection yet.
Okay.
table.
Person you're trying to reach is not available at the time. Please record your message. Finish recording and
Hi, this is a message for Jeffrey Kierlieber. This is Carrie, the city clerk for the city of Muskego, recording secretary for the Board of Review. We are calling to let you know that your telephone testimony has been approved, and you aren't available, so we will,
10:40, is that reasonable,
we-
everybody?
we'll give you a call back by 10:40 a.m., and if you're not available at that point, then your hearing will not be heard.
Right, the board will deny.
We'll just point out that that's Central Standard Time. It looks
Oh,
like
yeah.
you might be in Florida.
That's
Thank
right.
you.
Yep, so we're talking here at 10:30 a.m., 10:26 a.m., we're giving you a call Central Time. We'll hold and call again at 10:40, but would appreciate a call back earlier. Thank you.
Does he have the number to call back?
Well, I don't know what the
I was
number.
gonna say, so we'll just have to call him, unless he calls through the,
You might see the thing.
This is like
That's all right.
fun. I'm glad this is all.
I see that the third person has a request to testify by telephone. Any objection to review that? I think we may as well
makes sense to do that.
be productive. Yep. All right, so we're going to look at the third tab and consider. All right, so this is Cal Evans, the agent for Tree B Property Holdings. Do we need to approve the agent as well?
Yes.
So I see the objection, I see our findings of
There-
facts.
You just need to look at the agent authorization and just,
Yep.
if you think it's okay, you can leave it alone. If someone wants to talk about it and discuss, you can do that.
All right,
Everybody just kind of looks at it.
yep, perfect.
You don't really need a motion on it.
In council chambers, okay.
Okay, yeah, I see sign agent authorization in there.
And then your telephone would be, says he's out of the country.
Yep, I see that the agent says that they are out of the country at the time of the hearing. If possible, they would suggest that method.
Zoom or Google isn't gonna be,
No.
we'll just do the telephone.
Yep,
He notes in his letter that he thinks an international call is going to be difficult. Do we have an international number for him?
That'll be Jake's question. That's a good point.
Sure.
So would we be able to allow an international call to come in here?
That's a Bob question.
Okay.
I'll just try swapping this.
Well, when are we on,
Well, I
Jeremy?
guess it's,
so we're looking at number 3 on the request to testify
Thank
by
you.
telephone.
Thank you.
All right,
So you guys are moving forward? So everything's-
yeah, just
Oh,
to
cool.
do that, I'm going to write this down.
Um,
Yep, so looking at Cal Evans, the agent for Tree B Property Holdings, they've got a request to testify by telephone. I have reviewed it, I see others have as well. I'll take a motion to approve or perhaps deny the request to testify by telephone.
I'll move to approve it.
All right, Mara moves to approve the request to testify by telephone for Cal Evans.
I guess the question is, are we moving to approve the request at the number indicated, or are we changing numbers if we can't reach?
well, to be perfectly honest, I spoke with Cal, and he did not bring it to my attention that he wanted to do a Zoom or a Google.
Well, this
did give
looks
a
like his
phone
cell
number.
phone number.
Yeah, he gave a phone number. I think it's approving it at the telephone number, and if needed, we can try other means, do our best efforts.
It was just a question.
Yep.
You know, yeah, how limited we are, or are we gonna try to reach them at other?
I think we'd
By other
try another method if we
I just
have the
walked
ability.
out, so are you talking about the telephone out of country?
Yep.
Barb's not here, but I'm thinking that it would be, the call would be okay to come in, so
Well, I dialed that number, but he's asking, so she noticed on here, he's saying on here, he's suggesting Zoom or Google.
Yeah.
I can't do that.
No, it's, yeah.
That.
it only is what we can do. We're not gonna do, we just can't
Okay.
do Zoom or Google.
And we don't have an international number, we only have a cell.
Oh.
And that's what I'm trying to point out.
Oh.
How far are we going? Are we just approving this, or are we gonna allow some leeway and try some other method to
If it doesn't
contact
work?
them? If it doesn't work? Or are we gonna
Your
deny
call,
it?
but your call, but I would call the number that he's saying is the best number to reach him at.
And I would suggest that the motion limit itself to exactly what's on the document as opposed to anything further than that.
Correct.
I'll amend my motion to say I would move to approve attempting to call him at the 949 area code number listed on his application and allow him to appear via that method.
So first you're voting on the amendment, then you're voting on what Mara just said. So first, can you amend? That's the first vote.
I'll move.
Yeah, well, I haven't heard, one second, I haven't heard
Nobody
a
even
second.
seconded.
Oh,
so-
nobody, okay, then I'm sorry, I walked out, my fault.
No.
If nobody seconded it, now we don't need to do that.
Thank you for not seconding, I suppose.
Yeah, good move,
Okay.
yeah.
Mara can state her,
So
her
first
motion.
there's no set motion, now her first motion is
All
this.
right, so my motion is to permit Mr. Evans to testify by telephone at the phone number listed on his application.
And I'll second that.
Second, okay.
All right.
Now you can vote on that.
All right, so for that motion for Cal Evans to testify by telephone at the telephone number listed, all approved, or approved, say aye.
All in favor?
All in favor, thank you. All in favor, say aye.
Aye.
All opposed? All right, so the motion passes for Cal Evans to testify by phone at the number presented.
Thank you.
It's 10:33, should we try again?
Sure.
You
Okay.
can, but we gave him till 10:40, so, but you can.
Yeah.
So, I think we should try again.
Go
Yeah,
ahead.
Okay.
as well, because
Go
it's
ahead.
close to the time.
Okay, so I just got instruction from the municipal court clerk as to how we do the telephone.
Okay.
So, she said just aim it towards it is all. Do you want to dial again, Jeremy? I'll give
I
you
will
the
do
number.
that. Let me find the best
So,
number.
Gina, we keep it on this table and just, okay.
Oh, look, she's even gonna hang out with us because she's so awesome. All right, 9 first. 9-1-262-893-8228.
Now you can point out the timers again if you get a voicemail.
Hello?
Hi, is this Jeffrey Kyrlever?
It is.
Hi, this is Jeremy Kyle, the Board of Review Chairman, calling on our time here to review your, well, it's not the right case, your objection.
Oh, okay. Did we have a set time?
We have a set time that was emailed to you at 10:30 a.m. for the first property address, 10:30 a.m. Central, and then 11 a.m., really just including that, for the second property address.
Okay, I'm in Florida,
Wait
I'm
till
on a
Becky
job
Ackerman.
site.
She's the one that's been communicating with me. Hi, this is Carrie Roller, the city clerk for the city of Muskego.
Hey, how you doing?
I sent, I sent two emails to Becky, actually letting her know that there was going to be a meeting today for both of your properties.
Okay, now, sorry, it's loud here. This is just, two parcels that we have, and it's just vacant land, right?
This is for the property address S85 W21531 Janesville Road.
Okay?
And the second one is the same address, but the rear parcel.
Yeah, and you have them both as vacant, right?
I don't
Vacant
know
land?
that, but
Okay.
yeah, and you had requested for the ability to testify by phone, and we have approved that.
Okay. When did you approve it?
Well, we're approving the request you have to testify by phone as opposed to having to show up in person. We
Right,
approved
right.
that just now. That's something we do during the first 2 hours of our Board of Review meeting.
Okay. I mean, I don't have anything in front of me. I had no, now maybe somebody sent me an email this morning, but that's kind of short notice for somebody to see that and react, especially when I'm 1,200 miles away.
Right on.
Yeah, I mean, I do have a file on it, but it's at my Florida office, and I'm about 15 miles away from that right now. Yeah, I could have rearranged my schedule if I would have known, but I didn't. Didn't know it.
This is just when I emailed it, and I emailed it to Becky
Yep.
Ackerman.
So it looks
She's the
like,
one who
is it,
submitted it.
is Betty Ackerman, your assistant or someone? We'd emailed it at, August 29th, 2025, stating that the time was 10:30 a.m. Central Time on September 4th.
Okay, well, yeah, she's been on vacation. She's back one day. That's today.
Okay.
What do we do now? What did the assessment go from what to what? So I can recall it.
Yep, so that hasn't, what you received was a notification of the assessment for this tax year. You
Yep.
had filed a notice of intent to object, but
Yep.
we have not received an actual objection. And then we also, in that email, we had a Board of Review information sheet sharing that objection of real property assessment information.
Can I jump in?
Yep, I'm going to have our attorney, Jeff Warhol, say hello real quick.
Hello, sir. This is
Yeah.
this is the city attorney. Today is your day for your hearing. The hearing is all scheduled, and you are supposed to provide a reason for your objection, and then the assessor provides their reason, and the board here, who's all ready to go, makes a decision. And so, number one, it doesn't sound like you're ready, and number two, you haven't filed an objection. You filed your notice of intent, but the law requires a notice of intent and an objection. And so, is it your intent to file that objection by noon today? Doesn't sound like
I
it.
would assume. I mean, I would assume so. I mean, normally we discuss something with the assessor ahead of time, and if we don't come to a conclusion, then we have time to file an objection.
But sir, this
Maybe doing it differently.
this is your day. This is basically a court, like a courtroom would work, and assumptions
Yep.
don't work in a courtroom. And so you're making an assumption that's of no value to me or the board. So I mean, you can ask right now for an adjournment of today's hearing, and the board can make a decision on that, but that's kind of where you're at. Today's your day, and the board
Yep.
gets to decide whether they're going to hear anything. If you don't have anything prepared to hear, then your only option would be to make an adjournment.
Okay, and let's say I make an adjournment and you don't give it to me. Can I then?
Nope, then you're
I mean,
then you're done. You're basically done.
Okay.
I'm sorry, sir, but this is the way it works, and you're supposed to be informed. I can't give you advice, and I'm looking at the notice, you were given proper notice. So again, today's your day. Again, it's like a court. You need to show up
Yeah.
and be prepared, and it sounds like you're not. So I can't really answer to other than that, but to explain to you that that's the law and that's what we're doing today, and we're all here ready to go.
Right, well, okay, then just forget it. I mean, this is goofier than shit. Got people on vacation. I don't get an email, and all of a sudden I'm the guy that's screwed. So just forget it. All right.
All right, that's fine.
Thanks for the courtesy. Bye.
So just can you make a finding on the record to what he said?
All right, well, I suppose, yeah, so we can still find related to that.
I have a question
Yeah.
for our attorney. Since he didn't file an objection, do we have to do anything?
Well, with that being said, though, I have a question.
Well,
He has till noon.
He's got till noon, but he's just informed you that he's done. And so I would just say, even though he has till noon, you're going to forget that and you're going to make a finding right now based on his own statement. He's not filing by noon, and you're going to make a finding that he's basically denied.
Well, technically, he withdrew his objection.
Or withdrew.
Right, so do we have
Withdrew
to
his
do
intent
anything?
to object.
Right.
He withdrew his intent.
So if he withdrew, I see what you're saying, Mara. I mean, Do you need to do anything? Probably not. This is half a dozen of, this is just, should we do anything? You don't have to. Legally, if you want to just put on the record, he withdrew his objection and you're pretty much done with this.
Well, we're basically saying he withdrew his intent to.
I'm sorry, withdrew his intent that he didn't file an objection. And based on all of that, you got tons of stuff here. Based on all of that, you're just going to move on to the next hearing.
Because when I have withdrawals, I do keep record of that as well. So it does stay with all of the documents that we have. So I could just note on the notice.
Right. I think a good record's been made that he withdrew.
Right, and I guess my suggestion, I don't know if it would be a motion or what, is to wait till noon, and with everything else, deal with him.
And
I'm fine with
and I
that.
would argue the motion that it shouldn't be that he should he basically indicated he was withdrawing his intent to object because there was no objection on file. The only thing we have is that he intended to object, and he indicated to us that he no longer wished to do that.
Right.
So I don't think he even has till noon, to be honest with you.
So now it would be discussion amongst all of you and majority rules.
Yep.
Yep. I'm hearing both sides of, if you were to walk in before noon, that's a different thing. I suppose he could object before noon. All we're saying is that he withdrew his intent to file objection.
So
Is what we had heard
this is
from-
kind of a fine line. I've had people come to court at noon who has a court date at night and look at me and say, I'm not coming, and then they show up at night. I've had that happen just last week. I've had other people say they're not coming and they don't come. So, yes, Mara.
Just speaking with Mr. Boyce here, we were looking at the fact that anybody could file a notice of intent by noon, and we would have to determine whether we were going to waive the 48-hour notice.
That's the good cause,
So
extraordinary
now-
circumstances.
Now we're both on the same page, that if we wait till noon, then he's definitely waived it and we don't have to consider it. So maybe, I guess I'm going to move to not deal with this until noon.
And I don't even know if we need to move. I think it's just, I don't think we need a motion. I
So
think we're
is
just moving on.
discussion done, and Gary, you're okay with what Mara said?
Yeah, that's clear.
So we're waiting till noon?
We can wait till
Yeah,
noon.
and even, yeah, and if it went after noon, that he filed, you'd have to do the good cause thing. But why don't, this all makes sense to me, because like I just said, I've had people in court, I'm not coming, and then they show up. So he could do that, he could call back, right now he could call an attorney, or, hey, if you call back by noon, so it's a good idea probably to wait.
All right, so we're just moving on, not taking any action. I don't think we need any motions
Okay.
at all.
fair.
Yep.
I don't think, I'm just debating whether you need a motion on that. I don't think so.
I don't think so.
Yeah.
Yep. Good.
I think you're okay.
Well, we've already approved the request to testify by telephone for Cal Evans. I see one other request to testify by telephone today listed and two for tomorrow. I think that's a good thing to move towards with the time that we have right now.
Which one is that on
So,
the
number 8,
page?
Muskego School Apartments related to Pivotal Tax Solutions agent. So let's all just take a look at tab 8 and review. We're just reviewing now the request to testify by telephone. There's no motion needed, but also just make yourself familiar with the agent authorization as well.
Oh.
And these are all listed after the findings of fact and determination, where there's a notice of intent to file objection, there's agent authorization, and, do I see it? Oh, this is, sorry, request to testify by telephone or written testimony. Is this a written testimony one?
Yeah, I'll find
I'm not seeing the,
Sorry.
It's, did we miss?
oh, I skipped over it. It's my fault.
No, that's good.
Okay,
Did you all find it in your book?
Yeah.
Okay.
there it is, yep. So there's a agent authorization, which I see for, who is the agent then? The agent is just Pivotal Tax Solutions, there's no one listed, which is, it's a company, so.
I was exchanging with a Tiffany, and then a Samara called me yesterday.
I believe this happened last
Yes.
year on the same property with the same company. So I'll be interested to hear what's going to happen on this. But you can approve the agent.
Oh, I
Somebody.
see here, sorry, so, yes,
Christy
Gary
Morgan.
listed, Pivotal Tax Solutions, but listed on there as authorized agent is Christopher Glidewell, Austin Glidewell, Chaz Standage, and Wayne Tannenbaum. So those are the 4 agents that they've authorized, the owner
So
of the
if
property.
one of those people are able to testify, that'll be fine.
Yeah, perfect.
Someone else from Pivotal tries to, that's
It's
not an
on the-
authorized agent.
Right, yep. Then we have the request to
to
testify by
find them
telephone. That just lists the agent name as the business. And their basis for request is that they are out of state, and appreciate your consideration.
Can I just, I'm a little confused. I see Christy Morgan as am I on the wrong one?
No, Christy Morton is the owner.
Oh, where is all those people's names?
Section 2 on the agent authorization. So it's above the address. and
Very
they says it.
tiny.
Oh, I
Yep.
see it now. Okay, my eyes.
Tiny 'cause
my
there's
eyes
4 of
are-
them.
Yeah,
It's all
okay.
squished.
I'm good. I just wanted to make sure we had it. Okay.
Thank you. All right. So we have agent authorization, but then we're talking here about the request to testify by telephone. They list the agent name as Pivotal Tax Solutions, and they're requesting, basic requests are located out of state.
It's really.
So I'll entertain a motion to, one way or another, on this request to testify by telephone. And this is for the Muskego School Apartments on Janesville Road.
I'm just going to just state for the record, I haven't made a decision yet on this, but I'm looking at an assessment given to them at 2.5, and they're asking for an assessed value of 1.2. They hired an agency out of state that's now using the fact that they're out of state not to appear in person for frankly, over $1 million reduction in assessed value. I haven't voted on it, I'm not moving on it, but I just wanted to say something that that the board should have some criteria, at least in mind, or some agreement as to how we handle these. These are getting kind of, it's getting easier and easier for people to appear by telephone, but to me, it reflects the importance of the hearing if you require them to appear. I'm also speaking as a lawyer. There are plenty of times that I would wish that, I have a 3-day trial that I could just sit at my office and talk on the telephone while the trier of fact is sitting elsewhere. So that being said, I just wanted to make a record on
Well,
that.
and to your point, I know when you do a waiver, we have those lists of things you can consider. I couldn't find that for any of these, and maybe that's something we could think about for next year, to put together some kind of policy, at least some circumstances that you could use to consider when you're doing this telephone stuff, but we don't have it now, so it's your reasonable basis. As you know, and lawyers, reasonable can mean anything.
Right, and I very well understand their position. Don't get me wrong, I've made a lot of appearances
It's good
by
for the
Zoom,
record, yeah.
but it's really not for when there's a trier of fact involved, but be that as it may.
Well, it states that the board may allow, it doesn't say we have to, and it says if we may allow, we may not allow, as well. So it's up to our discretion on there, so, looking at the one-page form and the request to testify, I'll take a motion one way or another on this form to request to testify.
Can I ask a quick question?
Yeah.
What happens if we deny it, if they're denied the phone? What is the procedure after that?
They're basically done, because they can't testify by phone, they're not here, and
So they wait till next year, or?
yeah, they could wait till next year and do this again.
Right. Yeah, each year is a different
Right.
year. It's just this particular hearing. Are
Right,
they
if you
allowed to
deny
testify
it,
by
you're,
phone or-
if you deny it, you're basically denying, they don't have the right to have a hearing because they had to be here. So I kind of caution that, because everybody has a right to have a hearing, and I know they're not here, but I know what they're asking for, but we allowed it last year, not to say we've got to do the same thing every year, but it's just questionable because we don't have a policy right now. My advice would be to allow it, but you don't have to take my advice. I just here to give you advice. So that's my take on this.
I have the same problem that Attorney Boyce has, which is you have a local property owner who hired an out-of-state company and now is using that as an excuse to not be here. It just seems very odd.
And that is a good factual pattern to use in this one. It's not like your other ones, it was the person, but this one is you hire an agency who's already out of state and now they're saying I can't be here. So every case is different, as you know, and those are some, I think, good facts for the board to consider in this one. Again, your call, discretionary.
I'm going to take back what I said. I'm not going to make a motion. I'm going to move that we deny the waiver.
Just need a second.
All right, so Gary Boisitz moves to deny the waiver to testify by telephone, accepting a second.
If you don't get a second, it fails.
I'll second.
Okay.
Mara will second. So the motion is to deny the request to testify.
On this one, I would do a roll call.
I would do a roll call.
Yeah.
Okay, so Carrie will do a roll call of, if you approve the motion, we're denying the ability to testify by.
So if you say yes, you're denying it. If you
Yep.
say no, you're allowing it, or you're just voting down the
Denying the
motion.
no.
Right,
Yep.
right.
Yep, so aye is denying it, and nay is turning down the motion to deny. Yep.
Henry Posbrig. If you,
I want to deny it, so that'd be,
So you would be a yes that you're denying it.
Okay.
You're in favor of the motion.
yeah, yes.
Mara Spring,
Yes.
Gerald Boisitz,
Yes.
Jeremy Kyle,
I'll say nay.
and Cindy Schmier.
I'll say yes.
All right, the motion carries 4-1 to deny the Muskego School Apartments the ability to, rather their agent name, Pivotal Tax Solutions, to testify by telephone.
All right. So when you get to that one, when are we getting to that one?
So that is
That's
at
at
3
3 o'clock
today.
So-
But on the bottom of this form, it does indicate that the taxpayer was advised, which one we called the first one. We let him know verbally. Do we let them know now and then I can email the person who submitted this information?
Yes, and we got the same problem. They've got 2 hours for someone to physically show up here. So,
That's fine. Then
Right.
the
Right.
local taxpayer
right,
can
no, I
come.
get it, just so we got the same issue. So you can call them and then we can wait till noon and we do the same thing we're doing on the other one.
Should I also email her because I have access to my
Sure,
email right now?
sure, the more
So
in-
we will call and email.
Yeah, the more info, the better, the more communication.
And the reason for denying is this is a local taxpayer with the ability to attend in person,
Okay, so, I'm sorry.
or what?
Or without any stated reason why that taxpayer couldn't appear.
There you go. There's no reason why the taxpayer cannot, there's no stated reason why the taxpayer.
And they kind of have a track record with you now, that last year they did the same thing and the person was not prepared to do anything. If you remember that so they have a bit of not to say you can always consider previous, but they did the same thing last year. And Gary, you're shaking your head at me, which I get it.
I'm just saying it's de novo, and
Right.
again, I guess the thing that bothers me, and I get, it may not even be a legal point, but the long story short is they're asking for more than $1 million reduction on this thing. This is a serious thing, and I would like to see the people, or at least hear the property owner tell me what the issues are, and they're avoiding that.
That's another extremely good point, because this is a biggie. This isn't like I'm asking for a couple dollars. With that kind of money, you should be serious enough to show up and have your hearing heard. So that's a very good point also.
Yeah, and we're going to notify them, advise them.
And I want you to tell me, as the board, what you want me to say, because the email that I have drafted, there's no stated reason as to why the taxpayer cannot appear, but this isn't not about the taxpayer. We haven't even
The
gotten
agent.
to the agent yet. So tell me what I'm supposed to
So
write,
we're
'cause this-
denying the agent's request to testify by telephone.
The board
That's
has-
all we've denied. We haven't addressed the issue. And they're scheduled at 3 PM today. And the taxpayer could show up at 3 PM. And
So, right, the board denied the waiver, for the testimony
Well-
by telephone
Of the
for
agent.
Pivotal Tax
of the
Solution.
agent.
Yep.
Right.
The request
Not
to,
to say if the taxpayer didn't submit one, we
I will
might-
not send this until you guys let me
Yep.
know you're okay. And I'm not gonna put the entire name of it. The board has denied the request. The board has denied the
You can say
request.
on the record,
Where?
on the record, the board has denied the request to testimony by telephone. And then I would just leave it, and I would just say in the event that this hearing would go forward, someone has to be here at,
Well,
3
then
p.m.
should I state your hearing has been scheduled for today?
they should know that, but yeah.
Yeah, I would restate it, yeah.
Okay,
Your hearing is scheduled for 3 p.m. In the event, no person, there's no personal appearance.
well, here's another thing.
See, we're dealing with
Oh,
somebody.
The people that
make
have
sure you
talked to
say
me-
Central Time.
Yeah.
Yeah, there you go, right on, say central.
That's.
Yeah, thank you.
Another thing is, should I reiterate the fact and remind them that the only agents that would be able to come would be these people listed
I
here?
wouldn't go that far.
Okay. Your hearing is scheduled.
Are you putting in there that we denied the request of your agent
Yes.
to appear?
No.
I thought you put in there. That's what they're denying,
They're denying the request by telephone.
For the agent?
for the agent.
But requested by the agent.
Yeah, the agent is the one requesting.
They may
I won't
not-
hit
they
send
may
till you
not
guys are
even
good.
know.
There you go.
Right.
For the agent. Okay, just a minute. September 4th, 2025, at 3:45?
3 o'clock.
3.
Sorry, Sam and Nick, this is we're kind of going all over the place here.
Okay, I have written, the email states, for the record, the board has denied the request to testify by telephone for the agent.
I would say on the record. Because that's what they did, they put it on the record.
Okay.
So
On the record,
The board,
the Board of Review has denied the request to testify
by telephone.
jeez, for the agent.
Made by the agent. Made by the agent.
Testify, did I spell it right?
The telephone made by the
Okay.
agent.
On the record, the Board of Review has denied the request to testify by telephone made by the agent.
I
Your
would say
hearing,
a hearing is scheduled
a hearing is scheduled today at September 4th, 2025 at 3 p.m. Central Standard Time.
And then I would say in the event of no appearance,
Do you want to mention the Muskego School Apartments? Hearing is scheduled today,
that makes sense,
What?
for Muskego School Apartments.
so at 3 p.m. for Muskego School Apartments LLC.
Look at this guy.
School?
Muskego School Apartments LLC.
Thank you.
Didn't receive a call or voicemail, but did you show up at the
Sorry about all this. And in the event of no personal personal attendance, that no one attends.
In the event no one appears
Sure. In the event no one appears,
in person,
right.
And that's why they want to tell us.
Well, it's basically the hearing is being denied, their hearing is denied, their objection is denied.
The objection
Will
will be
be
denied.
denied.
Yeah, there you go, because they filed the objections.
would you
So-
like for me to reread this again?
I think I'm standing over your shoulder, which
Oh,
I know
you're
you
the one.
hate, which
Oh.
I think it looks fine. I mean, you can read in the record if you want. We're still on, right? So why don't you read what you just read?
It actually feels better than it did before the surgery.
Hold on just a second. Nah, it's already in there.
And are we also gonna call?
We can.
Right, then.
They gave us a
Christine
phone
will just
number.
Put on the record that we called.
Okay, so an email is being sent to Tiffany and Samara from Pivotal Tax, who have been in contact with me in regards to filing an objection and their intents. The email is going to state on the record, the Board of Review has denied the request to testify by telephone made by the agent. A hearing is scheduled today at September 4th, 2025 at 3 p.m. Central Standard Time for Muskego School Apartments LLC. In the event no one appears in person, the objection will be denied.
Sounds good.
Okay. Are you guys ready? I'm hitting send.
Yep.
Okay.
No, are you also gonna call? If you call, are you taking notes, Christine? She can make notes that we also call. An email was sent and a call.
Oh, so we don't need to call him right now?
You can.
Well, let's make the call right now.
Yeah, I would call.
You want to call it right now? Yep. Okay, hang on.
I mean, they're in Middleton, they could get somebody over here.
Oh, you waited, yeah,
Yep.
nine again.
914806169. You still at the Will Rose apartment? You still at Will Rose?
Just ask who we're talking.
Is this Pivotal Tax Solutions?
Yes.
This is Jeremy Kyle. I'm the chairman of the Board of Review in Muskego, Wisconsin. And we're calling about the request to testify by telephone today on behalf of Muskego School Apartments.
Okay. Let me write this down really quick. You're calling from Muskego?
Yes, the city of Muskego, Wisconsin.
Okay. So you're calling regarding a telephonic hearing?
Yes, this is regarding the request to testify by telephone by Pivotal Tax Solutions on behalf of Muskego School Apartments.
Okay.
And we have
Alright,
sent an email as well, but we're calling to inform you that we have denied the request to testify by telephone on behalf of Muskego School Apartments for the Pivotal Tax Solutions as the agent.
Oh, okay. All right, well, I'll go ahead and make note of that.
Okay, thank you.
All right.
And what's
you
your name
so much.
again?
You have a good one. Jackie
Jackie, and your last name?
Romney.
Can you spell
Can you
that?
spell that, please?
Yes. Romney.
Okay, all right, thank you.
Thank you so much. Have a good one.
Bye. All right,
Can move on.
move on. We've got,
All right, you're past the 10. Oh, we're waiting on that one, okay.
yeah, we're waiting now for 11:30, Cal Evans. Is that one? Because 11 o'clock was the same person.
Oh, okay.
Yep.
We don't have to call him again, do we?
No,
I don't believe so.
you can examine the tax roll if that's what you'd like to do.
I like the idea of reviewing the request to testify by telephone. We've got two more for tomorrow, if that's all right.
Number
So-
16, right?
So number 16 is for Chad Gates. Do you have it? Okay, so this is,
16.
should be yellow tab 4, all the way through, it's the teal tab, then 16.
Pause. Go off the record. Have him pause. You can do it now.
I'll wait till he's done.
Oh, because that's the last one? Yep, all right. So we see tab 16, we're reviewing the request to testify by telephone. Getting there.
It's the last one in that group. So if you find tab 17, it's the one before it.
All right, there it is. So we have Chad, who is the property owner, is
I'm terrible at
requesting to testify by telephone, states that he is currently working on site, unable to travel back to Muskego, and then gives a phone number. So I'll entertain a motion one way or the other regarding the request to testify by telephone.
I'll move to approve his request and allow him to testify by phone.
All
I'll
right.
second.
All right, so Mara moves
Thanks.
to approve the request to testify by telephone for Chad Gates, and Gary Boyzitz seconds. All in favor, say aye.
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 I'm as aye as well. All opposed, say nay. Motion passes to request to testify by telephone for Chad Gates. All right. The next one, number 17, is Matt Welford, the agent for the Roth Family Limited / Julie Andrew. And that's in the next tab.
I got it. Thank you.
Notice that Matt Welford is the agent, Roth Family Limited Partnership is the property owner.
I guess on this one, they're saying he did not receive a call or to confirm the appointment. Is that what he's saying? Am I on the right one?
I have a question for the assessor. Did he appear at the open book?
So if this is the, is this the
Roth family?
Yes. So they had requested an open book meeting, and I was given a phone number to call them for the commercial open book, and I called to, because I did not have an agent authorization form, and I did not receive one before the close of the open book. So there was not an appointment that was available to be had. But if I'm allowed to give my opinion, I would not deny the opportunity for the objection. So that's something that is a miscommunication of some sort, but we did contact him. I did not receive an authorization form at that point.
I think that makes
I was
sense.
asking that because that's what I interpreted this to mean. So, okay.
So you would just need a motion then to approve that one? If that's what you want to do.
Or not, yeah.
If you're listening
Motion
to-
one way or another. So we're reviewing the request to testify by telephone for the agent Matt Welford on behalf of the property owner, Roth Family Limited Partnership.
All right, I'll move to approve that one also.
I'll second it.
Mara makes the motion to approve. Henry Osberg seconds. All in favor, say aye.
Aye.
All opposed, say nay. Motion carries. All right. Was there another one that came in that you're talking about for number 19, Brian Miller? That's a different,
Afternoon.
we'll do the afternoon. Okay. All right. So.
Did you want to go off
Do
record?
they, while they review the role, do we go off the record?
Yes.
Because we can
Yep.
take care of that then.
Okay,
too.
that's fine.
All right, we're going to go off the record as we review the roll until 11:30 with the next hearing scheduled. All right, we are back on the record. It is 11:30 a.m. We have a scheduled hearing for Tree B Property Holdings, and we have already approved the request to testify by telephone, so we are going to give a call at that telephone number.
We have to let him know he was approved. Thanks.
The number you have dialed is not in service.
Oh, that's
Please check the number and try your call again. Thank you.
All right, let me double check that. I'm fairly certain I did that correct. See, is this one? Is that just, what's this thing just saying?
Why is that flashing?
I don't know. Pick it up and hang it up. Did you dial 9?
Thank you.
No.
Okay.
All right.
Did you dial 9?
Yep.
949
949
303
03
5127.
7. Oh, there you go. What's the number?
I thought you dialed it.
This is Cal.
Hey, Cal, this is Jeremy Kyle. I am the chairman of the Board of Review for the city of Muskego. Calling
hi,
here
Jeremy.
for the hearing for the Tree B Property Holdings.
Yes, sir.
All right, yeah, we are prepared to start the hearing as you have, your request to testify by telephone has been approved.
Thank you.
All right, so that's just the approval for the request to testify. We did actually hold the hearing. We saw your notice of intent to file objection, and I believe we have the objection here. Carrie is the clerk. And yes, we see your objection to real property assessment. We first
Okay.
need to make sure that this is being recorded. I'll have the clerk check that.
Yes, our video recording is on, and we do have, the backup, audio recording as well.
All right, she is going to introduce the case for the hearing.
This is the case for Cal Evans, agent for Tree B Property Holdings. The property owner objector resides at 4380 67th Drive, number 101, Union Grove, Wisconsin, 531829338. The address for the property in question is South 108 West 21315 Waters Court. Tax key for this property is MSKC 2283.006. The property has been classified as residential. The value in the assessment roll for the current year is land $132,300. Improvements are $745,700, and the total is $878,000.
Carrie, did you say the owner mailing address, you said Suite 101, is it 1021 or 101?
I have 101.
All right, mine says 1021, but if it's 101, you're good.
Well,
Is the address at Suite 1021 or 101?
Great question. 1 second, let me just find that for you.
oh, I see.
The suite address is 1021.
Okay,
Thank you.
If I might, could I clarify something?
Yes,
Could you restate the assessed value that you have for the property?
I have it wrong also. Go ahead.
I have 132,300.
Yes?
Improvements 745,700.
No, the improvements are 727,100.
700
27,100.
is my total, right?
The total assessed value is 859,400.
And we have the 859,400 on the objection to the real property assessment.
Yes.
Okay, so my apologies. I want to restate that then. The land is 132,300. Improvements are 727,100, and the total is 859,000. That is the assessment roll. I corrected it with information from the city assessor, Sam.
All right, we've got the hearing, or the case introduced for the hearing. The clerk is going to swear in all the witnesses, including the agent for the property owner, as well as the assessor.
Do you want to quickly inform him how that's going to go?
Should we do that first?
Oh, yeah, you can.
Okay. Yeah, we'll just, to give you a heads up of how this is going to go, first you will testify and present your evidence. Then the assessor can ask you questions. The Board of Review members will then have the opportunity to ask you questions. After your testimony, any other witnesses that you have can testify, and they would be subject to questions from the assessor and the Board of Review. After all the witnesses have testified, then the assessor will present their case. Then you, as the agent for the property owner, can ask the assessor questions, followed by the Board of Review members who can ask the assessor questions. If the assessor has any witnesses, they can testify next. From then, the property owner, you as the agent, can respond to the assessor's testimony by presenting any other evidence, and then the assessor and the Board of Review can ask you questions from there. The assessor can then present any other evidence in support of their assessment, again, subject to questioning from the owner and the Board of Review members. After all the evidence has been submitted under oath, testimony will be closed, and then you can make a brief summary about your case. The assessor can make a brief summary about their case, and then after each summary has been presented, the Board of Review will deliberate on the testimony in an open session, and we will do that immediately.
Thank you.
Any questions on how we will proceed?
No.
All right, excellent. So then we'll have the clerk swear in all witnesses. Do you want to do, who do you do first?
We'll do them all.
Yeah, just do it all so everybody's in.
Yep, so we're swearing you in, Cal, as well as the assessors.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And from you, Cal, I need to hear that as well.
I do.
All right, thank you. So Cal Evans and Sam Monroe and Nick DePalma have all sworn in.
Would the property owner or agent who has just sworn please state your name and address for the record?
My full legal name is Callum Evans. That's spelled Charlie Alpha Lima Lima Uniform Michael. Evans is spelled the normal way. My personal residence is the property itself. I rent that from the company of which I am the agent. So the address is S218 West 21315, Waters Court, Muskego.
Okay, I did not understand that, so can I get that by email, Jeff, from him?
Can you what?
Can I get it confirmed by email
Sure.
from him with him? Okay, all right.
Yep.
So I will email him and ask him for that. Okay.
All right, we'll ask you that by email as well, but I heard that. I believe so.
Are there any witnesses for the property who has just sworn? Please state your name and address for the record. So Cal, do you have any witnesses?
No, ma'am. No witnesses from my side.
All right, no witnesses then.
And Assessor, can you please state the estimated level of assessment for the current year?
The estimated level of assessment for 2025 is presumed to be 100%.
To be what?
It is presumed to be 100%.
Thank you. Can Cal hear him?
Can you hear us, Cal? Is that turned on?
I actually can't. No, I actually
No,
can't hear
it's
the
on.
assessor. Jeremy, I can hear you very
You might have to
clearly.
hold it right up to your-
I'm struggling to hear anybody else.
Yep, thank you. We're working our best here, yes.
Or Sam can come up with the microphone.
That's true too. Why don't, Sam, you want to come?
Grab
do you
the
have all your
microphone and
paperwork?
come on
We'll
up.
have the assessor come closer then.
Is that going to work for you, Sam? Okay.
Bring that microphone. Thank you. Okay, so this was.
All right, thank you. So the assessor has stated that the assessment of $859,400 is presumed to be 100% of the fair market value.
Okay, thank you.
All right, and then just to Cal, can you please state what amount, in your opinion, is the fair market value of your property?
Absolutely. So I'm working on a fair market value of somewhere in the region of $640,000 to $700,000.
I see a different number on the objection to real property assessment. We need to have a specific.
You need a number.
We need a specific number that you
Oh, yep.
believe.
$629,000.
Okay.
All right, thank you. All right, thank you. And then I will ask you to present your evidence first as to the value being $629,000.
Absolutely, thank you. So the assessment's been made based on publicly available information. Effectively, with the tools that are available to us, and I respect the fact that the city has chosen to outsource to a third party, but we are able to make a very accurate assessment based on information that's available in the marketplace, taking data from sales that have occurred within the city and taking in the premises itself, material factors, size of the plot, any improvements that have been made, current market conditions. So it's effectively taking all of that information that's publicly available and running it through an AI model with specific LLM, which LLM stands for language learning machines. It's very easy to see that the property valuation actually comes out at a price at around $629,000. That's further substantiated when you actually look not only at the publicly available information from the last 5 years, when we compare that to outside factors such as the national average, the state average, and the general market conditions that we're seeing overall. Effectively, the city is suggesting at the moment that it's been a 65% increase. It was initially 70-something percent when I made the initial request to reassess. Now we're in the formal one. It currently sits at about 65%. That's an extraordinary increase in valuation estimation of the property when we consider that actually across the city of Muskego, if we average over the last year, the average increase in property price has been 17.5%. If you look at point 2 in my objection, you can see where that information is taken from. If we actually compare the price property increase that's suggested by the city for this specific property against the state as a whole, it's a 371% increase as to the actual prices that the state sees. And so the correction that we're seeing that's proposed by the city is again astronomical. That's also backed up by the Wisconsin Homeowners Association and the Wisconsin Realtors Association, which give similar market conditions. If you turn to Exhibit A, you can see that the median house price in the city of Muskego is $562,500. Again, that's open source information over the last 3 years. The average house size is very much where this property sits. It's 3 bedrooms, just over 2,000 square feet, which marries in line with that. This property has no extenuating features other than it has access to a boat dock. It is not lake frontage. It is not and doesn't have any major improvements such as a swimming pool. And so if we go to Exhibit B, you can actually see a property that's on the market today that is almost identical, both in size.
1 second, Cal. I want to make sure we have the right understanding of which exhibit we're referencing. I see a document saying Muskego, Wisconsin housing market, referencing the median sale price of $562,500. You referenced that as Exhibit A?
Correct, yep, that's Exhibit A. Exhibit B is an extract from Realtor.com. It's a property that's, it begins west 129, south 8634, Muskego Way.
So thank you. 1 second. So Exhibit B you're referencing states a house for sale at $758,990 with an address of W129 S8634 Muskego Way in Muskego. That's Exhibit B.
Yep.
Thank you.
Thank you, Jeremy. As you can see, you may not be familiar with the property, the subject property, but this property that's in this exhibit is almost completely identical to the property that is subject to this review, both inside, in amenities. There are 2 elements to consider here. This has 1 additional bedroom, and it has been on the market for 262 days, which, if we look at that from a very practical standpoint, means that it's priced so high it hasn't actually sold in a very booming market. If we then turn to Exhibit C, Jeremy, if you need clarification on this, this document begins with LLM AI-based model house valuation.
Yes, I see that it has an estimate as of September 3rd, 2025 in big letters right after that.
Thank you. So for the board's consideration and for the assessor's consideration, this is the information that comes back if you use an AI-based LLM model. And it uses open source information from the city and from third-party sale agents such as Zillow, Realtor, Truilla, and there are comparable properties that have sold between July and August. And it's very specific what we can include in. You see the syntax, the search at the beginning. It tells us that $600,000 is the average for a non-waterfront single-family home with 2,500 square feet on 4.6 acres in the city. A reasonable range it predicts is between 575 and 625. That's where we get our estimate of the 629 number. And reasonable comps that have sold recently, this is 4 that are presented here, all range between 590 and 670. There again, take away from comps, Hillendale, the Truilla produced this, that sold at 16K. We then actually went through and updated the property on page 2 halfway through. It says update property estimation value. This is where we included and we said the property sits opposite open land, so it always has the enjoyment of that, and it has access to a pier which is licensed for the property because it's not a deeded pier. You can see that the actual property does go up slightly, and there are more comparables. It said it pushes it up to about 625 at the maximum end, and then goes through. It goes through peer access cross-market and produces an estimation of a reasonable range of 575 to 625. I'm respectful of the fact that the city is looking to future-proof this so that it doesn't have to burden itself every year, and looks at the practicalities of the competitive market that we have. And that's why on the objection, I actually raised that amount to 629, saying, well, we can be practical and say that others bid on this. Then the final exhibit that I produced, that is Exhibit C, I apologize, but what is available to the city but actually hasn't been produced as an exhibit, and I apologize for that because I only just got this yesterday, is the actual list of the city assessment. The disparity of the range on our street alone, on the street alone of the subject property, ranges of anything in excess of $300,000. And a property at the entrance to the street which has more bedrooms and a similar square footage and enjoys luxury such as a hot tub is actually listed at almost, or assessed by the city, as almost $100,000 cheaper. I appreciate, again, I'm not using any sales that have occurred in the city because it wouldn't be appropriate to use that on our street. That's not a good benchmarking point. But what I am using is actual information that's available based on the median average, the property prices, and the properties that the city has priced on the street itself. I hope that's made sense to everybody, and that's effectively the submissions I'm making before the board.
Okay, so you have then presented your evidence. Have you presented your complete evidence? Do you have any further to add right now?
No, the only thing I would like to comment on, Jeremy, I can't comment on other properties within the city, but I will say I do raise a concern with the use of the third-party software company in Texas that seems to have used a very obscure methodology. I do work in technology. I am familiar with AI modeling and how easy it would have been for the city to have conducted its own assessment. We actually ran a comparable AI model on the city and came back with very different numbers, both with city information and public information, and it's very concerning to see that, and also the fact that the company that the city has used has been involved in litigation every year since 2020 in relation to the software that they've deployed for similar cities and similar situations. So I also just would like that placed on the record that I do have some concerns about that.
All right, so I think we're at the point here where we'll have the assessor ask any questions of you.
Thank you. Mr. Evans, can you hear me?
You are quiet, but I can hear you.
Okay, thank you. Going through the information that you provided here, the one question that I do have, the comparable properties that you're pulling, are all these comparables, are they sold properties, or are they current asking prices, or are they a mixture of the two?
They are a mixture of the two. The AI information that was provided uses actual sold properties, and the exhibit from Realtor is a property that's currently on the market.
Okay, thank you. And the other question that I have, reading through the information that you had provided, are you under the impression that this is a change in value over 1 year, or do you realize that this is a market update from 2021 and this is an increase in value over the previous 4 years?
I do, yes. I am respectful of the fact that it is an increase for the last 4 years, but I'm also mindful of the fact that the taxes for the property have increased every year, and if the mission now is to benchmark the property value at 100%, which again, I completely understand. It's fair that the city makes a valuation on 100% of valuation of the property. What I and we are effectively saying is, well, this is actually, if we're doing it both ways for 100%, we need to look at everything from afresh. In a legal sense, this would be called a de novo review. It's almost like you're starting afresh and you're saying, this is what 100% of the valuation of the property would be.
Okay, thank you. One final question. At the open book hearing that was conducted, your opinion of value was originally $800,000, and can you explain the process between the opinion of value from the open book hearing to the $629,000? Is the decrease in the opinion of value due to information that you did not have at the open book hearing?
Yeah, absolutely. It is. I've had the opportunity to run this through a very succinct AI model which pulls data from lots of open source venues, including the city itself. Again, I'm aware that AI isn't perfect. It does have rudimentary flaws to it, and I know that obviously your knowledge of the city and the board's knowledge of the city is always going to surpass that. But I think we also have to take the practicality of the information that's available. So I didn't have that at the time, but now I do. I think it's great for everybody to see.
Okay, thank you. I just wanted to clarify why there was a higher initial value of opinion before the form that was the objection form was filed here with the city. I have no further questions.
Okay, we can then move to where
Does the board have any
assessor
questions? Board have any questions?
Yes, does the board have any questions? I think the board has a couple questions. Before that, I do want to make a statement. I failed to make it earlier, so I'm just going to read it off to Cal and have you affirm. Here's my statement. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand?
I do, yes, thank you.
Yeah, thank you for that. We do have some questions. I'm thinking it's
You might be able to have to come over here
and just ask the questions at this table here, so I'll make some room. There you go.
Mr. Evans, can you hear me?
Yes, loud and clear.
All right, Exhibit 3 of your submission, it appears that you're stating that the increase year from year is 17.1%. Is that right?
Yes, that would be the information that's come out.
Oh, I think it's A. Sorry, I had the wrong exhibit. But
No, that's
then
okay.
my other question is, in your objection on sub D, you state that within the last 5 years you had an appraisal, and it looks like that was on January 1st of 24 for $700,000, correct?
Correct, yes.
And was that done by an appraiser in Wisconsin?
It was done by a realtor in Wisconsin.
Can you repeat that? Thank you.
It was conducted by a real estate agent in Wisconsin.
All right, that's all I have. Thanks.
Any other questions there's further questions from the Board of Review to you?
Hello, can you hear me?
Yes, sir.
Okay. I'm going back to the appraisal that you had done by the realtor at $700,000. That you stated in your objection that was for insurance purposes. Is that correct?
That's correct, yes.
What are you currently insuring that property for?
It is currently insured at the $700,000 mark.
I'm sorry, I didn't hear that.
It is currently insured for $700,000, in line with that assessment.
So your testimony is that you're currently insuring the property for $700,000, correct?
Yes, I believe. Correct, yep.
All right. And nothing further. Thank you.
Okay, seeing no further questions from the assessor or the Board of Review, it is time for the assessor to present their evidence related to the assessment.
Thank you. Nick is currently passing out Assessor's Exhibit A, the two-sided property record card with the assessment details for the subject property, and Assessor's Exhibit B, which is a one sheet that is the comparable sales that were used to value the property.
Thank you.
So beginning with the Exhibit A, the property record card, the subject property sits on 0.56 acres of ground. It is a two-story colonial home built in 2020. We have it listed as a kitchen and bath condition of average for both, a full basement. The grade is a B grade. The condition, desirability, and utility rating is very good. It consists of 6 total rooms, 3 bedrooms, 2 full baths, 1 half bath, with 3 additional plumbing fixtures, 1 prefab fireplace. The ground floor is listed at 1,035 square feet. The total living square feet area is 2,405 square feet. Moving to Assessor's Exhibit B, the comparable sales. Comparable 1 is located at 166 South 8362 Kurtz Lane. This property sits on 0.31 acres of ground. It is a 2-story contemporary, built in 1995, with 9 total rooms, 4 bedrooms, 4 full baths, 2 additional plumbing fixtures. It has a full basement. It is heated and air conditioned. It is a B+ grade, a very good condition. The total square footage is 3,104 square feet with 680 square feet of finish in the basement. The kitchen and bath rating is very good. That property sold for $1,300,000 on July 16th, 2024, approximately $418.81 per square foot, with an adjusted sales price of $908,000. Comparable number 2 is located at 75 West 18642 Kingston Drive. This is a 2-story contemporary home built in 2000 with 6 total rooms, 2 bedrooms, 3 full baths, 1 half bath, 5 additional fixtures. It has a full basement. It is centrally heated and air conditioned. It is a B grade in very good condition. The ground floor, the above grade area is 2,057 square feet. There's 552 square feet of finish in the basement for a total of 2,609 square feet. The kitchen and bath ratings are listed as average. That property sold for $1,250,000 in July of 2024 at a per square foot value of $479.11. with an adjusted sales price of $826,400. Comparable number 3 is located at 66 West 18515 Jewel Crest Drive. This is a 2-story colonial home built in 1994 with 5 total rooms, 3 bedrooms, 3 full baths, 1 half bath. This full basement is centrally heated and air conditioned. The total square feet is 2,822 square feet. There is 987 square feet of finished in the basement. It is listed as average for the kitchen and bath ratings. And that property sold for $1,150,000 in June of 2023 for a per square foot sale price of $407.51 with an adjusted sales price of $880,100. Comparable number 4 is located at 166 South 8348 Kurtz Lane. This is a 2-story colonial home built in 2003. It has 7 total rooms, 3 bedrooms, 4 full baths, no half baths, 4 additional fixtures. It has a full basement, is centrally heated and air conditioned. It is listed as an A- grade, and the condition is listed as very good. The above grade area is 3,112 square feet. It has 1,000 square feet of finish in the basement for a total of 4,112 square feet of finish. The kitchen and bath ratings are average. That property sold for $1,100,000 in June of 2024, or per square foot value of $267.51, with an adjusted sales price of $635,000. Comparable number 5 is located at 76 West 18160 Janesville Court. This is a 2-story contemporary home built in 1984. It has 6 total rooms, 2 full baths, 1 half bath, and 3 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. It is an A- grade in very good condition. The above grade living area is 2,818 square feet for a total of 2,818 square feet of finished area. The kitchen and bath ratings are listed as average. That property sold for $1,180,000 in June of 2023, or $418.74 per square foot, with an adjusted sales price of $815,500. The comparables that we've shown are similar in size and style. They are recent sales that occurred between 2023 and 2024, which is the time frame that we analyze sales for the current market update, and they were all listed as valid open market sales. The sales have been adjusted with an adjusted sales price, and the subject property, we feel, is a fair assessment at $859,400. And that completes the assessor's evidence.
Okay, so then Cal, as the agent for the property owner, you can ask the assessor any questions.
Yes, please. Could you confirm how many of those comparable properties are lakefront or lakeview properties?
I'm sorry, I didn't hear the question.
Could you confirm how many of those comparable properties are lakefront and or lakeview properties?
So I do not have the information on each sale. I do see notes that the majority of the comps are on lake front lots, but our adjustments on the properties assume that the land value adjusts for let me rephrase that the land value is the adjustment for the lakefront properties versus off-lake properties, and the land value is taken in a 1-to-1 consideration through the adjustment process for the comparable sales.
Okay, thank you. If I may, just as a point of clarification, and if you're not aware of this, feel free to disagree with me.
I think at this point you're going to be allowed to ask questions but not present any further testimony right now.
Correct. This is a question around the assessment, if I may be permitted to continue with it. The question is, are you aware that the property, the first, second, the one on Kurtz Lane, the one on Kingston Drive, the one on Hurt Lane, and the Janesville are all lakefront properties? They enjoy lakefront to Wind Lake, Little Muskego, and Back Bay.
I think you're. I'm gonna ask you to. Yeah, we'll need a question. You'll have a chance to present further evidence.
Well, I believe he's asking the question if I'm aware that the comparables are lakefront properties.
All right, so you're asking, are you aware that these particular comparables are lakefront?
Isn't that his last question, or?
Well, just to confirm, Mr. Evans, that the question is the comparables that you named, you're trying to clarify that we are aware that those are lakefront properties as opposed to off-lake properties?
Correct.
Yes, I am aware of that. The adjustment for the lakefront versus off-lake would be the land value or the assessment for the land itself.
Okay, thank you. Final question. Are you aware that the property that is subject to this review does not enjoy either a view of the lake or is not lake-fronted?
I am aware of that, yes.
Okay, thank you. No further questions.
All right. Any questions for the assessor from the Board of Review? I don't see any questions to the assessor, so the property owner can respond to the assessor's testimony with other evidence.
Thank you. Thank you, Assessor, for presenting that evidence. I'd just like to come back by way of a rebuttal and point out that through my familiarity with Muskego, I'm aware that 4 of those streets are direct lakefront access, and even the supposed comparable properties enjoy a clear view of the lake. For all intents and purposes, the comparable properties are either or lake fronted or have a pretty much clear, unobstructed view of the lake. So in a layman's terms, they're lake houses. The property that's subject to this review does enjoy access to the lake from a pier that is licensed to the property, but it does not have a lake view, and it definitely is not anything like a lakefront property. It sits almost 6 plots back from the lake and does not have a clear view to the lake at all. So the comparable properties take in what is arguably one of Wisconsin's most enjoyable features, the lake, and this property doesn't have that, which is why its valuation is significantly lower.
Thank you. Any further evidence to present?
No, thank you.
And from the assessor, any further evidence to present?
I have no further evidence.
All right. We're going to then hear a summary from the property owner agent regarding their position.
Thank you, Jeremy. The summary is very simple. The comparables that have been used have been derived from an out-of-state company to begin with. After an initial request to reassess, similar comparables have been used, which are either lakefront or have an unobstructed lakefront view. Some of the properties enjoyed more bedrooms, although they were all of reasonable comparable size with a land plot. They didn't take into account the fact that this subject property isn't lakefront and doesn't enjoy a view of the lake, which I think, as we all know, is one of the most selling features of properties in Wisconsin, especially in the city of Muskego. So therefore, I respectfully ask that the board consider the actual valuations that have been provided using extensive publicly available information that have been produced by myself as agent for the property owner, and take into consideration the true market value to bring it to that 100%, so that the city can collect accurate taxes on it.
Thank you. And then the assessor can summarize?
Yes, I would first speak to the question that while I do work for Tyler Technologies, we are a company that our corporate offices are based out of Texas. All the local appraisal staff lives and operates here in the state of Wisconsin, so we are familiar with the local market. I would also point out that the CAMA system, IAS World, that's used and implemented in the city of Muskego is certified and used by the Department of Revenue for the state of Wisconsin. We believe that we've provided 5 comparables of the subject property. We believe that the comparables are similar in size and style and location. We also feel that the adjusted sales prices fall within the range of 2023 and 2024. And there was no sales that were used that were after the January 1st, 2025 valuation date. We believe that it is a fair and equitable assessment for the subject property.
Okay, thank you. We're then going to close any testimony.
Correct.
And as the Board of Review, we get to deliberate here in open session. Okay, we're working on it. Yep. So we've got a findings of fact, determination, and decision we need to go through.
Yep, so then I did this part right here. Board members.
Yep. We do notice that timely notice of intent to file an objection was provided.
I have a question. Sometimes in the past, we've done the deliberation immediately. Sometimes we've done them all at the end. Are we planning to just do them as we go? I know we have another person waiting.
Yes, we're gonna plan to do it as we go.
Okay.
Yep. Yep. Any thoughts or deliberation from the Board of Review here?
Well, I will note that the property owner indicated that there was an appraisal that was done on January 1st of 2024 in the amount of $700,000. And his own presentation says there's a 17.1% increase in 2025 from 2024, which results in a number of around 820,000, which is pretty fairly in line or within their margin of error from what the assessor has. So I don't feel that the owner has presented any sufficient evidence to tell me otherwise. His own evidence is supporting the assessor, is what I'm saying.
Got it. I'll say my thought on that is often an insurance-based appraisal is more on a rebuild value, which is often higher than a fair value, is my experience. Any other deliberations from?
That'd be my belief as well, but I asked the question simply to just see whether or not what they thought the property was worth and what they wanted to insure it for. And going along with Mara, if you even add the land value to the $700,000, you're getting to a number closer to the assessor's math than to the homeowners.
There you go. So you're saying that the insurance appraisal amount is...
You're insuring property, you're insuring the house, you're insuring
not
it
the
for
land value.
$700,000. It could be replacement value, it could be current value. We didn't go that far.
Right.
But bottom line is you add 132.3, which is the land value, onto the 700,000 they were willing to insure the structure for. You're already at 832.3. You're in your ballpark, particularly when you start looking at the comparables, which I believe have taken into account the value of the property, the comparables that were on the lake. There's no question that that's taken care of on the land value. So I tend to agree with the assessor.
Got it. And I suppose a question for Jeff. We're not necessarily assigning what we believe our own value is. We're determining whether the property owner presented evidence that fulfilled their opinion of 629.
You really have two numbers in front of you, the assessor's number and the number of the owner. You're not really going to say, okay, we think it's in between there. Those are the two numbers you're working with.
Right. And do we have the evidence from one or the other to support one or the other?
Correct.
Value? Okay. Got it. All right. Well, going through any further deliberation or questions? All right, so we're going to send out a findings of fact and determination, but we're going through that right now. There was no recent sale of the subject property. Nope. Yep, so 1A. This is from the property owner. Did they present recent sales of comparable properties? What he testified is that some were sales, some were on the open market. I'm looking through. They do list, he lists 4 recently sold comparable sales. That's Exhibit C. They presented other factors such that this property is not direct view of the lake as opposed to comparables presented by the assessor being on the lake. There's no other sworn testimony by other witnesses. The sworn testimony by Assessor Sam Monroe is that the level assessment for the current year is 100%, so the assessment and the fair market value are at 100%. Testified there is no recent sale of the subject property, and he did list comparable properties with a total number of 5 other properties. Other factors or reasons presented, he did state that while the comparable properties were mainly lakefront, those were accounted for in the adjusted value that was assigned to each property while coming up with the assessment. No other witnesses were presented. The assessor's estimated level assessment for the municipality is determined to be 100%. There was no recent sale of this subject property. We're finding that there are recent sales of comparable properties. Now, did the property owner present testimony of recent sales? Yes. If yes, were the attributes satisfactorily adjusted for their differences from the subject and their contribution to value? They've presented multiple, so it's almost as if you have to believe one or the other, right, or go off one or the other. I'm going to state that no, the attributes were not satisfactorily adjusted from the property owner. And then yes, the assessor presented testimony of recent sales of comparable, and that yes, the property attributes were satisfactorily adjusted for the differences from the subject and the contribution value. We'll list out those 5 sales later. The Board of Review finds that the assessment should be based on other factors. I think the answer is no. What was the most credible evidence presented overall? I believe it's the 5 comparables from the assessor. And then we have a decision to make, and motion must be made and seconded whether we go through with number 1, that the assessor's valuation correct, or number 2, the assessor's valuation is incorrect. So I will take a motion for either of those.
I will move that exercising its judgment and discretion pursuant to WSStat Section 70.47 sub 9A, that the Board of Review determine that the assessor's valuation is correct.
And so Mara Spring is moving that the assessor's valuation is correct, which includes the other things listed, that the assessor presented fair evidence of the fair market value, presented evidence of the proper classification.
Just going to need a second on that.
Yep, so we'll take a second on, what, is there certain kind of reasons behind it we want on the motion, is that correct?
You would check all the boxes that apply.
So does my motion have to include all of the things that are in the box?
I think your motion can say the valuation is correct, and then everything that's in the box, you wouldn't have to list every single one. You've
Okay.
got the main thing that the valuation is correct, and all these other boxes can be checked.
Not necessarily 4 and 5.
That's true. So if you wanted to, you could read the ones you're checking.
I think.
Or just read that you're not checking 4 and 5.
I'm seeing 1, 2, 3, 6, 7, 8 is what I'm seeing. But Mara's making the
Yes.
Motion.
The first 3 boxes should be checked, and then the 5th, 6th, and 7th boxes should be checked.
All right, so I'm hearing Mara Spring move that exercising its judgment and discretion pursuant to Wisconsin Statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of the fair market value of the subject property, that the assessor presented evidence of the proper classification of the subject property, that the property owner did not present sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the assessor's valuation is reasonable in light of all the relevant evidence and sustains the same valuation as set by the assessor. From Mara Spring. That's a motion. We'll need a second.
I'll second. I'll second.
We'll go with Cindy. I heard her first. Cindy Schmier seconded.
So remember, it's a roll call vote.
It's a roll call vote. Yep.
All right. Gary Boycitz,
Aye.
Jeremy Kyle,
Yes.
Henry Posbrig,
Yes.
Cindy Schmier,
Yes.
Mara Spring.
Yes.
All right, so the Board of Review by 5-0 upholds the assessor's valuation. Thank you for your time.
Do you want to fill out the last 2, the value of the property is?
Yes.
Land and improvements.
Yep.
It's
so-
just that one last question. After you vote, you can make that finding.
Yep, so the full value of the property is those amounts. Carrie has those, and that the level assessment is at 100%.
Okay, that's good.
Or it's probably just the first one. I don't think we need the second one.
Correct.
The level assessment.
Correct.
That's already stated earlier. Okay. Good. Thank you, Cal, for your time.
Thank you.
All right. All right, Carrie's just going to take a second. That. And then we have the next hearing, who I see is here. Thank you for your patience. I don't know why. I don't know. That should be better. I don't know, yeah. People cannot know things.
Yeah, yeah.
It's gonna keep coming up, so
I got
I
you.
was curious.
Yeah, I'm looking, yeah.
Yeah, we'll deal with that later.
Yeah.
Yeah. Okay. All right.
Are we on number?
We are on number 4 in the book, Daniel Zernicki and Hillary Zernicki. All right. Let's make sure that the tape recording is in working order, and we'll go from there.
Yep, we are still recording, and my Zoom is still recording as well.
All right, excellent. I'll have the clerk introduce the case for a hearing.
This is the case for Daniel Cernicki. The property owner resides at South 110 West 20968 South Danoon. The address for the property in question is South 110 West 20968 South Danoon. The tax key for this property is MSKC 2283.997.004. The property has been classified as residential. The value in the assessment roll for the current year is $267,400 for land, improvements $695,100, the total $962,500.
All right, just to give you a heads up on how you're going to do this. First, you'll get to present your objection and evidence for that. Then the assessor and the board of review can ask you questions about that evidence. Then the assessor will present their evidence about the assessment, and then you and the board of review can ask them questions about their evidence. Then you can testify or present further evidence, in which case the assessor and us can ask you. The assessor can present further evidence. You and us can ask the assessor from there. Then you'll be able to summarize your testimony. The assessor will be able to summarize their testimony, and then we will deliberate. And I don't see any other witnesses, but if there are witnesses around, they could do the same thing. So, yep, good.
There's a button on
You
the
gotta-
top, push
yeah.
it up towards the microphone itself.
And do you understand all the rules he just said, sir? Okay.
Okay, hold on, let me get him he's still, okay, there we go.
All right. Is that better?
Yes.
Okay.
There you go. Excellent. So we're going to have the clerk swearing everybody, and then I'm going to make a statement, and then we'll go from there.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in this matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Would the property owner who's just sworn please state your name and address for the record, please?
My name is Daniel Zernicki, address S110W20968 South Danoon Road in Muskego.
Are there any witnesses for the property who was just sworn?
No.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for 2025 is presumed to be 100%.
Thank you.
All right. So for you, Daniel, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand?
Yep.
All right, thank you. You've already stated your full name and address. Please state what amount, in your opinion, is the fair market value of your property.
I believe the fair market value of my property is $810,000.
All right, I see that on the objection. And then we'll have you present your evidence.
All right. First of all, thank you guys for doing this today, taking all your time. And thank you especially to Carrie. I called her on Monday. She's very helpful getting me through this process and how to get here. So really appreciate it. I guess, here, I'll hand out my evidence packets to you guys.
Hand them to me and I'll send them out that way.
And does the assessor have one?
Do you have some for the assessor? Dan?
Oh, yes. Yes.
Yeah, here, they get actually two. Sorry. We go next. Okay.
Thank you.
Thank you.
Okay, so the exhibits I just handed out are actually the comparisons that the assessors gave to me with my first meeting with them after I received my notice. After looking through this sheet, I went through, I looked at the sale prices from prior years, I looked at the adjusted prices, I looked at the market value they gave our house, and my first thought was, okay, it makes sense. Although I still felt 65% increase from our prior assessment seemed like a lot. So what I did is I actually decided I'm going to go look at these 5 comparisons on the Muskego website where all the assessments were listed. So I went and looked up each house and see what they were assessed at. And if you look at so each page is a page out of that packet. That's on the website. I have them highlighted for each of you on the total assessment amounts. And on the last page, you can see kind of the comparisons. So what I did was my first comparison was against the sale price of each year, or of each house, or each comparison house. So the first house sold for $1.3 million last year. That house was assessed this year at $772,000. The next one was sold at $1.25 million. It was assessed at $1.07 million. The next comp was sold at $1.1 million. Got assessed at $786,100. Comp 4 was sold for $1.15 million, got assessed at $938,400, and comp 5 was sold for $1.18 million and got assessed at $978,600. So I saw that information and I kind of thought to myself, well, why are they assessed so much lower than what the assumed market value would be? And I know the sale price from the prior year isn't necessarily the market value. I know they actually have the MRA estimates on here. A couple of them are a little lower than the sale prices, a couple of them are a little higher than the sale prices. All the adjusted prices come down quite a bit when they compare it to my house, due to basically taking out rooms and square footage. So I guess my thought was, why is it listed so low? Why all these assessed so much lower and mine's assessed at 100% of what they believe is market value? And it was hard to come up with a conclusion. So the only thing I can think of is either my house was valued too high, or all 5 of these were assessed way too low. None of them are within 10% of the fair market value, and I think we're all assuming that everything assessed is supposed to be at fair market value. I should say at sale price, not necessarily what they have as market value for these homes, because I can't see the market value of these homes. I don't have that information. But if we assume that they're all assessed at fair market value for this year, that means the house that sold for $1.3 million, they're saying the market value is at $772,000. And if that house was adjusted from $1.3 million to $1 million after taking out square footage and rooms to get a comparable to my house, then why is my house assessed $200,000 higher than that home? It seems like there's a bit of equity disparity there in the comps. So I guess my main argument is I went and looked at the adjusted prices, and I went and saw what they were assessed at and how much lower they would be from the sale prices based on the assessed value, and I put my house at $810,000. In my thoughts, it actually could be lower based on those assessments, but I thought $810,000 was a fair value for my house. So that's my argument.
All right, then we'll hear any questions from the assessor to the property owner.
Yes, I just have, the analysis that you've done here was simply on the comparable properties that we had listed on the
Correct, yes.
comp sheet for your home?
Yes.
Okay, and that was what you're looking at is a comparison between the market regression analysis estimate, the sales price, the assessed value currently, and then a ratio between the assessed value at the sales price?
Yes, that's correct.
Okay. And these were the only sales that you had researched at this point in time, simply because they were the comparables that were used to value your home?
Yeah, due to time, I didn't really have time to go out looking for anything else. So.
Okay. I have no further questions.
Any questions from the board to the property owner? Seeing no questions, I'll ask the assessor to present their evidence.
Nick is currently passing out Assessor's Exhibit A and B. Exhibit A is the two-sided property record card for the subject property. Exhibit B is the comparable sales that were used to value the property itself. And while he's passing that out, I would make a comment that the assessment sales ratio is something that is used in our analysis through the model that we build to value the properties. Our goal is not to have every property hit the sales price itself. We calibrate our model, so we will have some properties that are assessed less than their sale price. We also inversely have properties that are assessed more than their sales price. It's a statistical process that we go through with the model. So not everything, we cannot set everything exactly to the sales price for those properties, just kind of a little bit of a background of the analysis that we use. The market regression analysis is one of the processes that we can use. The majority of the properties in the city of Muskego, we currently use the market approach, which is the comparables that are provided for the sheet. The market regression analysis is a process that is, again, another model. It takes into consideration not as much as the market process or the market approach with the styles and age and size constraints from the market approach. That is more of a looking at the individual components of the home, the value of a bathroom, the value of the per square foot, regardless of style, regardless of anything along those lines. So market regression analysis is another tool that we can use outside of the market approach. That it is a value that is calculated, but that is one that we may use on a hard to assess property if it's very unique or if there aren't significant comparables. We can also use the cost approach, which is the cost to replace it brand new with less depreciation. So just kind of a small description of the three processes that we use. Beginning with the Assessor's Exhibit A, the property record card for the subject property. The home sits on 1.43 acres of ground. It is listed as a two-story colonial home that was built in 2021. It is listed as average condition on the kitchen and bath ratings. It has a full basement. It is centrally heated and air conditioned. It has a prefab fireplace. It is considered a B+ grade and in very good condition. It has 6 total rooms, 3 bedrooms, no family rooms, 2 full baths, 1 half bath, and 2 additional plumbing fixtures. The total square feet of living area for the home is 2,428 square feet. Moving to Assessor's Exhibit B, the comp sheet that was used to value the property. Comparable number 1 is 166 South 8362 Kurtz Lane. The subject sits on 0.31 acres of ground, is a 2-story contemporary, built in 1995, 9 total rooms, 4 bedrooms, 4 full baths, 0 half baths, 2 additional plumbing fixtures. Has a full basement, is centrally heated and air conditioned, is a B+ grade, in very good condition. The above ground area is 2,424 square feet. It has 680 square feet of finished basements for a total living area of 3,104 square feet. The kitchen and bath ratings are very good. And that property sold for $1,300,000 in July of 2024 at a price of $418.81 per square foot, with an adjusted sales price of $1,008,900. Comparable number 2 is 75 West 18642 Kingston Drive. This is a 2-story contemporary home built in 2000 with 6 total rooms, 2 bedrooms, 3 full baths, 1 half bath, 5 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. It is a B grade in very good condition. The above grade area is 2,057 square feet. It does have 552 square feet of finished basement living area for a grand total of 2,609 square feet. The kitchen and bath ratings are listed as average, and that property sold for $1,250,000 in July of 2024, at approximately $479.11 per square foot, with an adjusted sales price of $927,300. Comparable number 3 is 166 South 8348 Kurtz Lane. Property resides on 0.28 acres of ground, is a 2-story colonial home built in 2003 with 7 total rooms, 3 bedrooms, 4 full baths, 0 half baths, 4 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned. It is an A- grade in very good condition. The above grade area is 3,112 square feet. It has 1,000 square feet of finished basement area for a total square footage of 4,112 square feet. The kitchen and bath ratings are average, and that property sold for $1,100,000 in June of 2024, approximately $267.51 per square foot, and then it has an adjusted sales price of $735,900. Comparable number 4 is 66 West 18515 Jewel Crest Drive. That property resides on 0.18 acres of ground. It is a colonial, 2-story colonial, built in 1994. It has 5 total rooms, 3 bedrooms, 1 full bath, 3 half baths, a full basement, centrally heated and air conditioned. It is a B-grade home in very good condition. The above grade area is 1,835 square feet. It does have 987 square feet of finished basement living area for a total of 2,822 square feet. Kitchen and bath ratings are average. That property sold for $1,150,000 in June of 2023, or approximately $407.51 per square foot, with an adjusted sales price of $981,000. Comparable number 5 is 76 West 18160 Janesville Court. The property sits on 0.41 acres of ground, is a 2-story contemporary built in 1984. It has 6 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 3 additional plumbing fixtures. A full basement, is centrally heated and air conditioned, is an A- grade, is in very good condition. The above grade area is 2,818 square feet with no finish in the basement for a total of 2,818 square feet. The kitchen and bath ratings are listed as average, and that property sold for $1,180,000 in June of 2023, or approximately $418.74 per square foot, with an adjusted sales price of $916,400. And that concludes our assessor's information and evidence.
All right, thank you. The property owner can ask questions of the assessor.
Yeah, I just have a couple of questions. So when I look at the MRA estimates on the sheet, if you were to use these comparisons against another home, would the MRA estimates all remain the same, and then the adjusted price would all change?
The adjusted price and the MRA estimate would be different. So if you're using these comparables on a different subject property, those values would change because the comparables and the MRA are based on adjustments made to the comparables from the subject property. So if the subject property were larger or smaller, that would affect the MRA estimate and the adjusted sales price.
Okay, so it would affect the MRA estimate also?
Yes.
Okay. And then my other question is, when looking, so these are all lakefront homes. Mine are lakefront homes, or mine is a lakefront home, obviously. Do you just look at land and for adjustments on the land, say, okay, this is a lakefront home, and then treat them pretty much the same, or is there an adjustment based on where you are on the lake?
The adjustments so that we would have a difference between the lakefront and channel lots, we do break that out. There is a different rate that is applied, and then there could be additional factors depending on the location of the lot on the lake. There are several ways for us to adjust the values of those lots.
Okay, and would you be able to tell me, was the channel rate used on mine?
Yes.
It was, okay.
It was.
All right, thank you. That's all I have.
Any questions of the assessor from the Board of Review?
I think I have a couple questions.
Yes.
For the assessor. I'm having problems understanding the MRA. Because I'm looking at the final sheet that the homeowner submitted, and darn, it looks like the MRA is pretty darn close to the sale price of the house. Can the MRA be a predictor of the sale price of the home?
It can be in certain situations. We normally defer to the market approach, and the market regression analysis does not take into consideration the style that the comparable process for the market approach does. In situations, the market regression analysis estimate may be used to value a property, and that does not look at style. It looks at the raw square footage and the amenities of the home. So the amount of square footage that's finished, the amount of basement. There's an adjustment for the number of bedrooms, number of bathrooms. There's a value that's applied to several factors of the home, and that can fluctuate, vary. So in some situations, our market approach may be more spot on than the market regression analysis.
Do you have a choice when you do this, or you are consistent throughout?
We primarily default to the market approach. There are some properties in the city of Muskego, which we'll see later in other hearings, that we use a cost approach, but we can choose between the market regression analysis and the market approach.
And then what criteria do you use to make that choice?
Typically, we will look at what the model is doing within a subject neighborhood. So while what we're seeing here with the assessed values being significantly below the sales price, we're not seeing any of the properties that are assessed closer to sales price or above the sales price, or the statistics that are related to this area that we're making the determination based on.
So what does it get down to when you decide what method you use?
We look at the areas that are being reviewed. We look at statistically. So we're looking for medians that are close to 1 or within the plus or minus 10% from the market value, or 1. So we're looking at sales that are falling in line statistically between 90 and 110%. We do look at the area. So if we're looking at analyzing a neighborhood, we look at the statistics for that neighborhood outside of individually looking. We do normally look at any outliers, so anything that's assessed significantly above or significantly below. This looks like we did have a couple that did not raise a flag for us to review before the values were set.
All right, so I guess I have two more questions. One, if we just look at the sheet, this last sheet, statistically speaking, we've got 5 properties. Mm-hmm. Out of the 5, obviously one is the homeowners. The others are the comparables you used. Statistically, does this match between the MRI and the sale price? Is that unusual?
This is a situation where the MRA estimate is a little more sound than the market approach that we are using. So that is correct. It may not be the case in every situation or for every area that we review.
Would looking at the sheet and taking into account the statistical differences that are pointed out by the homeowner maybe cause you to look at a different approach to assessing the value?
It may be something that triggers to look at using a different approach for an area, depending on the statistics that are being analyzed and what the statistics actually are for that neighborhood.
Did you have an opportunity to go over these numbers with the homeowner at open book or whenever prior to today's hearing?
Yes, I believe there was an open book hearing or informal meeting with the homeowner, and that was on August 21st.
All right. And was there any reason that you decided not to change your approach to the valuation of his property, at least based on that last page?
Well, this information was not presented to us at the open book. This is something that we've been provided with between the open book and the hearing today. The information, basically, at the open book, we go through the assessment information to verify the assessment data and room counts, square footage, things of that nature. Condition primarily is one thing that we look at if there's some significant wear and tear. What we were looking at there, the assessment data seemed to be correct and accurate, and we're not looking at the sales within that area outside of the comparables, but we were looking at the comparables as the market value, not a comparison between the assessments. We were looking at the sales price versus the assessment of the subject since it had not recently sold.
All right, would anything that you've heard today from the homeowner, given the new information that he's presented today, cause you to defer to another analysis of his home as far as valuation?
I think that the information that is provided shows that in a limited view of the 5 comparables, because we're also not looking at any other sales that are in this area, I can see statistically that the comparables are below market value. That may be something that I may have been able to take into consideration if I had the information at that point in time through the open book process. The determination was made not to change the value through the open book, and I'm here to defend my value today.
Thank you.
You're welcome.
I have a few questions. The assessed value that the taxpayer presented for each of those 5 comparables, is that correct for the 2025 tax year?
I believe they are because he pulled them from the assessment roll or the preliminary assessment roll. I have not verified if any of those did change from the open book process. So the information he is using is from.
Got it. All right. I see. Yeah. And also the cost approach for the subject parcel is listed at $786,000. Is that correct? 786,400.
That is correct.
All right. And I see the assessed values from these 5 comparable properties are closer to the cost value listed on the sheet, on the pricing data, than they are, generally speaking, compared to the MRI or the sale price.
I believe that's correct, yes.
Okay. That's the questions I have.
Okay.
Any further questions from the Board of Review to the assessor? All right, any further evidence from the taxpayer?
Just one thing I'd like to say. So with the open book session, I don't believe I had a chance to talk with Sam or Nick. I think I talked to somebody named Dean. Is that?
Dean was the holding the open book.
So I talked to him over the phone. I wasn't able to give him the sheet with this comparable, but I did bring up this issue with him. I did tell him, I gave him the sale prices and I gave him the assessed values, and I told him I thought there was a discrepancy here. And his response was, he basically said, he said, basically quoting, "So you don't like the comps?" And I said, well, no, I think the comps are fine. I think the assessed values and how you're using them to compare to my house is wrong. And that's kind of where he left it. So I don't know what he wrote down for them, but I know over the phone I did share with him this last page. I told him over the phone this last page. So
Got it.
Yeah.
Can I clarify?
Yeah.
The last page with the comparison, is this what you were speaking to?
Yes, sorry, yeah.
And you provided that to him?
I brought it to his attention, yes.
Was it at the open book meeting? I don't have
Yes,
anything that we received.
it was, so I talked to him over the phone during the open book, and yes,
Okay.
it was during the open book.
Oh, okay,
Yes.
it was over, okay. So physically they were.
Physically,
not provided?
physically, no
There was
document,
okay,
yes,
no,
correct.
I just wanted to clarify, thank you.
Yes.
Any questions from the assessor to the property owner related to any further evidence?
No, I have no questions at this time, thank you.
On the Board of Review? Yes.
I
So,
have a question for the homeowner.
Yeah.
In your objection, you claim that your home is worth $810,000. Where do you get that number from?
Yeah, see, obviously I didn't have time to go and find an assessor to do an appraisal of my house. So what I did is I went and I looked at each of these assessed values on these homes. And I looked at where they were compared to my house with the adjusted price at the bottom of the sheet. And I kind of just made my own assumptions based on that. So say for the first the first comparable home is kind of hard to use because it's assessment to sales 59%. But say comparable to the assessed value for that home was $1,072,900. Sale price is 1.25. They had it adjusted down to $927,000 on the adjusted price. So I said, okay, market value is at sale price is 125. They have my market value at 962. With all the adjustments, they have that one down to 927. That's kind of what I looked at, and off that information, I said, I think my house probably falls around $810,000.
Thank you. I don't have any further questions.
any further testimony from the assessor?
Not at this time, thank you.
Right, this is the only time, I
Yeah,
believe.
that is the only
No,
time.
so that's a no, okay. Thank you then. We're to the point where we can deliberate.
Oh, do you want a summary from either of them?
Oh, yes, sorry, thank you.
That's all right.
Would you like to present a summary, Dan?
Sure, yeah. So I guess in summary, after looking at the evidence and what I have presented, I believe my house was assessed unfairly high, and I think it should be lowered to 810,000. Thank you.
From the assessor, a summary?
Given the comparables that we've provided, I feel that it's a fair and accurate assessment in lieu of any direct market information provided. The assessments cannot be critiqued based on the value or the assessment level of other properties, whether they are sold or not. It is required that we use market data, and we feel that we provided 5 comparables and that the assessment is fair and equitable.
All right, thank you. We shall deliberate. What thoughts or questions does anyone have right now? I'll go with mine. I know we're not supposed to use assessed value. You can just use comparable value, but at the same time, the comparable values, the adjustments are just not seeming to line up to me, where you take a look at the sales price and what the adjusted values are. Those 5 comparable properties aren't seeming to adjust in my mind.
I agree, and it sort of seems like from the assessor's answers to the questions that maybe a different approach might have been used if that had been presented at open book. These other ones all seem to be using a different approach.
Right, it seems like the comparable approach, the comparables were maybe not using MRA, but here we're using those comparables and like basically applying the MRA, which is very close to market value, but the comparables appear not to be in line with the MRA.
Right.
I'm not disagreeing with it. Those were the questions I had.
Right. What other thoughts or questions, deliberation here?
Do you have any more deliberation?
I'd probably like more time to talk about this than probably what we've got right now, but it's up to the board as far as.
More time for the 5 of us to talk about it?
Our deliberations are public.
All open record, yeah?
Yes.
They've never been closed.
No, and that's why I would hope you would do them now. He's here so that he can hear your answer.
I'll defer to the board.
I mean, I'll just say I'm kind of leaning toward the homeowner based on what we've seen here and the comparables. These aren't comparables that he came up with. These are the ones that were used by the assessor. So I'm kind of leaning toward his value.
And that's where my problem lies. The assessor by law is correct unless proven otherwise. And no offense to the assessor, but at this point, there seems to be a discretionary choice over what method to use in terms of these comparables. And frankly, to a layperson, it looks like the wrong method was used, and that it was a choice of the assessor to look at that. And I personally think that maybe if he would have had more information at open book, maybe that last page, that there might have, we may not even have had a hearing at this point. So I guess that's my 2 cents worth. But again, as far as what the law says we're to do and what we can or can't do is the thing that's troubling me.
And just to clarify, I believe the testimony was there was an open book. It was by telephone. The numbers were given to the assessor.
He's saying that the last page with those percentages was not given.
I think he said he told those numbers to them.
I did, yeah. Over the phone, I did tell him these numbers. So there was no physical exchange of this document, but I did tell him the numbers, yes.
All right, I'm sorry. I thought that Mr. Monroe had said he didn't have it, so.
He didn't, but it was a different assessor.
If I can clarify?
Yeah.
I'm just saying that there's not a physical record. I realize it was a phone call.
Right.
There is not a notation on the review sheet with this information on there. So whether that's a step of the process or if that information was not conveyed, I did not have that on or the reviewers did not have that for a final.
But I just wanted to make sure I clarified what his testimony is. And remember, you're going off of what the testimony is right here today before you. We're done with evidence. What's before you is before you.
Any further deliberation? All right, go for it.
I'm going to throw in a couple more. Okay.
Curveball.
Just for the sake of argument again, if we feel these comparables were incorrect and that the assessor did not meet his burden of proof, as the homeowner met his burden, I mean, what happens? Do we blindly accept what the homeowner thinks the value of his property is? Or is there some basis that we believe that maybe we're talking about his testimony, he did use the numbers, but do we arrive at a number, is this an either or again? Just what he put on his sheet versus what the assessor?
It's an either or, and I believe the testimony he put on is what you're going off of. I know he answered your question of 810, but that's what you would go off of, would be that value. And again, you can't pick your own value. You're looking at the two values that have been presented.
Your dilemma, Gary, is that perhaps he didn't meet his proof, but he probably disproved the appraiser.
I think the assessor didn't meet his proof.
Yep.
Well, tie goes to the assessor.
That's.
Wait, excuse me?
Tie would go to the assessor. If both didn't meet their burden, in your opinion, that's a tie, and that goes to the assessor's value is correct.
All right. I need a minute.
All right.
That's fine. You guys could just take a couple minutes.
Think about it.
So just sit still let us know when you're ready. You guys can just sit still if you can.
Yep. So the time frame? Yep. Oh, okay. Right. Okay. We'll be fine. Yep. Oh, yeah. We'll get it done. Yep.
So we'll either accept his or accept the assessor's.
Correct.
I'll say that I'm going to read this off as if the assessor's valuation is incorrect and that the property owner has presented sufficient evidence to rebut the presumption of correctness granted by the assessor. That's how I'm going to read it off, and we can vote on it.
And I guess what I was trying to look up, and maybe you can answer it for me, is the burden of proof is on the homeowner to show that the assessor's valuation method was incorrect. If he meets that burden, whose burden does it become to show what the value is?
It shifts then to
the assessor.
If he proves that to you, the burden shifts to the assessor.
I'm reading the last three check boxes. It's the assessor's valuation is incorrect. The owner has presented sufficient evidence to rebut the presumption of correctness granted by law to the assessor, and that the property's owner valuation is reasonable in light of the relevant evidence. I'm feeling all three.
It's kind of similar to court, Mara, once the burden does shift.
That's what I wanted to check,
Yes.
because I think that was part of Gary's question is, did the homeowner meet a burden of proof on the second? But I don't think it's his.
He doesn't have a burden of proof on the second.
It just has to be reasonable.
Just the first, right.
All right, I'm ready to read it off. Okay. We got the property identification. We have this all on the record with the subject property on Danu Road, the property owner of Daniel Zernicki, and who all is present, keep saying that. There were no witnesses. The property owner, did not present proof of a recent sale. They did present sales of comparable properties, which was 5.
And it might be noted they're the same 5.
Well, yeah, same 5, and we'll mark that down. Other factors, if presented, this is really other factors around the property.
Another method evaluation was used for the comparables.
There you go, yep.
Another method of valuation was used for the comparables.
So, yes, that the factors, reasons that the valuations of the comparables appear to use a different method than the method used for the property. No other witnesses. The estimated level assessment for the current year is 100%. There is no recent sale of the subject property. There was sales of comparable properties. I think the other factors presented is that a market value is used, which is referenced in the property that adjusted prices were used, comparables to the property. No other witnesses. So we're going to find that there is no recent sale of the property, that there are recent sales of comparable properties. The property owner did present that testimony of the comparable sales. There were attributes satisfactorily adjusted for in their properties. The assessor present testimony of recent sales for the properties, yes, but we're going to say no, the attributes were not satisfactorily adjusted for the difference compared to the subject properties. I don't believe, there's no other factors besides what was presented, so I'm going to say
Correct.
no to number 4.
Yes, correct.
The most credible evidence presented was the discrepancy between the valuation method and the comparison properties relative to the subject property. And the decision which someone would need to make, I would like someone to make a motion related to number 2.
I would move that exercising judgment and discretion pursuant to Wisconsin Stat 70.47(9)(a), the Board of Review, by majority and roll call vote hereby determines that the assessor's valuation is incorrect, that the property owner has presented sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the property's owner's valuation is reasonable in light of the relevant evidence, that the full value of the property, as stated, I'd have to do the math, but we would go with the $810,000 presented by the homeowner minus the valuation, or the land evaluation.
So you're going to have land and improvements and then equals the 8.
I'm going to suggest the cost basis shows $519 for improvements, and whatever the math is would be the land is my...
Pardon, I didn't hear that.
There's a, presented by both of them, it's the same sheet, that the cost basis shows $519,000 for the improvement value. But I'm curious how that connects to... What's the current assessment value for the land and the property?
It's at the front of the final.
If I'm correct, I'd say that the value, it would be based on really the sheets, the Exhibit B we received, that the cost of the dwelling is approximately $519,000, and that the rest would be by land, the land.
42,600.
Yep.
That makes sense, right. You're using the exhibit that he presented, which is an evidence.
Yep. The difference would be $291, which would be a higher land value, but it comes to the $810.
Pardon?
The land value on the assessment's at $267. So that's another way to do that is to
meet the number of the, I didn't use the...
$810.
It would meet the number of the landowner, that we have a total of 810.
That would mean 267,400 for the land and 542,600 for the. It would be 291.
Well, let's do the math here.
If we do use this number.
Yeah. So 810 minus 519 would be 291.
So do you want to do it the other way?
No,
Or are we doing a
in discussion with other
proportionate?
board members, the land value should remain at 264.
Minus.
Okay.
267.
267, 400.
What you're changing are the improvements.
And we're changing
That
the
makes sense.
improvements.
I was
Okay.
just gonna jump in on that, yeah.
All right.
Okay, so 810.
So 810 minus 264.
Is 542,600.
That's 542,600.
Yes, that's what I get to.
Yep, thank you. Okay. All right, so I heard the motion of number 2 there. All 3 checked out with the land value of 267,400 and improvements of 542,600 for a total of 810,000. But I've yet to hear a second.
I'll second that.
Cindy seconds that. This is a roll call vote.
Gary Boyce,
Yes.
Jeremy Kyle,
Yes.
Harry Posberg,
Yes.
Cindy Schmier,
Yes.
Mara Spring.
Yes.
All right, the motion approves or carries, and it's set to 810,000 as the assessed value.
Thank you, sir.
Thank you, guys, appreciate it.
All right, and I suggest we recess until, just go off record, or?
Why don't we, what did we do last time? We just called,
We just said that we were going off the record.
you could just go off the record again for a half hour, or
Let's just do that. Go off the record until
we're coming back.
30.
1:30. Well, Gary, did you have to head out?
Gary's leaving, or?
We just have to let the dogs out. I'll be right back.
Okay, wait.
Yep.
We could send somebody to do
We
that
can go
for
off the
you.
record at this point.
We'll go off the record. All right, so we are back on the record, and we have a hearing scheduled at 1:30 for John Michaels at College Avenue and Gold Drive, but I do not see any objection filed.
No, let me check. I did not have that by noon. And he didn't even have an email, so I would be surprised.
Let me
Well-
just, can I read into the record?
Go for it.
All right, so remember, there's a notice of intent and there's an objection. Both have to be filed. The notice of intent was filed, correct, Carrie?
Yes, it was.
The objection, the statute reads, shall first be in writing and filed with the clerk within the first 2 hours of the scheduled meeting, except upon evidence of extraordinary circumstances, the board may waive that requirement up to the end of the 5th day of the session or the final day if less than 5 days. So I'm just pointing out, he's not here, so I'm not saying do that, but there's these extraordinary circumstances. Had he shown up, he could argue that to you. He's not here. There's no argument on that, but I just want to put it on the record.
All right, so it's scheduled right now, and we have nothing to discuss with it.
So I would just move on forward, and that was.
Moving on forward, which is in our tabs number 6, and we've got Eileen Glazier, who is here, the property owner. We've got a table for you over on your right. Thank you. All right, let me get organized here. I'm going to have you wait on that real quick, though. Yep, thank you. I'll just describe how we all go about it. Makes it easier for Brian because he'll see how it's been done, so. All right. Yep, all right. So first, we're going to make sure we have all the tape recordings working. Yep, and we've got that one working as well. We're recording, excellent, good. So the clerk is going to introduce the case for the hearing.
The case of Ellen Glazier, the property owner resides at West 186 South 7588 Kingston Drive. The address for the property in question is West 186 South 7588 Kingston Drive. The tax key for this property is MSKC 2195.021. The property has been classified as residential. The value in the assessment roll for the current year is land, 338,700. Improvements, 801,800. The total, 1,140,500.
All right, thank you. And then I'm going to outline first the hearing, so this is how we'll proceed, so you're aware of that. First, you get to testify, present your evidence. Then the assessor can ask you questions. We can then, as a board of review, ask you questions. Seeing no witnesses, but if you had witnesses, they could talk to. The assessor then would present his evidence. You could ask him questions. Then we could ask him questions. So you would have both had the chance to present. Then you get the chance to present any further evidence again, and then he can ask you questions. We can ask you questions again. The assessor can present evidence again for the second time. You can ask him questions. We can ask him questions. Then you can each make a summary, and then we will deliberate and make a finding on the assessed value. Make sense? I think so. Good. We're going to then swear in all the witnesses.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn?
Yes, ma'am. Yes, ma'am.
Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right.
And then you'll need to be by the microphone, and it should be on for you.
Okay.
Okay. And then with the property owner who just swore, please state your name and address for the record.
It's Eileen Glazier, W186 S7588 Kingston Drive.
All right, thank you. I'm going to read a statement, and then you'll be able to present your evidence. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as a taxpayer. Do you understand?
Mm-hmm. Yes.
All right, thank you. And then you can present your evidence.
Okay. So I'm going to hand out these pictures.
Can you give one to the assessor, please?
I forgot to ask the assessor to
Thank you.
the estimated level of assessment.
Okay, I'll do that at the first part. Thank you. Or I'll do that. I'll do it right now.
Thank you.
As you're passing that out, Eileen, we are going to ask the assessor the present level of assessment in the city.
The presumed assessment level for 2025 is 100%.
Okay, thank you. Which means that it's 100% of the fair market value. All right, thank you.
Okay.
Go for it, thank you.
All right. So I just rolled out something that's in your packet too, but thank you for giving me the opportunity to speak today. I lived in my home for the past 16 years, and I've done my best to maintain it. I don't have high-end finishes, a finished basement, or any recent remodeling. In fact, no upgrades have been done in the last 16 years. The assessment I see doesn't reflect the true situation. The comparable homes used for this valuation are not fair comparisons because none of them sit next to the kind of property I live beside. My neighbor's house was supposed to be torn down 16 years ago, but instead it's become a drug house. There are multiple police reports, garbage piled in the backyard, no garage door, and animals living in the garage and yard. That environment has a major negative impact on my property's value. I feel like I'm being penalized simply for keeping my house presentable, even though my circumstances are very different from the comparables used. I'm asking for a fair reconsideration of my property's value, taking into account both the lack of upgrades in my home and the condition of the neighboring property. Thank you.
All right, and you've given us some pictures as well as evidence. Real quick, though, I apologize. I was needing to ask you what your opinion is of the assessed value. What would your opinion be of the assessed value of your property?
Well, I'm not an assessor, but I mean, I was just looking at comparable properties and I'm thinking like 975 to $1 million. I mean, I don't, I just think the 114 is like a little much.
Yep,
And
so we'll
just-
need just one value. What would you say your value is?
Okay, all right, I'm gonna say 985, we'll just do in between.
All right. You had written 975 to 1 million, but you'll say that's 985?
985,
Okay.
yeah, okay.
Yep. Thank you. You had given us some evidence. Can you describe a bit of the evidence that you gave us?
Yeah, one of them is just like a street view. I mean, all the properties on Kingston Drive are really, very beautiful, and everybody takes care of their yards, except for the one that's next to my property. And I showed you pictures, let me just get all my pictures out, but I showed you pictures of the neighboring house, which when we purchased our property we were told it was going to be torn down. But since has been 16 years later, and we have lived next to a lot of problems throughout the years. And it's still, it's a drug house. They pile their garbage in the backyard. There's no garage door. I mean, we've gone to the city about stuff like this and because apparently the garbage can't be seen from the road, it's not a problem. But that's our backyard is where their garbage is. So, and then, no garage door. And I mean, we actually are trying to maintain as much of that property as we can just to, keep it from encroaching on ours. And, I mean, it's just, we've had problems with drugs over there. We've had the police out multiple times throughout the years. It's just been a living nightmare over there. So I don't know that pulling up to our house or my house or whatever, if somebody would say, oh, geez, I really want to live here, and then live next, I mean, you can obviously see that's not a place you'd want to live at. And then the inside of the house has not been, I mean, I don't have any custom tiling or anything. They're fiberglass inserts for showers, linoleum flooring. I've been in some of the other homes on Kingston Drive, which the values are close to mine or a little higher or whatever. And they have custom bathrooms and, high-end appliances and everything else. And I'm like, well, my house isn't like that. It's been the same for the last 16 years. So, those things. And I just wrote down some current listings. There are some of the properties that are currently on the market on the lake right now. And, I mean, obviously, they have much, they don't live next to what I live next to, and their properties are are updated. So, I guess that's my information
All right,
so.
thank you. We'll have the assessor ask any questions of you.
Sure.
Thank you. Beginning with the photographs that you've provided here, this is the directly neighboring property with
Yes.
the trash in the yard.
Yep.
And that is the one that you referenced in your letter that was supposed to have been torn down but was not at any point in time?
Right, and it's not going to be torn down.
Okay. Also, just a question on the accompanying police report.
Yep.
Is that on the neighbor, is that establishing that
That's-
that's the neighbor?
That's the
in
neighbor.
question? Okay.
That's the address, yep.
Okay. Also, you have two photographs of listings. Are you trying to suggest these homes are more similar, or have you reviewed these homes?
Right,
They're currently for sale, but they have not sold?
Right,
Okay.
right. And like the one that's 959 or whatever, I mean, that one has a finished basement and, I mean, it's obviously, upgraded. And then the other one, the inside is upgraded, the 825, so,
It's recently been remodeled?
yes.
Okay. And then the other packet here, you have just the linoleum floors, fiberglass
Yeah, just so you have
just kind of
picture-
giving us an idea of the overall finish of the
Right,
interior.
of the, those are all 3 bathrooms that, full baths.
Okay.
So no tiling or anything, it's just fiberglass inserts and.
Have you has there been a recent appraisal on the subject in the last couple of years, or?
I refinanced, I know a couple of years ago, I don't remember when the rates were like super low, that I refinanced, but it's been longer than
It wasn't recent?
it wasn't like within 5 years, no.
Okay, all right. I believe that are all the questions I have.
All right, thank you. Any questions of the Board of Review to the property owner? All right, then we'll have the assessor present their evidence.
Nick is currently handing out the Assessor Exhibit A, the property record card, two-sided for the subject property, and Assessor Exhibit B, the comparable sales that were used to value the home.
Take it, okay.
Thanks, Dan. The subject property, located at 186 South 7588 Kingston Drive, sits upon .18 acres of ground. It is a two-story colonial home built in 2008. We have it listed as average rating on the kitchen and baths. It contains a full basement. It is centrally air conditioned and heated, and the physical condition is listed as good. The grade is a B+, and the CDU rating is very good. It has 6 rooms, 3 bedrooms, 1 family room, 3 full baths, 1 half bath, 4 additional fixtures, and for a total of 17 plumbing fixtures. There's a prefab fireplace. The ground floor is 1,072 square feet for a total living area of 2,481 square feet. Moving to Assessor's Exhibit B. Comparable number 1. It's located at 166 South 8362 Kurtz Lane. Property resides on .31 acres of ground. It is a 2-story contemporary built in 1995. It has 9 total rooms, 4 bedrooms, 4 full baths, no half baths, 2 additional plumbing fixtures, a full basement, centrally heated and air conditioned. It's a B+ grade in very good condition. The above ground square foot is 2,424 square feet. It does have 680 square feet of finished basement living area for a total of 3,104 square feet. The kitchen and bath ratings are listed as very good. And that property sold for $1.3 million in July of 2024, approximately $418 per square foot, with an adjusted sales price of $1,185,200. Comparable number 2 is 75 West 18642 Kingston Drive. The property resides on .21 acres of land. It's a 2-story contemporary, built in 2000, with 6 total rooms, 2 bedrooms, 3 full baths, 1 half bath, 5 additional fixtures, a full basement, centrally heated and air conditioned. It is a B grade in very good condition. Above grade area is 2,057 square feet. It has 552 square feet of basement finished living area for a total of 2,609 square feet of finished area. The kitchen and bath ratings are average, and that property sold for $1,250,000 in July of 2024, approximately $479 per square foot, and it has an adjusted sales price of $1,103,600. Comparable number 4 is 166 South 8348 Kurtz Lane. The property contains .28 acres of ground, is a 2-story colonial built in 2003. It has 7 total rooms. It has 3 bedrooms, 4 full baths, no half baths, 4 additional plumbing fixtures, a full basement, is centrally heated and air conditioned, is an A- grade, in very good condition. The ground, above grade area is 3,112 square feet. It does contain 1,000 square feet of finished basement area for a total of 4,112 square feet. Kitchen and bath ratings are average. That property sold for $1,100,000 in June of 2024, approximately $267.51 per square foot, with an adjusted sales price of $912,200. Comparable number 4 is 66 West 18515 Jewel Crest Drive. The property contains 0.18 acres of ground. It is a 2-story colonial built in 1994. It has a total of 5 rooms, 3 bedrooms, 3 full baths, 1 half bath, and 3 additional plumbing fixtures. It's fully, does contain a full basement. It's centrally heated and air conditioned. It is a B grade in very good condition. The above grade area is 1,835 square feet. It does contain 987 square feet of finished basement for a total of 2,822 square feet. The kitchen and bath ratings are average, and that property sold for $1,150,000 in June of 2023, approximately $407 per square foot, and it has an adjusted sales price of $1,157,300. Comparable number 5, 76W18160 Janesville Court. Property sits on 0.41 acres of ground, is a 2-story contemporary home built in 1984 with 6 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 3 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned. It's an A- grade in very good condition. The above ground area is 2,818 square feet. There's no finish in the basement for a total of 2,818 square feet. The kitchen and bath ratings are average, and that property sold for $1,180,000 in June of 2023, or approximately $418.74 per square foot, with an adjusted sales price of $1,092,700. And that completes the assessor's evidence.
All right, thank you. Eileen, any questions for the assessor?
No, it's just that I know where these properties are located, and they don't have garbage next to lots. Yeah, but, I mean,
Yeah.
I know when you assess something, you look at the property. I understand it, but it's like, if I was a homeowner looking for a house, I don't think I would choose my house over somebody else's house when you see that. I mean, it actually, your backyard smells from the garbage, and there's nothing I can do about it because they can't see it from the road. So, you know, I understand, you know, it's hard to find comparables on a lake, but most lake properties have beautiful homes next to them with beautiful landscaping and everything, and it's.
Do you have do you have a question though for the assessor?
I guess just that, I guess I don't.
Any questions from the board of the assessor?
Yes,
Gary, go for it.
The homeowner's arguing that the property next to her, which is not, it's not a comparable at all or anything like that, is it, where's the calculation in your appraisal that takes into account the location of the property? I know you try to find similar locations and do comparables, but if you do have a property that is in a situation such as hers, was there any consideration given on that?
I was checking the notes to see, we have no indication of the issue with the neighboring lot. So there is no adjustment that's made to the assessment currently for the condition of the home next door at this point in time.
Okay. So you're saying that did you have a meeting with the homeowner? Is there notes on that?
Yes, there was a open book meeting that was held on August 13th. The notes from that meeting, the land value is higher than the comps. The neighbor's house has actual garbage all over the yard and it smells. It's a drug house, trees laying on the house, no garage door. Cops are there a lot. So we did have the information from the homeowner from the open book meeting.
So is there anything in your records that indicates that you arriving at the assessed value on the property took that into account or purposely disregarded it for some reason?
Well, without knowing the extent, it's not anything that we have. We have the homeowner's information, her comments. We did not have the photos to show us the extent of that, and we also did not have any information pertaining to police visits or what's going on with the neighboring property or its effective value. We just simply had that there was trash in the yard and that it smells.
Well, would that have warranted further investigation if she claims that the property?
If we had, well, we can take everything into consideration. If there was sufficient information, if there was photographs or if there was a situation that we were more familiar with, we could have taken that into consideration, but we do hear quite a lot through the open book process. And I'm not saying that this is not the situation, but there are extenuating circumstances where people will tell us that they don't have a finished basement and they do have a finished basement or things of that nature. So if we warrant that it requires a field inspection, we will go out to review a property through the open book process to verify information. But at this point in time, we did not make an adjustment because we just did not take that fully into consideration without having the photos or doing a drive-by of that property. Typically, it's more of a check the condition or check the information at the owner's request.
That being said, would your opinion as to valuation change with what you've heard from the homeowner today?
I feel that there could be an adjustment made to the property for that. I still don't have the full scope of the extent of the issue. I've seen the photos myself. I believe that there could be an adjustment made, but it was not made through the open book, and I'm here to defend the value of the assessment as it is for the board of review.
I understand that. Do you have any information as to what the assessed value of the property was before open book?
Yes. Prior to the revaluation, the prior total value was $679,500.
All right. So the assessment went up significantly.
It was a 68% increase.
Thank you. I have no further questions.
If you had that information that was provided to you at Open Book and provided by pictures today, would you have maybe used your discretion to use the other model versus the MRA to determine the assessed value?
I don't know that I would make a distinction between, I would probably still use the market approach. I feel like there would be more of an adjustment for location to the land value to account for the neighboring property or any decrease in the market value due to the neighboring property or the dilapidated home.
These 5 comparisons that are listed here, are they the same 5 comparisons that we've seen in 2 other times earlier today?
They could be. I have not confirmed that. I mean, they look very familiar. I don't know if they are the exact same 5 that we'd had, but I know a couple of them have been used previously, yes.
Thank you.
I have a few questions. Could you describe, all these are listed, the subject property and all the comparables are described as very good. Can you describe what very good CDU might
Yeah, so the
entail?
CDU is the condition, desirability, and utility of the property. So it's a conglomeration of the location and the desirability and the condition of the property itself. So there is an actual condition rating for average, fair, and good. But the CDU is more, we may set that to a neighborhood of higher end homes. We may have that set to a default of good or very good because it's more of a desirability and utility, that the home is worth more because it's in a certain neighborhood.
Got it. I also see that the one home with a grade of B+ has a market per square foot of $418. The only home that has a no basement, which the subject parcel has no finished basement, also has a market price per square foot of $418. Can you give me a thoughts on how her market price per square foot might be at $460 compared to those two at $418?
So, just to make sure, the current assessed value per square foot?
You have it listed as the market per square foot is at 459.69.
Yes.
And then there's only one other that rated as a B plus grade, that's at 418.81. There's only one other one with no finished basement, that's also at 418.74. So curious
You're
how.
looking for an adjustment from the 456.9 or?
Yeah, I'm curious how those two and the comparables seem to me to be the most comparable, with the same grading for the one and the same lack of finished basement for the other one. Those are both at 418 market price per square foot, and hers is at 459. I'm curious what the
comparable number 5 is an A minus grade, which is a higher quality of home. So it does not have a basement finish, but it is a higher grade than the B plus.
So it's a higher grade, but it's got a lower market price per square foot. Is that correct?
Yes.
Okay. My other question related to the land is that this is the smallest lot out of those 5, and yet it's the highest land value of those 5 comparables. Can you speak to that?
Give me a moment to look at the property card. It is listed as a waterfront lot. I don't have the information on the other lots necessarily, but we do have that listed as waterfront primary and secondary. So it is split out between 50 feet of lakefront primary water frontage land, and then the secondary land is 10 feet for a total of 60 linear feet of water frontage. And I would have to look at the property cards for the other properties to see how they were, what rating or what land rate they are assessed at.
Got it. Okay.
I have.
Actually,
Go for it, Gary.
He can elaborate on that.
So the lakefront properties are typically around Little Muskego. The primary value is in the first 50 feet of waterfront. The next 50 feet are given a secondary lesser value, anything lower than 100 residual value.
Got it.
So it could be she just has more frontage on the lake than those large properties. They may have 40 feet of waterfront, the larger lot, the less frontage on it.
Okay, got it. All right. Any other questions for? Yep, go for it, Gary.
Yeah, I just have 2 more. One for you. I guess I have a problem. It would have been real simple for you to see what the property condition was next door based on what the homeowner said. Am I correct? I mean, you could go to Zillow or Redfin or whatever and see a picture of the house or what it looked like. That wasn't done. Is that a fair statement?
Not for the notes that I see. The review process goes from the person holding the open book period, well, it's not a hearing, but the open book meeting. They have notes and recommendations. They are looked at by a secondary reviewer, and there was no, as far as I can tell, there was no notes that they checked a Google Street View to take a look at that or went out to look at the property itself.
Do your notes reflect, though, that there were police issues with the house, or that the house was condemned next door to them, or anything like that?
The notes from the owner that were reported in the open book meeting were pertaining to the garbage in the yard, the smell, that the house next door is a drug house, and there's trees that are laying on the house, there's no garage door, and cops are there.
All right. Were you aware that you could get police reports from the city if there's references made to?
We could, yes.
All right. I guess I have a question for the city attorney. Were any requests made by the assessor's office in any way?
No, these are open records. The assessor is independent contractor, but I am the city attorney and I work with other independent contractors here. So I do get asked for this stuff. So had they asked me, yes, I could have provided, well, this and anything. I would have run the property and provided anything I could find based on that. But that wasn't done here. To answer your question.
I guess at the risk of repeating myself with a question, had you had the information that's been made available to you today, is it likely the assessed value that was issued would be lower?
I believe that there would be the ability to add an adjustment for the issues, but I can't.
I understand.
I'm here to defend it as it is.
I understand. I have no further questions.
Okay. Then we're at the point where we can, Eileen, you can present further testimony or evidence.
No, I don't have any other further evidence or testimony.
Thank you. Sam, the assessor, do you have any further evidence? Okay. Eileen, you can make a summary of your evidence and case and testimony.
I just understand that there's just extenuating circumstances in this situation, that I feel that my property is not worth what those other comparisons are. I think that I mean, if you're looking at properties on the lake, I don't think that my property is going to be one that people are going to be excited to be next to, actually, so. And I just thank you guys for your time. I don't know what else to say about it.
Thank you. Sam, any summary?
Yes, we feel that we have provided sufficient comparables for the subject property. The comparables are similar size, style, similar locations. We feel that we're using the market information that we have to determine the assessed value through the market approach for the property. We feel that it is a fair and equitable assessment.
All right, we're at the point where we would deliberate. Any thoughts or questions right now from the board? Or questions to each other, really? We're going to close the testimony, and we'll say that on record from both sides.
I'll tell you what I want. My point here is these are the same 5 comparables that we saw in the past 2. This is using the MRA estimate, where we already know that all of those other 5 aren't using the MRA estimate. It looks like from the previous assessment was 680. It's a 68% increase. The next door property was never investigated to determine, no accommodation was made for that. So I guess I'm kind of leaning towards the homeowner at this point.
And I'd probably second everything she said for the sake of time.
There you go. It feels as if perhaps if there was this level of evidence maybe presented at the open book, it might have been adjusted at that point in time,
Right.
especially around the police report. So I just want to make that known to the world. That's just our feeling so far. But I'm going to go through and read it, and I will just give everyone ahead of time that I'm going to go with number 2, that the assessor's valuation is incorrect. So we'll go through that. Pardon me, sorry. All right, so for our findings of fact, determinations, and decisions, we have the property identified, and they did notice their intent to file on time. The property owner, there is no recent sale. She did not present comparable sales, I don't believe. But there are other factors related to the condition of the location, specifically the next door neighbor, is the other factor she focused on.
Plus police.
And the police reports, yep. Related to the police reports and condition of the property.
No, there's just one police report. I know she's saying
Yes,
there's more.
correct,
but
yep, there's one police report
one that we
presented.
have.
Thank you, Jeff. Yes.
That you presented.
Yes.
You're right. Can I say something about that?
Not at this
Kinda
time.
too late.
Okay,
Thank you,
I'm
though.
sorry.
Yep.
Okay.
No other witnesses. For the assessor, estimated level assessment is at 100%. There is no recent sale. Comparable properties were presented. There was 5 properties, no other factors were presented besides the comparable properties. We find that there is no recent sale of the subject property, that there were recent sales of the comparable properties, The property owner did not present testimony of recent sales, but there were attributes satisfactorily, let's see here. Well, there's going to be no, I think, for B, because this is all related. 1A,
Correct,
3A and B is related to that. Did the assessor present testimony of recent sales? Yes, but were the attributes satisfactorily adjusted? I'm going to say no. It perhaps should have been adjusted further with the evidence presented today. And yes, we find the assessment should be based on other factors, which we wrote down related to the location, specifically the neighbor. She's next to virtually a nuisance property for the location, which was the most credible evidence presented. And we'll accept a motion. I'm accepting a motion on number 2 from anyone that would like to make that motion.
I will make a motion that exercising its judgment and discretion pursuant to WSStat Section 70.47 sub 9A, the Board of Review by majority roll call vote hereby determines that the assessor's valuation is incorrect, that the property owner has presented sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the property owner's valuation is reasonable in light of the relevant evidence, that the full value of the property should be
She had presented at 985.
$985, keep the land value listed at $338.7 and figure out the difference to come up with the improvements.
We'll do that.
Well, I did 975. Was that?
She said 985.
Yeah, why 975 was what was on that project.
Yeah, 646, that's what you had, 646, 300 for the improvements.
300, and that the level of assessment of the municipality would be at 100% with those same numbers.
That is Mara's motion. Any second?
I'll second it.
Gary seconds, and we'll do a roll call vote.
Gary Boysitz.
Yay.
Jeremy Kyle.
Yay.
Henry Posbrig.
Yay.
Cindy Schmier.
Yes.
Mara Spring.
Yes.
All right, the motion passes 5-0 with the new, or with the assessed value at 985,000 even. Okay, thank you.
Thank you.
All right.
Are we going to try to?
Are you Thomas Gendusa? All right. I'm Bill. I'm thinking we'll have Thomas, as he's at his scheduled time. There's very likely an opening right after him.
I'm also open to coming back tomorrow, if that's more conducive to the board, because
You'll.
business meeting I need to attend at 3:15. So.
Oh, do you? Okay. All right. Well.
But if that's having the opportunity to observe the process, mine might take a little bit longer, but I will leave, if it's acceptable to the board, some materials with the assessor.
Do you have flexibility for your availability tomorrow, that once we get through today, I can contact you? We can just do that, right?
Yep.
Let me double check.
Maybe we can ask this gentleman if he minds waiting.
Well,
I will
tell you also that I have criminal tax. So I've heard from criminal tax, so we have to talk about that.
Oh.
I don't know.
Tomorrow before noon.
What?
Tomorrow before noon.
Before noon?
Before noon.
Maybe.
That works.
I'll know by the end of the day. 'Cause this guy.
Did you have a trial?
Yeah, he sent me an email. So does that mean I can go ahead and put somebody in
I would, well, of course, Jeff left. Our 11 o'clock tomorrow, Jeff emailed a withdrawal.
Okay,
And so,
that's easy for me.
So can
Okay,
we
so
put,
then we can put him on for 11 o'clock tomorrow morning?
Right.
And you're
Let's do
Brian,
it.
right?
Yes.
Yep.
11 o'clock tomorrow.
he's at 1:45 tomorrow.
Okay, but he's here today, but you want to just,
he's here today, but
But the
we also have the
next
next
person's
person at 2:30 and,
and we still have enough going that you can't move him in?
He's got
Yes,
somewhere
we-
he's got.
Oh, you're fine then. If tomorrow's okay with you, then you're fine.
That's fine.
Okay.
yep.
Is it appropriate for me to leave the materials, the evidence I was presenting?
I would wait.
Not appropriate. Now we're at the kind of the hearing stage,
Yep.
and you have to present it to the board.
Yep, so,
Fair enough.
I will send you an email confirmation.
I wrote it down this time.
there
Well,
you
I will
go.
anyway, but yeah, okay.
All right,
Perfect.
11 o'clock tomorrow.
11
a.m.
tomorrow here, yes.
Thank you, sir.
Thank you
Yep,
very
thank
much.
you, yep. Yeah, is there, Carrie, do you need things for us to do immediately, or can we move up 10 minutes for Thomas?
Well, Jeff doesn't even know. Oh, yes, about the school. I mean, can they talk about that now because I got that email?
Well, it's a
Let's
3
talk about it at 3 o'clock.
It's a 3 o'clock.
Okay.
I'd wait
Yeah,
that one out.
let's just do that.
What else have I got? Sorry.
With the other
Tax,
one in the
please.
morning.
Oh, and then we can talk about Walmart.
Yeah.
And then we can.
That's perfect. That's all 3 o'clock-ish. All right.
Give me just a second, guys.
We will do that. So everyone can get ready. We're on number 7 in our books, which is Thomas Gendusa. 1 second. Did I get that right?
No, 6, 9.
Oh, I skipped
Is
it.
that 9?
All right. Perfect. We are set. You can have a seat over here. Thank you.
Got it.
All right, you got to see some of it, but to give you a fill-in, we're going to introduce the case. I'll describe to you in just a second how we'll proceed, and we'll move on from there.
Sure.
Set or no? We can take a break. Here you go.
Okay. We're ready.
You want
All right.
5 minutes or 10 minutes? No?
No, we're good.
All right, we've got the recordings going.
Yes.
Excellent. And then we'll have the court, or not court clerk, but the clerk will introduce the hearing.
The case of Thomas Gendusa, the property owner resides at South 81 West 17985 Reese Drive. The address of the property in question is South 81 West 17985 Reese Drive. The tax key for this property is MSKC 2221.991.006. The property has been classified as residential. The value in the assessment roll for the current year is land at $62,100, improvements at $361,900, and the total being $424,000.
Okay, perfect. And then to give you a, do you prefer Thomas or Tom?
Tom's fine, thank you.
Tom, okay, thanks, Tom. So the way it'll go is you will introduce your evidence based on your value, your opinion of the value. And then the assessor and the board of review can ask you questions about that evidence. Then the assessor will introduce his evidence and why it's valued the way it's valued. You can then ask him questions. We can ask him questions. You'll be able to submit additional evidence, testimony as well. And then we can ask you questions again. Then the assessor will introduce his second testimony and evidence if needed. And you can ask questions of him. We can ask questions of him as well. Then you'll get to summarize. He'll get to summarize, and then we will deliberate and have our finding.
Thank you.
Yep. And let's see here. We're going to first we'll swear in. Then we'll ask the assessor the level of assessment. All right.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Will be you as well. Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who has just sworn please state your name and address for the record?
Thomas Gendusa, address is S81W17985 Reese Drive, Muskego, Wisconsin.
Thank you. And do you have any witnesses for the property?
No.
Okay. And assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment is presumed to be 100% for 2025.
Okay. Thank you. I'm going to read off to you a statement, and after that, I'll ask you to state the amount you believe the property should be assessed at. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct, unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand?
Yes.
Thank you. Please state what amount, in your opinion, is a fair market value of your property.
I believe my fair market value of my home is about $359,000.
And I see you did write down, though, $355,000 on your form.
I'm sorry, about that amount. 355 to 360.
I'll have you pick one.
355, I'm sorry.
Okay, thank you. And then please present any testimony and evidence that you have.
Certainly. Thank you. I appreciate the opportunity to speak before you regarding my objection to the value of my home that's been presented by the assessor. Let's see. The comparables that was presented by the assessor regarding my home, I don't think compare very well. For example, my home is, the exterior is just vinyl siding. The grade on my home is just a C+. I have no rec room. I have 5 rooms. The next home that was presented by the assessor is on Dlynn, D-L-Y-N-N Court. Do you want the full address?
Yes, actually.
Oh, okay, sure. I believe it's S80 W, excuse me, I can't read that one. 16995 Dlynn, D-L-Y-N-N Court. Okay.
All right.
That home value was sold last year for $345,000. It's a ranch-style home. My realtor, I spoke with her regarding this hearing and so on, and she told me that ranch-style condos are much more desirable than my home, which is a multi-level condominium. With that said, this home is a ranch-style home. It is a grade C+, just like my home. It's in good, parentheses, good condition. It has no rec room, and it has 6 rooms compared to mine, which has 5. The next residence that was comparable by the city is on Princeton. That address is S70 W15821 Princeton Drive. That residence sold last year in 2024 for $530,000. That residence is a ranch-style home. Its exterior is masonry and composite. Mine is just vinyl siding. That residence is graded as a B+ in very good condition compared to mine, which is a C+, grade good. That residence has a rec room. Mine does not. That rec room is 874 square feet. The total square footage on that residence is 2,000, I'm sorry, let me back up. I was looking at the wrong residence. That residence that I was describing, B+ grade, that rec room is 1,130 square feet. That total square footage on that residence is 2,799 square feet. Mine is 1,800. That one has 7 rooms, which again sold for $530,000. The next comparable that was presented by the assessor is again on Princeton Drive. That one is S70, S70 W15763 Princeton Drive. That residence sold in 2024 for $495,000. It again is a ranch-style home, more preferable than mine, which is a multi-level. The exterior, I believe, is masonry. The grade level on that residence is B+, very good. Mine is just a C+, good. That residence has a rec room as well. Mine does not. That that rec room is 874 square feet, giving that residence a total of 2,425 square feet, which has 5 rooms. The next residence is on Green Street, and that address is S75 17025 Green Street. I believe if I'm reading that correctly. I apologize for the small print here. That residence is again a condominium, ranch style, more preferably than mine. And its exterior is masonry and composite. Mine is just vinyl, which is more desirable. That grade level on that residence is a B-, grade very good, has no rec room. According to Zillow, the square footage on that residence is 2,060 square feet. Again, no rec room. The last residence that was presented by the city as a comparable is again on Princeton. That residence address is S70 W15834 Princeton Drive. That residence sold in 2024 for $499,900. That residence also has a masonry and frame exterior, which is more desirable and has more curb appeal than mine. It was built in 2023. Mine was built in, I believe, 2005. This is virtually a brand new home with a grade B+ in very good condition. It also has a rec room with 861 square feet, giving that residence a total of 2,321 square feet with 6 rooms, compared to mine only has 5. My square footage compared to that is 1,802. So first off, I believe that the comparables that were provided by the city for the assessment really don't compare. I think they're apples to oranges. I think the ones that do compare, let's say the closest that were provided by the city, are the one on DeLynn, which sold for $345, and the one on Green Street, which sold for $350. The grade on those residences are C+ and B-. They do not have rec rooms, and I believe they compare closer to mine. I also have, and I'll provide to you folks, a copy of a residence that was provided to me by my realtor of another home that had sold last year in the city of Muskego as well. Would you like me to provide that for you folks?
Yes, please.
Sure.
Sir, can the assessor have one too, please?
Sure, absolutely.
Thank you.
Thank you, sir.
Thank you. So this residence with an address of W162 South 7027 Olive Circle sold last year, December 29th. Oh, I'm sorry, 2023 is the sale rate. That was a 3-bedroom, 2-bath, 2-car attached garage, built in 2005, like mine, sold for $329,000. That was in 2023 again. Square footage was more than mine, 2,120. I also looked up that residence in Zillow. The facade is masonry and composite. Mine is just vinyl. But I thought that this residence on Olive Circle, the residence on Deline Court, and the residence on Green Street were more comparable to my residence than the other ones on Princeton. Actually, the other three on Princeton, one of which was just built in 2023. I do believe that the comparisons really don't compare to mine. And the increased value of almost $116,000 to my residence, of which I think I was told some homes in Muskego went up considerably, and mine is in that higher bracket of higher assessed value. And I also believe that the land value on my home is much higher than the other ones, and I do not believe that that compares as well. So again, though the information and evidence that I presented, I believe, shows that my home is not the value that the assessor is describing, and I believe that my home is much more in the range of $355,000.
Okay, thank you.
Thank you.
Any questions from the assessor to the property owner?
Yes, I do. The subject property, is this a condo? Is this within a condo association, or is this a standalone?
Correct. It is actually, it's a standalone mirror image of there's two residences, and they're standalone. So they're mirror images of each other, connected to each other, and that's all it is. My neighbor, who is right next door to me, got the same assessment as I did, and her interior and exterior are the same as mine. And so, yes.
So there are not multiple units. It's basically a duplex home.
Call it a townhouse, right? Exactly. Yes, right.
And I was looking at the MLS listing that you provided for 16995 Gilman Court.
Yes.
Showing that there is a list price. Oh, I'm sorry, it does have the correct, I saw the list price and I noticed that we had a different sales price on that.
Yep.
And are you aware that through the comparable process, that there are adjustments that are made? This is not a straight one-to-one comparison, so there are adjustments made for graded condition and things like that.
I understand that, and taking in consideration all of that, I still believe that my house is not worth that amount of money. Okay. As a matter of fact, periodically, I do get emails from my realtor that gives us the fair market value of our home, and again, I don't have it in front of me, but I think one that was presented to me and my wife about a couple of months ago was about $350,000, and I said to my wife, how come it's gone down? Because I thought the one she had sent a couple of months previously was about $369,000. And I didn't have an opportunity to speak with her about that, but obviously there's fluctuations in the market, but in consideration, I think that her assessment, as well as the ones that I had presented here, are in that ballpark.
So if I understand you correctly, the realtor that provided the comparables for you also gave you an estimated market value of the property?
Right. Over the last couple of years, she periodically sends an email or a text message that my wife gets, and it's like a market value snapshot, so to speak. And so, like I said, the last one that she had sent was about 350 or so, but the one that previous to that was more than the most recent one she sent, and it kind of caught my wife's and I attention because it had fluctuated about almost $19,000. And so And so all the information we've been seeing and so on, I believe our house is in that range of about $350,000 or so. But I do not believe that my house is worth $424,000. If it was, I'd sell it tomorrow.
Okay, and my final question, do you realize that 2 of the 3 comparable properties that you provided to us were actually used in your sales comparison?
Yes. Yeah, the ones you provided.
Yes.
Of the 5,
one
right.
on Court and the one on Green Street were both used in the comparable sales analysis for your property then?
Correct. And I do believe that those 2 residences that sold, the sale prices on those were much more in line with what I think the value of my home is, as I compared, for example, the comparables, the square footage, the exterior, the grade of the home, the fact that they did not have rec rooms. The others had rec rooms, and which increased the square footage of those homes compared to mine. I guess when I look at those, I see, direct comparisons to my home. As a matter of fact, when I looked at a lot of the homes that were presented here as the comparisons, a lot of them had, like I said, masonry exteriors, ranch styles homes, which my realtor told me is much more desirable to folks buying than, let's say, a multi-level condominium. And I think the curb appeal, when you look at some of these homes compared to mine, is much more desirable. And so it goes with the price that they had received on some of these homes. And I think the last one that was presented on Princeton that was built in 2023 is kind of, it's so new that it's incredibly incomparable to mine, I believe. And so, again, I believe that I presented information that kind of shows my house in that 350 range, so to speak.
No further questions?
Any questions from the board to the taxpayer? All right, then we'll have here, sorry.
I just have one question. According to your objection, you purchased the property back in 2017, is that correct?
Yes.
You paid $249,000 for it?
Yes.
What are you currently insuring the property for?
Both homes, for the insurance, because I just had to look at it, unfortunately, because I had sewer backup on my house. For both homes, I think it was, to rebuild both was about $900 and let's say $20,000 for both homes. I don't know mine individually because the insurance for the exterior covers both homes. So we both have to provide, share the cost of the insurance for the home on the exterior.
Are you a part of a homeowners association?
Correct. Even though it's 2 homes that are connected together as a standalone, there's no other homes there other than our 2, because the way the house is built and the insurance demands that we have insurance that's combined for the exterior. As far as the interior, we both have individual insurance that covers the individual contents of the property inside.
All right, so the 900 plus thousand that you claim the property is being insured is just for the exterior of the home?
No, I should say it's to, for example, if, let's say there was a fire that would take both homes, to rebuild both homes from the ground up, I believe that figure is about $900 and some odd thousand to rebuild both.
All right. Thank you. I have no further questions.
Thank you. We will hear then from the assessor.
Thank you. Nick is passing out 2 pieces of paper. One, Exhibit A.
Thank you.
Is the assessment card, record card, subject property is 2-sided containing the assessment data. And Exhibit B is the 1-sided comparable sales analysis that is performed, and the confirmation is provided to the subject property.
Thank you.
Thank you, Dan. I'm sorry, I had a copy of that as well for you folks. I forgot to give it to you. He just gave it to you as well. So thank you.
Well, he was just giving us this. Yeah.
Sorry.
The subject property is a condominium-style home built in 2005. It has kitchen and bath ratings of average. It is listed as a full basement. It's centrally heated and air conditioned. Its physical condition is average. There is a prefab fireplace. The grade is considered to be C+, and it's in good condition. It contains 5 rooms, 3 bedrooms, 2 full baths, 1 half bath, 4 additional plumbing fixtures. The above ground square footage totals out to be 1,802 square feet. Moving to the Exhibit B, the comparables. I will say that through the comparable process, as we look at the subject property, the comparables, the sold properties that are being used to value the subject, you will notice upwards and downwards adjustments based on the similarities and the differences between the subject and the homes that were sold. Comparable number 1 is 80 West 16995 Dillon Court. This is a condominium. It's a 1-story. It's built in 1992. It contains 6 rooms, 3 bedrooms, 2 full baths, no half bath, 1 additional plumbing fixture. It has a full basement. It has air conditioning, centrally heated and air conditioned. It is a C+ grade in good condition. The above grade area is 1,629 square feet. There's no basement finish. It is listed as 1,629 square feet. The kitchen and bath ratings are listed as average. That property sold for $345,000 in July of 2023 with an adjusted sales price of $425,300. Comparison number 2 is 70 West 15621 Princeton Drive. This is a 1-story condominium built in 2010. It has 7 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 4 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. The grade is a B+, very good. The above grade area is 1,653 square feet. It is a total of 1,653 square feet of finished area. It does have a rec room of 1,146 square feet. The rec rooms do not count towards the finished living area of the homes. The kitchen and bath rating is listed as average, and that property sold for $530,000 in October of 2024, it was a downward adjustment to the sales price, the adjusted sales price of $427,200. Comparable number 3 is 70 West 15763 Princeton Drive. This is a 1-story condominium built in 2006 with 5 total rooms, 2 bedrooms, 3 full baths, no half baths, 2 additional plumbing fixtures. It has a full basement. It's centrally heated and air conditioned. It is a B+ grade, a very good condition. Above grade area is 1,551 square feet. It does have 874 square feet of rec room area in the basement. The kitchen and bath ratings are listed as average. That property sold for $495,000 in June of 2024 with a downward adjustment sale price of $412,000. Comparable number 4 is 79 West 17025 Green Street. This is a 1-story condominium built in 1988 with 5 total rooms, 3 bedrooms, 2 full baths, no half baths, 1 additional plumbing fixture with a partial basement. Centrally heated and air conditioned. It is a B- grade in very good condition. Above grade area is 1,246 square feet with 493 square feet of finished basements for a total of 1,739 square feet of finished area. The kitchen and bath ratings are listed as average, and that property sold for $350,000 in August of 2024 with an adjusted sale price to $359,800. Comparable number 5 is 70 West 15834 Princeton Court. This is a 1-story condominium built in 2022. It has 6 total rooms, 3 full baths, 2 half baths, 0 extra plumbing fixtures. The basement is full. It's centrally heated and air conditioned. The grade is a B+. The condition is very good. The above grade square footage is 1,460 square feet. There's no finish in the basements. The kitchen and bath ratings are listed as average. That property sold for $499,900 in July of 2023, with a downward adjustment to adjusted sales price of $430,700. And that concludes the evidence for the assessor's exhibits.
All right, thank you. Tom, do you have questions for the assessor at all?
Yes. You indicated an adjusted sale price different from the sale price.
Yes.
Can you explain what that is?
So that is when we are making the adjustments, we are making these properties that are being used in the sales comparison approach, we are making them similar to your property.
Okay.
So when you have the B+ grade and yours is a C+, there's a downward adjustment for the grade and quality of the home. If there's a difference in size, there's an adjustment for size. There's also an adjustment for some of the properties that we have here in the sales comparison were very good condition to where yours was a good, so that also is a downward adjustment for condition. So it's a series of adjustments that are made to the sold properties to adjust them to the characteristics of the subject property.
Okay.
The majority of the properties that we were using were downward adjustments because of the three that were B+ grades and very good. Those were adjusted downwards towards your sale price. The two properties that you had presented as comparables that we were using, those were both upward adjustments on the sales prices.
Okay, all right. I understand that, though. Thank you. I guess for me, the sale price on these homes that were sold is what the market will bear.
Is this a question, Tom?
Oh, I'm sorry.
Yep.
I'm sorry.
Yeah, you can tell us. Keep
Sure.
that thought. But do you have any further questions for Sam?
Not at this time. Thank you.
All right. For the board, do we have questions for the assessor? Go for it.
There's one. I have some questions. Your notes are abbreviated. Could you just, maybe for future reference as well as the current reference, is the note 1 on Exhibit B, does that refer to the current property or is that to another comparable?
On comparable one, note 1 on the comp sheet,
Yes.
the 124 2 condo per PA.
Yeah.
Yeah, so it is abbreviated. Maybe can you elaborate on that for me?
I guess I'm asking, the way they're listed, do they refer to the comparables or do they refer to
No, those are
the
the
subject?
notes on the comparables. So under the subject property, you would see the notes for the subject, and under comparable 1, that would be notes on comparable 1. Those are notes that would be on the
If you look
property.
at Exhibit A, you'll see property notes on the first page.
Uh-huh.
For the subject, 125, holding no change. Being above, there was no change in value. 1.8 from duplex to condo. So these are on the comparable sales sheet, the notes for those properties.
Okay, so basically this, if I read this right, in January of '25, this was changed from there was a change here. It was changed from a duplex to a condo, is that?
In comparison 1,
Yeah.
correct. 2 condo per, I don't have the full note.
And then it refers to a sale.
That's
That would be for comparison 2. One in 2018, there was a sale review.
Oh, okay.
Yeah, so these are contracted. Yes, they
I
are
understand that.
comparable.
I just didn't know what it was saying.
Sure, yes,
All right,
I-
thank you. No further questions.
Perfect. So my question, the valuation for the subject property that is supposed to be for which particular date?
The valuations for all assessments are January 1, 2025.
All right, perfect. And then the two that are the property owner is referencing as being most comparable were both from July of 2023, 18 months before then. Can you speak to any sort of market increase or decrease for that 18-month period?
We did analyze sales from 2023 and 2024 for the market update. So we have the varying sales from 23, 24. We don't look at just the 12-month time time period. When we're doing a market update that's more than 4 to 5 years since the last update, we do analyze 2 years worth of sales.
Yes, so but from July of 2023 to January 1 of 2025, an 18-month period, was there an increase or decrease perhaps in the general level of market value?
It is my understanding that there was not as significant as an increase, but the market was still increasing over that period of time.
Okay. Would you have any sort of estimate perhaps of what, or perhaps even just 2024, what the market value may have increased?
I don't have a number that I can rate. It's going to be different between property types and just a general overall for the market. I don't have that information.
Okay, good. Seeing no further questions from the board, Tom, you can share further testimony and evidence.
Sure. Would you like me to follow up or conclude, or?
If you have anything else
Sure.
to present or to say to us.
Yeah, I guess like I'd like to say is that the comparables that were provided for me and the one that I had provided to you folks regarding the value of my home, I think, like I said, the one on DeLynn and the one on Green compare most with my home. As I mentioned before, they are, again, those are ranch-style homes compared to mine, which is multi-level. Ranch-style is more desirable than mine. Those comparables, for example, in the grade of the home, are C+ and B-. The square footage is comparable. It does not have a rec room. And I guess I would like to assert that I added the rec room to the full square footage of the home because I believe that that is usable footage to the entire room, home, not just a basement where people don't necessarily use that all the time. So that's why I added that. And I think that does add an incredible value to the homes that were listed here that do have rec rooms. And I also, again, wanted to mention that the one on Princeton, the last one on West 15834, was built in 2023 with a grade B+. The other ones had a B+, the ones on Princeton as well. I just believe that they're comparing apples to oranges. Like I mentioned before, if you look at the exterior of these homes compared to mine, I believe that the masonry and composite has much more of a curb appeal and desirability to a potential buyer than mine that just has vinyl siding. So again, I believe that the value of my home is not what the assessed value is currently at $424. I believe it's in the range of $355. Just like the comparable homes that I had provided to you folks on DeLynn, Green, and Olive Circle. Thank you.
All right. Thank you. Any further testimony from the assessor?
To summarize, we've provided 5 comparable properties of similar condos, similar size, amenities. Those sale prices have been adjusted to arrive at a market value for the subject property. We feel that the information that was provided to us that we're using provides for a fair and equitable system.
Okay.
I think they both just did their summary.
It sounded like it to me.
I know what you were asking, but yeah.
Yep. Do we have any further questions for the assessor or the property owner? Would you like to provide another summary, or was that sufficient? It felt like you both had done a summary in a way.
Yeah, right.
Yeah, okay.
Yeah, I think I'm
okay.
concluded.
Okay, excellent. We'll move then to deliberation from the board. Thoughts or questions around for each other? And I'll first close the testimony from both the assessor and the property owner.
I would just note that the property owner states that the 2 comparisons that he thinks are the most similar are the one on DeLynn and the one on Green. And if you look at the 2025 assessment for both of those, DeLynn is $414,009 and Green is $448,900. So it sure seems like his assessment is right in line with what he says is comparable to his home.
All right. Any further questions or thoughts? Yeah, I'm seeing the adjustments that were made and, yep, all right. I think I see where it's at. Okay, so we're going to go through our findings of facts and decision-making. The property owner and property is listed there. There was a timely notice of intent to file an objection. The property owner testimony did not include a recent sale of the property, but did include recent sales of comparable properties. I'm going to say that 3 were presented from his sheet. Other factors, well, were related to the grade and finish of the home, like the exterior, and also the 2-story condo versus being a ranch condo. No other witnesses. Pardon me. From the assessor, we have the estimated level assessment for the current year at 100%. There was no recent sale presented. There were recent sales of comparable properties. A total number of 5 properties were presented. I suppose under other factors was the sales price was adjusted to, they have an adjusted price in each of the comparables. It was not a one-to-one comparison, but there was an adjustment price based on factors that the assessor took into consideration. Moving on for determination, the board finds that there was no recent sale of the property. Did the property owner, there was recent sales of comparable properties, yes. Did the property owner present testimony of recent sales of comparable properties? Yes. Were the attributes satisfactorily adjusted for their differences from the subject and their contribution to value? I'm going to say no, there's no adjustments made based on grading or square footage. Assessor, did the assessor present testimony of recent comparable sales? Yes. And were the attributes satisfactorily adjusted for their differences from the subject, property, and their contribution to value? I'm going to say yes to that. The Board of Review, no, we do not believe there's any other factors that should be considered, and I'll accept a motion on our decision whether to uphold the assessor's valuation as correct or as incorrect. Pardon me.
Well, I'll move that exercising its judgment and discretion pursuant to Wisconsin Statute 7047-9A, the Board of Review by majority and roll call hereby determines that the assessor's valuation is correct.
And any other checkboxes in there?
I guess I'll go through. I'll go through. Refer to the numbers again. This is not agricultural property, so that doesn't apply. Let's see. And so all the others apply.
Number 5 does not, though. Undeveloped land, agricultural forest.
The last one at the end, I don't think is.
What? The last one, yeah, should also be excluded.
So I can do this, can you say at least the first part?
Oh, you want me to, I'll read it.
You don't have to read the whole thing. So we've got the assessor's
Okay, the
valuation.
assessor's valuation is correct. The assessor presented the evidence of fair market value. The assessor presented evidence of proper classification. That the property owner didn't present sufficient evidence against the presumption of correctness. That the assessor's valuation is reasonable, and we sustain the same valuation as set by the assessor.
All right, that is the motion.
That would be my motion to accept that.
I'll second it.
Henry Posbrig, seconds, and we'll go to a roll call vote.
You don't need that. I'm sorry, I did that.
Yeah, you don't need that. Okay. Gary Boyce,
Yay.
Jeremy Kyle,
Yes.
Henry Posbrig,
Yes.
Cindy Schmier,
Yes.
Mara Spring.
Yes.
All right, the assessed value is correct and upheld. Thank you.
Thanks. I strongly disagree.
All right, it is right about 3 o'clock. We have something listed on the agenda here with an update, I think, from Carrie.
So, when, if you can hand these down, this is one email. You know how emails go, they're backwards, right? So I gave you 3. And we did hear from Pivotal Tax, and she just had some questions. Don't mind my top one. Can you print all these? But she
We're good.
wanted to know if it was gonna be her.
Oh, no one more.
Reheard. Oh, one more. So I
Right,
think if
no?
you go to the second.
We're okay.
We're good.
Okay,
Thank you.
if you go to the second page, she asks, stating some information from the conversation I had with her yesterday, but I have to bring this to your attention that she's asking these questions, right? I'm just the clerk, so if she's asking these questions, it's not up to me, right?
Yeah, it just gets read into the record.
Okay. Because it's not my determination to say anything, right? So she's asking the question, is there any other hearing date available that we can attend? Will our evidence be heard on the record if we're not there in person? And then at that point, I had said that you guys were still, currently the board is hearing testimony for another case. When time is available, I'll bring this correspondence forward. Please keep in mind, all decisions are made by the Board of Review. So I have not responded to her at this point, so I'm leaving that back to you guys and what you want to do with that.
Well, they state they canceled their travel plans. I don't know that we have any evidence of that, but.
This doesn't make any sense to me. I don't know what the explanation was for
Pivotal.
why they canceled their travel plans.
I think because they said they were going to be called at 3 p.m., but this makes no sense to me either. You've already, we didn't allow their waiver, correct, to testify by telephone. No one's here. I think this case is done. They can't just email at the last minute now and say, can we have another date? Today was their date.
Well, give us a reason as well.
Right.
Yeah.
I don't have a reason here, or we don't have one.
I mean, again, your call, but that's what I'm seeing right here. They're not here, and you emailed them, didn't you, Carrie, and said you got to be here.
I mean, I'm assuming that the conversation that she's referring to, she says, yesterday we discussed the board calling us at 3 p.m., meaning yesterday, like the 3rd?
I talked to whoever the. Who? Samara. And they just wanted to confirm that the hearing was going to be held. And again, this is another situation where there's 2 people that are communicating with me. And so she just wanted to confirm that it was going to be held today, and I told her that it was going to be held today.
You didn't say you don't have to be here. You just said it's going to be.
I said I received your telephone testimony request.
And the board has to make a decision on it.
Well, I probably didn't say that.
But I mean.
But I said I received it.
Yeah.
Because then I sent her an email stating that, because, again, these are 2 people that are doing 2 different things, so give me a second here.
They had to fill out the request to testify by telephone, which says the board may allow it, and it says if it's approved, what number should we call you? So it seems obvious that they were notified it wasn't a done deal. That wasn't a sure thing.
Okay, so.
Yeah, yes.
She emailed me, what is her name? Samara.
Yep.
Yesterday at 2:34. I wanted to reach Doesn't make sense. Good afternoon, Ms. Roller. I wanted to reach out as we have a hearing scheduled for tomorrow at 3 p.m. I've also left you a voicemail. Can you please confirm if we will be presenting in front of the board tomorrow? If not, will the hearing be pushed to a later date? We are located out of state in Arizona. Also, can you please confirm if there's an option for the board to hear our appeal if we are not there? I responded. I sent her the two emails, which I'll have to go back and read those again. Please see the attached email indicating confirmation of your hearing, and it is at 3 p.m. Central Standard Time, and it will not be rescheduled to a later time. Tiffany did already submit a request to testify by telephone. If we run early, we may try to call your hearing a bit earlier. If we can't reach you prior, we will call you at 3 p.m. Central Standard Time. But I'm okay with that because I did not confirm.
So once again, now, we heard this at what, we heard the waiver at what time? We heard the telephone testimony earlier,
Oh, yes,
right?
yes, around.
So why didn't we wait till 3 to call them for the telephone thing?
I think because it had on there that we had to notify them, so we sent them an email to let them know.
Right, but now I'm rethinking this.
Because if they knew they weren't going to be able to appear in person, they could have sent somebody at 3 o'clock.
The owners are listed in Madison. And
Right.
we said we're not going to accept telephone testimony, but their hearing is at 3 o'clock, and we can attend if,
Sure, and we let them know at whatever time that the testimony was denied. So they had time to be here.
Correct.
Right, right. Back to my original thought, right.
yep.
So is there a motion that we need
So
to make?
we actually did them a favor in a way because
did,
we could have waited till 3 to done that. We did it early and gave them the right to be here. So I think I would do them, well, yeah, I guess because they put this in now, I would do a motion of whatever you decide to do right now.
They do have an objection filed.
That was part of the reason, though, is their objection, they're not going to be here, and it was over $1 million objection. So it was determined that they could,
Sorry, go ahead.
just that they could send somebody. if they-
Right, you made a good record earlier that this is a big deal and it's $1 million and they should be here. So that was what you made record earlier. So at this point, you made the record, you denied the telephone testimony, you could just move on right now. What motion are we going to make at this point?
Right. Do we have to act on an objection? Do we have to do a determination of finding a fact if no one comes to present?
Not if no one comes to present. It's a null.
I'd move to reaffirm
Sure.
our denial of telephone
Testimony.
testimony, and further move
With
that
no one being
they
here.
no longer- No one is here, and they no longer have a chance to be heard.
Yep, second that. Anybody?
So we're reaffirming our previous denial of telephone testimony, and also acknowledging that no one from Muskego School Apartments has arrived for their 3 p.m. scheduled time.
And it's 3:15 right now.
I'm not even sure if they have the right to appeal this. If they do, then they can go to circuit court.
Yeah. Right.
At 3:15.
So there's an option for them.
Okay. So I have moved to reaffirm to deny telephone testimony and acknowledge that there's nobody in attendance for the hearing at 3:15 p.m.
For the 3 p.m. hearing. And you'll notice that
Right,
this
for the
is
3 o'clock hearing, and it's now 3:15.
For the 3 p.m. hearing.
Yep. All right, well, I heard that motion from Gary.
I'll second it.
Henry is seconding. All in favor, say aye.
Aye.
Aye. All opposed?
Roll call vote?
Let's do
Roll call?
roll call,
All right,
just
we'll roll
because
call it
this is a special one.
Yep.
All right. Gary Boysitz.
Aye.
Jeremy Kyle.
Aye.
Henry Posbrig.
Aye.
Cindy Schmier.
Aye.
Mara Spring.
Aye.
Now I have a question. What do I do with the email from her?
Ignore it. I mean, there's no reason why are we responding now? We'll end up sending them something. You don't need to send it right now, and then they're going to call, and I would just for right now, when I say ignored, I mean right now.
Yeah.
So, with that, we should probably take care of the things that we were supposed to address in the first 2 hours.
There we go.
right?
Let's do that.
Which I think some of them were done.
So what are we on?
So hang
Well,
on,
we
go
have
back
a
to the agenda.
3:45 is our next scheduled hearing.
Okay.
Oh, wait,
Uh,
okay, yeah.
Yep.
We hit during the first 2
And
hours.
on the agenda, back in number 1, we have already gone through everything on the first page of the business.
Yes, because we started the hearings.
Yep. And on the second page, we have some things to consider. The waiver of the required 48-hour notice of intent to file an objection when there is a good cause, including but not limited to Matt Welford, the agent for Judy Andrew Roth Family Limited Partnership. Is that the person who withdrew, or no? Did somebody else, you said somebody withdrew?
I think somebody tomorrow withdrew.
Yeah, okay. Sorry. Just like-
That's
I
the
wanna add
person.
one more thing to the slide here. Okay, and here you go. There's another email. If you guys want a copy, let me know. Hi, this came to me from Matt Welford. That's who we're talking about.
Yep.
Okay. 11:37 a.m. today, September 4th, 2025. Hi, Carrie. Thank you for all your good work on my paperwork for the review board. Judy and I have discussed the assessment and that we were seeking. Because the difference is only $28,000, we've decided not to pursue the issue this year, so please withdraw our Friday appointment at 11 a.m. Sincerely, Matt Welford and Judy Andrew.
That one's done.
Yeah, so we don't need a waiver then.
And are we having Brian
Okay.
and Brian's, at the number 19 then is filling in at 11 a.m. for that
Yes.
withdrawal?
Okay, so, yes, so that was the conversation that we were gonna move Brian up to 11 a.m., and I will email him this evening and confirm.
At the same time, you mentioned that he had filed his objection and agent authorization at 10:02 this morning?
Hang on, let me see what that one says.
That's your note.
Yep, that's Brian Miller. So, this morning at, what time?
10:02.
10:02, staff came in to give me the objection for Brian Miller and his, I put it away.
Agent authorization.
Agent authorization, yes, he is the gentleman that came in, thought he got his days mixed up. So he did file his objection and agent authorization within the first 2 hours of the Board of Review. So I just wanted to bring that to the surface because we've been discussing all of these on the agenda. But I just wanted to make note of it.
Okay.
Okay?
There's nothing to act on that right now.
No, I think that's just a note I just wanted to add because we
So his,
had some of this information over here.
I'll let
And
you
it was
keep
an
that note.
objection that came in the first 2 hours.
Perfect.
I have a question about the other item on for tomorrow that doesn't have a check box for the objection, the 1 o'clock?
Yes, we'll get to that soon,
Oh,
if you can wait.
sure.
Awesome. We'll get to that one soon. Perfect. So during the first 2 hours, we don't have to worry about Matt Welfare waiver because he took it back. There's a better term for that. And then Brian, we're moving to 11, but we don't have to act on anything now. Just everyone knows he submitted his stuff in the first 2 hours. And then I'm going to move to 3 real quick because we already handled all these. The request to testify by telephone for Cal, Jeffrey, and Pivotal Tax
But-
Solutions.
This is the one that withdrew.
That doesn't matter. Yep. So I'm going to move to 4, 5, then we'll get back to 2. Any? All right.
Today, September 4th, 2025 at 11:13 a.m. I did receive an email from the agent for Walmart, and they are.
Let's get to that. One second.
you're gonna.
Yeah, we'll get to that.
That's number 2, right?
That's number 2. We'll do 2 in a second.
Oh, I'm
Number
sorry. I'm
4
sorry,
and 5.
Jamie.
That's right. I'm
was
curious,
scrolling.
are there any subpoena
What-
requests?
yeah,
Yeah,
what
pass
is-
it on down.
What is for, why are we subpoena requests for, are there any,
Denny.
what?
There aren't any, are there?
Yeah, so
It's, we're,
you just put it on there,
yes.
okay.
All right. And then any other legally allowed or required Board of Review matters for us to review right now?
That normally comes at the end anyways, but no, you're fine.
All right.
Yeah. So we're back to number 2, I
Can
think.
we say number 5 is completed? Or do we need
We
to wait
normally
till the
would
end?
do it at the end of tomorrow.
Okay, so this
So
is
I
at
would
the
just
end.
hold it for tomorrow too.
Thank you for that. All right, now we're at number 2, which is request for waiver of the BOR hearing, allowing the property owner an appeal directly to the Supreme Court, Circuit Court, which is our 1 PM for Walmart. And we did get exactly that.
And on the third page, request for waiver of Board of Review. You guys have this? That's what I emailed you guys.
Oh, okay. Do you have extras for you?
I don't know.
When did you see his authorization?
No.
All right, so we have an agent authorization.
11:15 today.
Just say it. You see what it doesn't say anything. It doesn't say anything.
Well, okay, but it doesn't matter because.
So we're noticing the agent authorization. We noticed an objection to the real property assessment. And then,
I'm gonna review that agent and see what it looks like. Maybe it just printed weird.
I bet
know
you
what
printed
mean?
weird. We do have a request to testify, but we also have a request for waiver of Board of Review hearing. So I assume if we do the waiver, we don't even address the testify.
That's correct. And just so you all know, we do have a policy and a procedure on waiver. I don't know if you have it in your packets, but there are criteria, and you can hear from the assessor, but there are criteria for you to discuss.
We had reviewed that at our June meeting, I know.
Yeah.
It's in the back of your books.
It's in the back of
I
our
just want to make
books.
sure you have it, so when you're deciding this, you can look at that.
So that is tab 5, somewhere in there.
The last page I
Yeah,
have.
like
Last
they're,
page,
some
yep.
of them are in little sheet protectors. The first one should be ordinance number 999 for confidentiality. The second one should be your procedure for waiver of Board of Review hearing request.
All right. And then there's a procedure, if somebody wants to waive, then there ought to be a timely notice of intent to appear and a timely objection form, which I believe both those things happen. And then the criteria may consider any or all of the following factors: the benefits or detriments of the Board of Review process, the benefits or detriments of having a record for the court review, avoidance of unruly, lengthy, burdensome appeals, ability to cross-examine the person providing the testimony, any other factors that the BOR, Board of Review, deems pertinent to deciding whether to waive the hearing.
So Walmart put their request in by writing. Now, Sam has the right to answer, or if he cares to, tell you his opinion on this.
There you go.
Typically with properties at the Walmart or the big box stores, I would waive those to circuit court myself. I do not have any issue with it being waived up here locally.
So no objection, basically.
No objection.
All right, and in the request for waiver from Walmart Real Estate Business Trust, their basis was to take matter directly to circuit court.
And just, that happens a lot with these big box stores.
Gotcha. So then, how would we frame that as a motion to say we punt? How do we?
Well,
phrase
you
that?
can just kind of say that,
We
looking at
accept-
the criteria, you find that we've considered these factors and that you would accept the waiver and motion to approve the waiver.
There you go. So something like pursuant to our
Criteria.
All right, I'll let somebody do that then. I can do it?
So, well.
Then I'm going to do it. I'm going to make a motion.
Well, yeah, sure. Basically, the benefits or detriments of having a court, having the record for court review, well, the circuit court's going to do all this. So
Yep.
that's fine. Unruly, lengthy, burdensome appeals. This could be a long hearing with Walmart, I assume, correct? So there's no problem there. Just take it to circuit court and they can hear the whole thing. Cross-examine, that won't be a problem because there'll be cross-examination at circuit court. So I don't see any of these factors being a burden to you in your decision. I think that they're all fine in terms of you doing a motion to approve the waiver.
All right.
Go for it.
And I'm sure you've done this, I might have missed it, it's timely.
Yes, yes,
Yep.
yes.
Yep. Yeah, they met the first two things, a timely notice of intent. All right.
So you just need a motion then to waive.
I will move that pursuant to our procedure for waiver of Board of Review hearing requests, and after reviewing our criteria, we will accept the request for waiver of Board of Review hearing from the Walmart Real Estate Business Trust.
I'll second.
And Gary seconds. All in favor, say aye.
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 You don't
Do you
need a
prefer roll
roll
call?
call.
Any opposed? All opposed? All right, the motion passes. There you go. All right, so next is listed at 3:45 for Michael and Suzanne Albrecht. And looking here, I don't see anything left on the agenda that would be covered up until now.
So we just, till 3:45?
3:45.
So we just go off record till 3:45?
Yeah, we'll do that. We're going to go off record until 3:45. All right, we're going to get back on record.
Well, congrats. When you move in?
Just a minute.
Okay.
Jeremy.
My throat gets dry in here.
We're missing one.
Yeah, we know, yeah. Yep, good. All right, our scheduled hearing at 3:45 is for Michael Albrecht and Suzanne Albrecht. Looks like you're here. Come on down. You've got a table here for you. We've got a uniformity that we do for each of our hearings, so we've
You can
got.
just make sure your microphone is on. Push,
Up, not on.
hang on a second, I might be muted her. There, how's that?
Sounds right. All right. Thank you. And the clerk, Carrie Roller, will read the hearing into the record.
The case of Michael and Suzanne Albrecht, the property owner resides at West 190 South 7058 Wetland Drive. The address for the property in question is West 190 South 7058 Wetland Drive. The tax key for this property is MSKC 2180.948. This property has been classified as residential. The value in the assessment roll for the current year is land at $263,100, improvements $749,700, the total $1,012,800.
All right. So I just want to share how we will proceed, and then we'll swear people in and have you start presenting your testimony. So first, as the taxpayer, you'll be able to present your testimony, any evidence that you have. Then the assessor can ask you questions. We, as the Board of Review, can ask you questions. Then the assessor will present their testimony, and you can ask them questions. We can ask them questions. Then you can provide further testimony, further evidence if you have that. Repeat the process. He can then ask you, we can ask you. Then it'll be turn for the assessor to present any further testimony. You can ask him, we can ask him. Then you'll be able to summarize your position. He'll be able to summarize his position. I'll close the testimony, and then we will deliberate amongst ourselves, which you'll view here in open record, and then we will make a finding of determination. All right, good. And then we will swear everybody in.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your hand to be, your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who just sworn please state your name and address for the record?
Suzanne Albrecht. My address is W190S7058 Wetland Drive.
Okay.
Michael Albrecht, West 190S7058 Wetland Drive, Muskego, Wisconsin, 53150.
Thank you.
Do you have any witnesses here to be sworn?
No.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for 2025 is presumed to be 100%.
All right. And then I'm going to make a statement, and then you'll be able to, well, you've already stated names. We're good there. Right. All right. So here we go. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand?
Yes.
All right. Thank you. Please state what amount, in your opinion, is the fair market value of your property. I see you have it listed on the objection to real property assessment.
Sorry.
775,000.
All right, thank you. Please present your testimony and evidence.
We are objecting to the 2025 assessment on the grounds of disproportionate increase that's inconsistent with the comparable properties. The disproportionate increase is that the value of the property increased by 68% from $604,000 in 2024 to $1,012,800 in 2025, despite any substantial improvements being made since the home was built in 2015. By comparison, the city of Muskego's average property increase was approximately 26% in both land and home values, making the 68% non-uniform with the rest of the municipality. I have an Exhibit 1 that just shows that the property values listed on Muskego's website. I included 2024 and 2025 values, and it appears that we have the 23rd highest increase since 2024 out of the 10,001 properties. And without any improvements in our house, I would imagine most people had some improvements, that there would be many more than that. The land increased by 30%, which seems relatively uniform, but the average of 27% by my calculations. And the building increased by 87%, which seems disproportionately increased. We have channel footage or frontage versus lake. We are located on a channel which is not on the main lake of Little Muskego. There are no shared beaches or deeded access points that we get to enjoy. Our channel footage has considerably less market value than a true open lake frontage. And our channel is often only 6 to 12 feet deep. It's 6 to 12 inches deep at its max in summer, and it often just runs dry. It runs dry in spring and fall and is dry in winter. It is a narrow channel, so we can only have one boat or less, depending on the depth of the water. And there's no swimmable frontage. It's all muck on the bottom, and the weeds that are chopped up in the lake all flow into our channel, so we often can't even get a kayak in it. So it's not very open lake friendly. In the winter, when we have the drawdowns, there's no water out there, and same with the spring and fall when the drawdown is there, so it's just muck, and it doesn't provide us access to the regular lake. In contrast, the lakefront properties that our house was compared to had swimmable beaches, elongated piers for multiple boats, swimmable areas, deeper frontage, and are just a much higher demand and a much higher valued home. Therefore, I don't think that those are true comparables to our house. I do think that we could compare our house with the neighboring channel homes or other channel homes, but I know that that is a very limited supply. In Exhibit 2, I supplied just photos of our house to show that even though our house is 10 years old, it doesn't compare to the houses as are shown in the other additional exhibits. Those houses are, again, on open lakes with more square footage and just more higher end homes in general. Our land value came in at $263,000 and our home at $732,000. So the cost per square foot came in at $260 a square foot. The average of the 5 superior houses compared to ours had a cost per square foot of 227. I do not believe that our square footage should be higher per square foot than those houses. The frontage of our 50 feet of lake footage shouldn't be compared to the other 50 feet of lake footage on those other types of homes. I'm going to go into the comparables used in our sales analysis report. We were given those electronically, and I reviewed, and in Exhibit E and Exhibit C, those houses are both located on Bass Bay. They have prime open lake frontage with large piers and sandy beaches. They have more square foot than ours. One has 3,000 square foot and one is over 4,000 square feet, and their costs per square foot are still only 213 and 171 respectively, which is much lower than the 260 that ours came in at. The recent sale prices on these homes were 1.3 million and 1.1 million respectively, and their adjusted prices in the assessment of Muskego has them at 1,818,000. So both of those respectively had a 23% and a 14% increase in from their 2024 values. So again, I'm not sure why ours had an 87% increase. The Kingston Drive parcel is a beautiful home on Little Muskego, but it's out on a peninsula with full lake views and a large dock. It's in Exhibit D. It was last sold for 1.25 million. Its adjusted price was 1 million. It did have a 61% increase since 2024, but ours is still higher than that. The Janesville Court property was Exhibit F, was last sold for 1.18 million. It's located on the southern end of Little Muskego off of Janesville Drive. It has full open lake views. There's swimmable areas right there. Its adjusted price was $999,000, and it had a 30% increase since 2024, much lower than our 87%. The Caring Court property in Exhibit G was last sold for $1.135 million, and it is located on Lake Danoon. It has full lake views, it has its own beach, and it's next to a public launch, so it has lots of open space and open beach area. Exhibit G, Part 2, shows where it's located on Lake Danoon. It has a 1.18 acre property with 180 feet of open frontage. So much more frontage and much more acreage than ours, and its adjusted price was $867,000. It had a 25% increase in value since 2024. Again, much smaller than ours. My next section is about our comparable neighboring properties. I know these houses are not the same as ours, but as far as the channel values go, they would have the same price point because they have the same limitations in the channel. The first one that I reference is parcel 2180947. It's next door to us. It's a very similar construction and look. It is older than our house. The assessment value decreased 2%. The parcel 2180949 is adjacent to ours. It is very similar construction, vinyl, 2-story. But that one does have, it's closer to the lake, so it's better access, less down the channel like ours. And that assessment value increased 28%. And then I included Exhibit H, which is parcel 2180952. This one is about 3 houses down from ours. It is a very comparable house to ours. It looks very similar to ours. It has the similar square footage. It has 3 bedrooms, 2 baths, but it has very open, full lake frontage. They have full frontage. They're not in our channel, and they have a beach. Their assessment value decreased 1% to $528,300. So that is, again, not in line with ours. These comparables show what channel properties should be valued like, and that they should not be valued like the typical lakefront. And even though lakefront piers declined or were flat, our structure rose 86.7%, a disproportionate increase, particularly given to the inferior channel location compared to the full lake properties. I did pull other comparable recent sales. Again, because it's hard to compare anything to channels, I did two separate kind of polls. And the first one was just comparables due to property square footage, and they're not on the lakefront because there was no matches within the time frames that I could pull. So most of their assessed values are going to be much lower than ours because they're not on the lake even, but the actual property value, the building, should be similar to what ours is at based on the square footage, bedrooms and bathrooms. The first one is just showing that 2,800 square foot bed, 3-bedroom, 2.5 bath, half-acre lot sold for $339, assessed for $361. It had a 23% total increase. Exhibit 1, or I, is South 71 West 19108 Hillview Drive. That's right around the corner from us. They have full view of the lake. They have access to the Hillview Beach. Looks very similar to our house in style and build. And it's a 3-bedroom, 2-bath, sold for $500,000 in October of 24, assessed for $447, a 15% total increase from the prior year. Exhibit J is just a very nice house, nicer than ours in comparison. It's a 2,975 square feet, 3-bedroom, 2.5 bath. It's on some land. It's on Sanctuary Court. Sold for $535, assessed for $456, and it had an 18% total increase. Then the parcel on Walter Hagen was a 2,891 square feet, sold for $540, assessed for $447, a 30% increase. And Kristen Drive is a similar home, less square feet at 2,120, but more bedrooms at 4 bedrooms, 2.5 baths. It sold for $610 this year, and it assessed for $487, a 25% increase. Now I realize that we bought our house in 2021 and we paid $852,000. So that is higher than what all those houses were. So I pulled some comparables versus based on sale price recently, and that's what the next section is. The South 71 West 15147 Rosewood Drive, Exhibit K. That house sold for $819,000, 3-bedroom, 2.5 bath, 2,200 square feet. It had an 18% increase in 2020 from 2024. Only a 13% increase in the assessed value on the house. The W129S8660 Muskego Way parcel is in Exhibit L. It sold for $806. That was a new construction. So the land had an 8% increase, but there was no construction increase, no home value yet. And it's now assessed for $571,500. So that one is a brand new construction with a new assessment, valued in the 800 range, and the building is valued in the 500 range. The Candlewood Lane parcel, Exhibit M, sold for $866,000. It is 3,580 square feet, much over about 1,000 square foot bigger than ours. It is was assessed for $656,000 with a 22% increase. And Exhibit N has a on Cherrywood Drive was sold for $830,000. It assessed for $582,000 with a 26% increase. All of those properties, again, with only one of them being higher than 852. There's only one at the 866, but they're all in the 800 ranges. Those are the only ones I could find in the 800 ranges that sold in the last year. So I couldn't really get to the perfect square footage match, but they all had much less assessed value in 2024 and 2025, and the increase was much less than ours. I would say that since 2021, the demand for higher value homes, it has slowed. We've seen many houses listed over the 1 million that are not selling. I would not list our house for 1 million, but I am in watching all of the houses for sale and noticing that they are not selling on the day that they are listing like they were in 2021 when we bought them. The Exhibit M is the only property on the channel that I could find that was for sale. It's on Jewel Crest. That's still not a comparable channel to ours because that channel actually goes all the way around. Its depth is deeper. It's flooded, but it is still a channel in the narrow aspect of things and in the view, like ours has limited options. That house there is older, and it is 3 bedrooms, 1.5 bath, and it's been listed for sale for over 3 months at $599,000, which is just showing again that demand for houses on the lake has slowed, as well as channel purchases are just not even slower than how fast they can sell on the lake. My home the value should reflect the current market conditions and the channel limitations in the best way we can. The market value of our house has not increased since the purchase in 2021, and it was assessed after our purchase with that purchase price knowing in mind after our purchase, so I don't know why it would have increased so highly. So we are just asking that our assessment reflect the fair market value. The last appraisal we had on our house was in 2023, and it is outdated, but it was for $775,000. We are asking that our house is uniformly compared with properties, particularly properties on the channel, and that they align with the other houses in Muskego more uniformly. I have some additional graphs included on those, just showing the total assessment increase against those other exhibits that we've provided and how much higher ours is showing, and that it doesn't appear to be uniformly aligned with the market and the neighbors. That's all I have.
All right, thank you. From the assessor, any questions to the taxpayer?
Yes, I do. When you're referencing the comparable properties that you're providing here, are you comparing the market value or the sold price to your home to establish a value, or are you comparing it to the assessment and the percentage increase of the assessed value?
Both.
Both? Mm-hmm. So am I to understand that by looking at the uniform or the non-uniform increase, your opinion of value, where does your opinion of value come from? You had the 2023 appraisal for $725,000, and you feel that there has been no market increase over the preceding 4 years in the property?
2 years, yeah.
Well,
this was in 2023, so
no, I understand that. And also, you said that, so the purchase price, you did buy that in September of 2021 for $852,000?
Correct.
And you said that there had been no recent updates to the property?
No substantial updates.
No substantial or no updates?
No substantial.
And what would be considered substantial?
We did complete the basement with drywall and floor.
Okay, so you did take out a permit there to add rec room of approximately 630 square feet to the home in the basement, and approximately 4 extra plumbing fixtures, which I'm assuming would be a full bath downstairs?
Bar sink.
I'm sorry?
A bar sink?
A bar sink?
Yeah.
Okay, we have it as there's 4 additional fixtures that were added from the plans. Was there additional plumbing, a bathroom or something downstairs that was
bar
added?
sink.
Just the bar sink? Okay. And again, you're looking at the percentage increase. You feel that it should be more uniform throughout the community, or just within your area?
Within our area, we mean that I understand the average is 26%. I understand the lake homes would have a higher value, but I don't know that it would be 87%.
Okay. And considering that you purchased the property for $852,000 in 2021, the 2023 appraisal, was there appraisal done that for the purchase price when you originally purchased the property?
There was.
And then 2 years later, you have an appraisal that's showing a decrease in value to the $700,000 or $700,000 range?
Yeah.
And has that been submitted with this information, or is that?
It was submitted for the additional, what's it called, last week? My conversation last week.
The open book?
Yes.
And was there a submission of the full appraisal?
Yes.
Because the information that I'm showing that was turned into the open book, there is a write-up with some comparable sales, but we're not seeing the adjustments that were made between the comparables and the subject property to establish the lower value than the previous purchase price. That's why we have
Sure.
4 or 5 pages of an appraisal, but I don't have
I can find it.
everything.
Yeah, you go. I kept a copy. I don't know that I have that on hand.
Give me just a moment there. You provided a lot of information.
Yes, no
So I just
problem,
wanted to
no
take a
problem.
second to verify. I have no further questions for the property owner.
All right, any questions from the board to the property owners?
I guess I have.
Go for it.
I'm trying. Have you recently tried to sell the home?
No,
It hasn't been on the market since you purchased it?
correct.
Do you recall what the fair market value was on the tax bill you received last year?
It was in the 700s.
High, low?
I don't recall.
Um,
No,
I-
that's not it. That's not on there. Yeah. It's on the property tax bill. I don't have it.
What were the circumstances of the sale that you purchased the home at $850,000 and now you're claiming it's only worth?
The market was crazy. We did know the sellers, and we had some hearsay that they were going to list, and we had lost the last 4 houses that we put offers in. One was on Bass Bay and was a lot more expensive, and we couldn't afford it. But we jumped on this one the day it went live with the asking price of what they were listing, and didn't expect to get it, frankly, as we had been losing every house possible. But because we were the first ones in and we had our pre-approval all in line, we got an accepted offer, and there we are.
And then you still did put more money into it though after that, correct?
We did put a little bit in the basement.
We finished the drywall and put in flooring. I mean, we didn't go crazy and add a room or anything else.
Yeah.
And part of that was the backside, there's a bar. We have access. We put in a sink with a bar.
We have a very specialty house. It's going to be hard for us to sell because
Did you get any, Did you get any appraisals or anything like that at the time you purchased the property?
At the time we purchased, we did. It came in at asking.
I have no further questions.
You list some comparable recent sales, Exhibit I, J, Walter Hagen and Kristen Drive. Do you know when those purchase dates or sale dates were?
Let me see if it's on there. Did you find it? Oh, did I not have those ones in?
I suppose I see in Exhibit I, it says 500,000 in 2024 and 535 in 2025. That's a K though.
Oh, it doesn't
That's
say the month.
Sanctuary.
No.
It says 500,000,
Or J, that's Sanctuary, yep.
that's all we had.
Yeah, no, I just printed those off of Realtor.com and I don't have the exact month.
Yep, I see it now, the 500,000 in 2024 for Hillview.
And then J.
and
535 in
535
2025
for
for-
Sanctuary in 25.
Doesn't have the month, though.
Did you have records, well, there's a price per square foot listed on there.
Correct. Price per square foot was $215 and $180.
And you said neither of these are on a channel? Those are just nearby properties that are not
Correct.
on the channel?
The Hillview one is not on a channel, but like I said, it just has beautiful lake views and access to the big Hillview Beach, which is a private
Sure.
subdivision beach there.
Perfect. Any other questions from the board? All right, then we'll move to testimony and evidence from the assessor.
Thank you. Nick is going to pass out Exhibit A, the property record card, two-sided, containing the assessment information for the subject property, and the assessor's Exhibit B, which is the comparable sales sheet used to value the home.
Sorry about that.
Thank you.
I will begin by pointing out that the subject property sits on .32 acres of ground, and it is assessed as a channel lot. It is not assessed as a lakefront lottage. The subject property was purchased in September of 2021 for $852,000. We have that listed as a valid open market sale. The subject is a two-story contemporary built in 2015. We have it currently listed as average condition on the kitchen and bath. We have no basement. It is centrally heated and air conditioned. The physical condition is average. The grade of the home is a B, and the CDU is listed as very good. The home consists of 5 rooms, 3 bedrooms, 2 full baths, 7 additional plumbing fixtures, and we are showing that there is a rec room of approximately 3,150 square feet. Oh, I'm sorry.
Is too big. Yeah.
Oh, I'm sorry, that is the value. The rec room is the 630 that we had mentioned previously. I apologize. The above grade, the total living area of the home is 2,807 square feet. That does not include the rec room area. Moving to Assessor's Exhibit B, comparable 1 is 166 South 8362 Kurtz Lane. The property rests on .31 acres of ground. It is a two-story contemporary home built in 1995, containing 9 rooms, 4 bedrooms, 4 full baths, no half baths, 2 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned. It is a B+ grade in very good condition. The above grade square footage is 2,424 square feet. There's 680 square feet of finished basement, bringing the home to a total finished area of 3,104 square feet. The kitchen and bath rating is listed as very good. That property sold for $1,300,000 in July of 2024, approximately $418.81 per square foot, with an adjusted sales price of $1,091,500. Comparable number 2 is 75 West 18642 Kingston Drive. The property sits on 0.21 acres of ground, is a 2-story contemporary home built in 2000 with 6 total rooms, 2 bedrooms, 3 full baths, 1 half bath, 5 additional plumbing fixtures. It does have a full basement. It is centrally heated and air conditioned. It is a B-grade home in very good condition. The above grade area is 2,057 square feet. There's approximately 552 square feet of finish in the basement area. The total square feet of living area is listed as 2,609 square feet. Kitchen and bath ratings are listed as average, and that property sold for $1,250,000 in July of 2024, approximately $479.11 per square foot, and with an adjusted sales price of $1,009,900. Comparable number 3 is 166 South 8348 Kurtz Lane. This property consists of 0.28 acres of ground, is a 2-story colonial built in 2003 with 7 total rooms, 3 bedrooms, 4 full baths, no half baths, 4 additional plumbing fixtures. It has a full basement. It has centrally heated and air conditioned. It is listed as an A- grade in very good condition. The above grade area is 3,112 square feet. The finished basement is listed as 1,000 square feet, bringing it to a total finished area of 4,112 square feet. Kitchen and bath ratings are listed as average, and that property sold for $1,100,000 in June of 2024, approximately $267.51 per square foot, with an adjusted sales price of $818,500. Comparable number 4 is 76 West 18160 Janesville Court. Property consists of 0.41 acres of ground. It is a 2-story contemporary home built in 1984, containing 6 rooms, 3 bedrooms, 2 full baths, 1 half bath, 3 additional plumbing fixtures. It does have a full basement. It is air conditioned, centrally heated and air conditioned. It is an A- grade in very good condition. The above grade area is 2,818 square feet with no finish in the basement for a total of 2,818 square feet. The kitchen and bath rating is listed as average. That property sold for $1,180,000 in June of 2023, approximately $418.74 per square foot, with an adjusted sales price of $999,000. Comparable number 5 is 208 South 10650 Karen Court. Property contains 1.18 acres of ground, is a modern 1.5 story, built in 1988 with 8 total rooms, 3 bedrooms, 3 full baths, 1 half bath, 3 additional plumbing fixtures. It is a full basement, is centrally heated and air conditioned. It is a B grade in good condition. The above grade area is 2,936 square feet. It does contain 800 square feet of finished living area in the basement, bringing the grand total to 3,736 square feet. We have a kitchen rating as good, and we have a bath rating of average, and that property sold for $1,135,000 in May of 2024 for approximately $303.80 per square foot, with an adjusted sales price of $867,700. I would point out that the percentage increase, when there is a market update or a revaluation, the percentage increase is not uniform throughout. We do not just raise the assessed values 25%, 30% across the board. Pockets of the community can sell. Some neighborhoods may take a larger increase. Some styles of home may take a larger increase, ranches versus contemporary versus split levels. So the comparison of the percentage increase on properties is not related to market value necessarily on the assessment side. We provided 5 comparables, and that completes our assessment evidence from the assessor.
Thank you. You can ask the assessor questions.
I would ask just, so even though there's not a uniformity on the 87% increase, what really, I mean, like I said, that these other homes are going to sell for more based on being on the lake. I would think that there'd be other lake homes that would have another increase like ours, and we're not matching that.
There are other lake homes that did increase similarly to yours. The adjustments for that, the way that I look at it, to explain it briefly, the adjustments for lakefront versus channel, we assess them using different rates based on the frontage of the lakefront or the channel frontage. So there are different adjustments. The similar home, if your home was on a lakefront lot, it would assess for more, it would be worth more because the land would be more valuable and would be assessed higher. So the comparison of the lakefront homes, whenever we do our sales comparison, we assume that the land value is correct, and that's negated from the sales prices, so that we're looking at the improvement prices of the, or adjustments on the improvements themselves. So that way, your home would be worth so much money, but on a lakefront lot, it would be worth more, if that makes sense with the adjustment through the land value.
That's right here.
It does, but
I'm gonna ask. I'm gonna ask about this too. The increase still just doesn't make sense. It doesn't just justify why there was such a big increase.
The increase is from the model that was calibrated using the comparable sales for that area. So that's, the houses that we're comparing you to did increase the assessed value, but none of that is based on the lakefront lot versus your channel lot front.
So then why would our cost per square foot be so much higher? That's all just based on the formulas?
But it's based on the model, but it's also based on the comparison. So the homes that we had, they are adjusted to be similar to your property, the subject. And through the model, it applies the increase in the value. So they are similar grades. There's some were A grades. Yours was a B grade, I believe. Similar sizes, similar amenities, but they are all adjusted based on the sales are adjusted to make them similar to your home. And the land value is negated from that equation because we're using a 1-to-1 land value. So the sales that you were compared to in the last reappraisal or the last revaluation in 2021 may be different from the current sales that we're using because different homes had sold at different times. So, but those are the comparables that we're using to value the property.
And how can you explain the 2,807 square feet and how what is the deck and you're calling the rec room the basement? But the deck versus the open porch, what those would be consisting of?
So if you're on the comparable sales sheet and below the kitchen and bath ratings, the rec room, open porch, closed porch, deck area, those are also, those properties do contain those amenities, but those are things
for
that
ours.
are adjusted
I mean,
on
for
value
ours.
Yes.
So what is what is the difference between a deck area and an open porch?
An open porch is a covered area. It can be a covered wood deck for an open frame porch. An open masonry porch is going to have a concrete base with some type of a roof area or canopy over that. Wood deck is just going to be a straight wood deck, railing and wooden base extending from the home.
Okay, it's only 27 feet, but we don't have anything like that.
You don't have any type of a porch in the home?
We have just a deck, but nothing with a roof over it. And no porch.
At 27 square feet, is there a covered opening on to one of the entrances from the outside of the home?
There's an awning over a door that's about 2 feet.
Okay, that may be what we're referencing there. It is 27 square feet, so it's not a large porch or wraparound porch.
It would be
but it would be-
literally just the doorway.
Is there something, steps or stoop below that?
The one step in the doorway.
Okay, I'm just showing that we have a 27 square foot open frame porch, or open porch.
I just want to make sure and that's minuscule, so I don't care, but that we're not double dipping on that basement because our house is 2,200 square feet.
We have the above ground area as 2,807 square feet.
And I don't know what makes that up. Our first floor is 1,302 and our second floor is 922.
Are those interior dimensions or exterior dimensions?
That was from the blueprints.
From the blueprints? Okay. In the assessing world, we measure from outside because our cost tables take into consideration the wall, the exterior, the interior, the wiring, the plumbing, things of that nature. So we may not match exactly what your blueprints are if those are interior dimensions because we are going from outside corner to outside corner.
Okay.
Now,
At
if
600
it's
square feet?
If it's 600 square feet, we have 2,807. Normally what we do is we pull the information from the plans, but that's the information that we have as of the valuation. There was no request to come out to review the square footage through the open book.
Mm-hmm. Yeah, it's hard to be able to reflect any of these comparisons and not see what the values are behind them to figure out if that's actually accurately compared. But that is the world we live in, I understand. I don't think I have any further questions.
Okay.
Good. Any questions from the board to the assessor? Laura?
I have a bunch of questions for you.
Yes.
I'm looking at Exhibit A.
Yes.
The record card.
Mm-hmm.
And I noticed in the value flag on the other ones that we looked at today, they all said market approach.
Yes.
And I noticed this one says override. Can you tell me what that means?
Yes, so at the open book, there was a determination that there had been an old frame garage that was on the property that was no longer there. Whenever we went to remove the value of the garage, it did not reduce in value. The garage was assessed, I believe it was at $3,500. So it was. It was a small adjustment for a $3,500 improvement that the computer is still calculating, which we're trying to figure out how to remove that. We overrode the value and just took the previous value minus the $3,500 improvement that's no longer there. That's why this one is on the override value.
Okay, so it's basically the same as the market approach you just took off the garage.
Yes, it's the market approach value, but minus $3,500 for the garage.
On the same card, under property notes, 123, it looks like basement remodel. 122, it says PU basement. And then if you look under permanent information, 13 of 22, basement remodel. But then if I flip it over to the back, I show you saying no basement, and you're subtracting money for no basement. Is that right?
It is saying that there is no basement. That is just, and I had noticed that as well too. They are being assessed for the 30, I'm sorry, it says the 3150.
It's in the rec room instead, right?
That's the dollar amount.
$5 a square foot for the rec room finish.
Yeah, they put it on the rec room, but so I don't know if that gets the same value or not. As a basement footage.
The rec room is priced out at $3,150. But yes, there is a flag in the system for no basement, full basement, partial basement, that does not control. Everything is based off of the sketch. So the basement is being priced, but that it is not.
That 122 no is when their sale was reviewed in 2021. There was a full bath in the basement that we did not have on the record. That was added as additional fixtures to the basement. So pick up basement full bath for MLS listing. That's what that means.
I guess I don't understand why the dwelling computations on the back is subtracting 32,470 for not, it looks like it's for not having a basement when there actually is a basement.
Oh, okay. So technically, we do not have that data entered correctly then.
Yeah, that's incorrect.
Okay, no, that is incorrect data. They are not being priced for, they are being priced for the rec room, but the basement is not being picked up. That is correct.
And then when I look at Exhibit B on the comparables, I note that again, we see under basement, it says none, and all of the comparables have a full basement. So how is that factored into this comparables on Exhibit B?
It would actually be adjusting the the comparable sales prices down for a lack of basement.
So the other comparisons, the other five are being adjusted down so that they're compared as if they have no basement?
They are being adjusted down because they're considered to be superior because they have the basement. The subject is not listed with the basement, and so therefore it would adjust the comparable sales down in value to remove the value of the basement. That is correct.
I'm also noticing that 4 of these 5 comparisons are some of the same ones that we've looked at earlier today, and the cost approach appears to have been used for some of those. Is there a reason why you were not using the cost approach for this one?
The cost approach was not used on anything that we had used yet today, I don't believe.
These other 4 comparisons, their assessed value for 2025 appears to be much more in line with the cost approach numbers that are listed on this sheet.
They are still using the market approach. The market approach is coming in closer to their cost approach.
I see.
But they are still using the market approach, even though the assessments are, of the ones that we have discussed where the assessed value is lower than their sales price, they are still using the market approach.
And based on what you now know about the basement and the way the basement was not calculated properly in this, do you believe that the value that you have is still accurate?
Actually, depending that the basement is not there, I would feel that the assessed value would actually be increased with the addition of the basement.
Would you remove the rec room then?
I'm sorry?
All right, any further questions from the board to the assessor? Yes.
Maybe it's the lawyer in me that's talking, but you're basically telling me now that the assessment that you've arrived at is actually lower than it should be?
The house would assess higher with the basement addition, or the additional basement that is not currently being calculated into the value, yes.
So the assessment's not correct?
The assessment would be low.
All right.
Thank you. Do you have any further testimony or evidence to present?
No, but I have a question. If you're adding basement, would you be removing that as a rec room?
No, it is, we've added the rec room because the rec room is pricing, but you're not being charged for the value of the basement itself. So it would be the additional value of the unfinished basement, not a finished basement.
Do you understand that?
I think.
The rec room is 630.
But
Where's the basement?
it's not in there. They manually. All right, no further questions.
All right, no further testimony or evidence you'd like to present. Any questions at all to the taxpayers?
No more, thank you.
Any further questions from us on the board? My question is that you spoke of an appraisal at $775,000 from 2 years ago, but I don't see that presented to us.
I sent it in the open book and I thought it was disregarded because it was too old.
Okay. When you say appraisal, tell me, was that an actual appraisal by an appraiser?
Yes.
Okay. And what was the purpose of the appraisal 2 years ago?
For finances.
For financing for, yeah. Gotcha. Okay. Thank you. Anything further from the assessors?
No, evidence-wise, or?
In terms of testimony or evidence, yes.
Testimony or evidence, no, we have nothing further at this time.
Okay. Any questions to the assessor from taxpayer for the board? Okay. You can then summarize your testimony and evidence that you have presented.
In summary, I still feel that the increase was increased higher than the value of the home based on the comparables not reflecting comparably to the subject property. That's all.
Okay. Thank you. From the assessor, a summary?
I feel that even though we've discovered the issue with the basement, I would point out that the home was purchased for $852 after the last market update was occurred, and it would actually be a 19% increase from the previous sales price in 2021, as opposed to the current 68%.
Okay. Thank you. And then we will deliberate. What thoughts or questions do we have right now?
Well,
And real quick, I'll close the testimony. All right, do that.
I feel like this is a struggle because I feel like the assessor has admitted that the assessment is incorrect. And I feel like the taxpayer has therefore met their burden to show, to rebut the presumption that his number is right. But I'm also struggling with the fact that I think the amount that's presented by the property owner is not a reasonable amount. And so I feel like we're kind of stuck right now. And to a certain extent, if you look at the appraisal that they had done in 2023, and you take their own testimony that the property values have increased to 26% on average in Muskego, we're getting really close to the assessment value that the assessor has put forth anyway. So what I don't know is, can we find that the taxpayer has met their burden but still go with the assessor's value? Can we do that?
You basically, if you're going to say that they met their burden, now the burden shifts, like we talked about earlier, you're only working with two numbers. And so it's your discretion, but we can't make up a number. I know you're saying that you
I
think.
know there's only two numbers, but
Right.
can we say they met their burden and still go with the assessor's number?
Why?
Is that even a possibility? That's what my question is.
If they met their burden, and that's their number, then that's the number, but you have your discretion to do what you want, but you have to back it up as to why you're doing. So how would you really back that up? They met their burden. I guess you're saying they met their burden to show it's incorrect.
But not their
But you
burden to
can't-
show it's reasonable what they're asking for.
But that's what you can't do. That's the struggle. That's what you can't do.
But I'll argue with you on that. There's been evidence presented by the resident indicating that they have an appraisal for $775,000.
Right, a year ago, and the increase is 26%.
2 years ago.
Well, in August of '23, and it was supposed to be going by January of
True.
'25.
There you go. Thank you.
That appraisal is not in evidence. That's what they're telling you. Unless they
I mean, their
said that.
testimony is in evidence.
Right, no, right. I'm just saying that you don't have a document to look at that unless the assessor has it because they sent it to open book, but I don't know.
We have a copy of the information of the appraisal, but I don't believe it's the complete appraisal.
Okay, that's what you were saying earlier.
Yes.
Yeah.
I guess I should have asked the assessor what the fair market value was in 2024 on the tax roll, because that would have solved the problem, but I guess evidence is closed.
The taxpayer did say it was in the high 700s on the fair market value.
Okay.
Our testimony is closed, but as the decision maker up here, you have the right to ask another question if that's what you want.
We can confirm the previous assessed value if that's what you're asking.
The fair market value on the tax assessment from 2024.
The tax assessment.
The assessment is 604, according to the documents that we
We're
have.
looking at
Yes,
fair market
640.
value.
But I'm looking what the fair market value was at that time.
That would have shown up on the tax bill.
Yeah.
We can look up the tax bill if we like, or I can do a quick calculation.
If you can look up the tax bill quickly, I would just look up the tax bill.
Well, I can tell you, I've looked at the tax bill.
You what?
I've looked at the tax
Oh.
bill.
Here we go. We have it here.
That's not in
That's
that's not in
not in
evidence.
testimony.
That's
Right.
the thing.
The estimated fair market value from 2024 tax bill is $797,800.
Even though it's not in evidence, you can take notice of that because that's an official document.
Right.
The record. So I know it's not in evidence, but judges do this all the time. You can take, we call it judicial notice, that's not what you're calling it here, but that's what you can do.
But if you increase that by 26%, which is what the taxpayer is even saying is the average in Muskego, we get really close to the number the assessor has. And that's my struggle.
I don't know though, because the assessed value in 2024, the average assessment ratio is at 75%. So anyone listed at 800,000 for the fair market value was assessed on average 25% lower. Yep. So you.
Right, but if we're saying fair market values increased by 26%, has nothing to do with the assessment.
Yeah, I don't think we're saying that. I think we're saying the assessments have, and that's, I got the blue notice. I took my blue notice from Mayor Rick here, that the assessments on average went up by 26%.
But I'm talking about the taxpayer's document where they say, by comparison, the city of Muskego's average property increase was approximately 20%, 26%. So I guess I took that to mean that they're saying the fair market value on average in Muskego was 26%. That's where I got that number from.
Yeah, I'm going to believe she meant the assessed value went up because that's directly from the letter sent out by the city that the assessed values went up by 26%.
It was unassessed value.
Yep.
That's a clarifying question you could also ask them.
We're still here.
Yep.
Can't ask.
Good.
Ask him what they meant.
What, the taxpayer?
With the 26%, what did you mean by that?
Yes, on the assessed value.
The assessed value in 1
Okay.
year. Yep. What other thoughts do we have right now? It's tough for me, I'll tell you that, because we have a sale price from 3 years before the valuation date. That's $852. I think in general, the market prices have gone up since then, so it's tough to say that it's actually gone down. Also, it feels as if their main evidence is around the increase in assessments and not necessarily around comparable market prices. There were some comparable markets presented, or market prices presented, but the assessor also presented comparable markets, and I see all the adjustments down. Each one of these comparables was adjusted down by $200,000, $250,000, $300,000, and they have noted that that the subject property is classified as channel and not lake, so that has been accounted for according to the assessor. So I'm torn. I've got both thoughts as well. Thoughts or questions? Cindy?
Well, I agree with Myra that.
You may want to.
Oh, it's on. I agree that it's hard because if you're looking at what it was assessed at in 2024, it was in the 700s, and then you add 26%, we're getting up over 900.
But the assessment was only 600 in 2024. It was the fair market value that was 797.
Mm-hmm.
They lived with the fair market value at 797 until.
Okay.
Now it's bumped up to over $1 million.
At least until this year, I guess you'd say.
Right.
Okay.
And that's in the record.
Right.
But still gets.
Yeah. What I'm going to say is that we do need to have that the presumption of correctness is on the assessor. Also, that I personally wish I had seen the full appraisal to see what was that's what the assessor had also mentioned too. It would have been helpful to see the comparable properties, where I see the 5 properties here, where it shows the adjustments and the reasons. That's helpful to make a determination of the value. So that's my thought around for any taxpayer at any point in time.
I just have to say that I would have a very hard time casting a vote in favor of the assessor when the assessor has admitted on the record that the assessment is incorrect. I feel that it's pretty clear that the taxpayer has met the burden under the circumstances.
Okay.
And I'm going to throw this out too, and probably ask counsel. There's evidence, and it's undisputed, they paid $852,000 for this property a number of years ago. We can argue whether it should have gone up or it goes down. That number is out there. I would think a motion could be made that it be assessed at that value.
I don't know if the attorney would like us to do
Again,
that.
we're back to the value that
Yeah, they
they're
presented
saying versus the
775.
value. You guys cannot come up with your own value.
Can they change
And are we coming up with our own value?
You are if you're going to use a number that is in evidence, but not their evidence.
That they're not asking.
Yeah, their presentation, their evidence is a number. You can't, no matter what happens here, you cannot come up with your own
What I'm
value. You can
seeing-
use their value or you can use the assessor's value.
What I'm seeing on number 2 in our forms of yay or nay in a way is that mark all that apply below. I think the answer to Mara's first question is I would read this, that we could say that the assessor's valuation is correct, that the property owner has presented sufficient evidence to rebut the presumption, but we don't necessarily have to check the box that their valuation is reasonable. Although, if we're going to go with their valuation, which it's one or the other, we have to say that it's reasonable. So we don't have to check number 3, but it feels like we have to check number 3 if we are going that way.
So we said, I understand that the assessor is saying if he had corrected the basement and added, his assessment would actually be higher.
Right.
We don't have that number
But we
either.
don't
Yeah,
have that
I get
number
that,
either.
but that's not
But that's what
in
you're
evidence.
referring to, that he made it the statement that the assessment was incorrect. It's actually incorrect in the favor of the property tax.
You said we could ask some clarifying questions. You mentioned your first floor is 1,300 square feet, your second floor is 900 square feet,
Yep,
and then you have a basement below your first floor.
yeah.
And how many square feet is that?
Around the 630.
Around 630. And is that a below-grade basement, or is it above grade?
Below.
I mean, is it,
It's
I think it's
below
awesome,
grade, but there's stairs to get outside.
So it's low grade.
does it open out? Is there like a sliding glass door?
No, it's just a door with a
Stairway,
concrete
just
piece
a,
of
yeah.
force
Gotcha.
to get up.
And the assessment has the above-grade area listed as 2,800, and it appears to be 2,200 above grade.
Try not to get caught up in whether the assessment
yep.
would have been higher or lower.
Right on.
He did make a statement that it has come out here that the assessment is incorrect, but the presumption is correct that their number is, you have to go by the law, and that presumption says that their number is correct. But now testimony came out that it would have been different. But don't get caught up on what that number would be, because that's irrelevant.
Yep.
But that's the second part of our findings.
Yeah, because the second part of our findings is we do write down what the assessed value is, which is either one number or the other.
Right. That's where you're stuck in this
Only
one.
if we go with number 2, if we go with number 1, we don't.
Right. Yep. Good.
This is kind of a unique case that hasn't happened before to you
Yes.
guys.
Yep.
But under these circumstances, I'm inclined to go for the homeowner.
But they're gonna get the same assessment.
We don't, I don't have another number. We had one or the other.
Yep.
If I feel like I'm saying they meet their burden, so what's the choice? I feel like it's stuck with that.
And it's kind of too late in the process, but had they agreed to a number that would be different at open book, then
Right.
you wouldn't be here.
Right on. Okay, I think we're going to do our findings of fact, determination, and decision. Carrie looks to be taking notes over there.
Are you taking?
We're writing down on the
He's
findings of
taking
fact. All right, good. I thought so. Okay, good. We have the property identification, the owner identification. Timely notice was filed. We do have sworn testimony by the property owner. There was no recent sale. That sale was too long ago to say it's recent. There were recent sales of comparable properties. They presented quite a few. We have to write down the number of it. 1, 2, 3.
Jeremy, since I have those records, I think we can review that.
Yep,
Right, Jeff?
it seems to me that there's 5 comparable recent sales, number 5. There are 5 of those.
And if you've got them in evidence, you can put those down.
You got them in evidence,
You don't
number
have to
5.
put it down
Yep.
right now.
Right.
But she's got them.
Yep,
So I would
other
just move on.
factors
Yeah.
presented, I'm going to say yes, related to the channel versus lake, and also the testimony of the appraisal. There's no sworn testimony by witnesses. The assessor did estimate, or says the estimated level of assessment for the current year is 100%. There was no recent sale of the property. They presented 5 recent sales. Other factors presented by the assessor, I don't believe so. I think they were just included within the comparable sales. The board does not find that there's a recent sale of the subject property. Did the, all right, this is only if we have comparable properties. Oh, yeah, yes, there were comparable properties. The property owner presented testimony of recent sales of comparable properties, yes.
They both did, right?
They both did, yes. So yes to assessor and property. Did the attributes satisfactorily adjusted for the differences from their subject and their contribution to value? I'm going to say no for the assessor and yes to the property owner, because I think we're heading towards a motion of number 2. And I can do a new sheet if we need to do otherwise, but the board of review finds the assessment should be based on other factors, yes, related to the channel and the appraisal testimony. And the most credible evidence presented is related to the accuracy of the, what would that be called, the property record card. And then I'll entertain a motion related to the decision of number 1 or 2 here. Or I can move, right?
You
So
can
it's your
move.
turn?
You
All right.
can move as the chair.
I move that exercising its judgment and discretion pursuant to Wisconsin Statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is incorrect, that the property owner has presented sufficient evidence to rebut the presumption of correctness granted by law to the assessor, and that the property owner's valuation is reasonable in light of relevant evidence, with the total value presented at $775,000. Land part at $263,100, and improvements at the difference should be $511,900, but we'll find out. $511,900 for improvements. All right.
I'll second the motion.
All right, so Mara seconds, and
roll call.
We'll do a roll call vote from Carrie.
Gary Boycitz,
Yes.
Jeremy Kyle,
Yes.
Henry Posbrig,
Yes.
Cindy Schmier,
Yes.
Mara Spring.
Yes.
All right, the motion carries. All right, the hearing is closed, and do we recess till tomorrow?
Are we doing a 5 o'clock?
Ah, 5 o'clock. That's it. Oh, we're late for the 5 o'clock. I thought yes, thank you. I'm the one leaving.
Okay, so the schedule is that we were supposed
Thank you,
to
and
have
sorry.
our dinner break at 4:15, and our next one is at 5 o'clock.
So no dinner break.
Well, I think you need to take a dinner break. That's my opinion.
You're leaving.
I'm leaving, so you don't have to listen to me.
So,
Thank you. Thank you. You're all set. Yep.
Thank you.
If you wanted to take a 10-minute break or something, you
I
can.
mean, yeah, we're delayed, right?
Oh, yeah, you are delayed, right?
So we're not doing a recess, or we're just,
I'd not do you could just go off record for,
well, do we have to do anything with him leaving, or I'm gonna note on the agenda he left, and then she's gonna take over?
takes over, right?
So we're gonna, then, what we're gonna do is then we're just gonna go off the record for a few minutes for a break.
Right. I would just take a break so people can go to the bathroom.
Okay, we've confirmed that the recording is on, and we have several proceedings tonight, all involving the same individuals. So we're only going to give you the brief overview of what to expect once, but then we'll go through each case separate. So what you'll expect to happen here is that you will have an opportunity to present evidence to the board as to why you believe that the assessment is incorrect. So you'll present whatever you have. The assessor will have a chance to ask you questions about that. The board will ask you questions about that. Then the assessor will present their evidence. You will have an opportunity to ask the assessor questions, and so will the board. We'll have another opportunity for you to present anything further, and the assessor the same thing. And then if you want to give like a summary at the end, then we'll close evidence, and the board will discuss, and the board will come to its decision. And that'll happen for each of the cases that we have tonight. So do you want to just
Introduce the first case?
jump right in?
Okay, so I'm going to introduce the first case. This is the case of Kathy L. Lemaster Revocable Trust, Jennifer Lemaster as agent. The property owner resides at South 76, West 18004 Janesville Road. The address for the property in question is South 76, West 18026-40-58 Janesville Road. The tax key for this property is MSKC 2195.999. The property has been classified as residential. The value in the assessment roll for the current year is land at $493,100. The improvements are at 0, and the total is $493,100.
All right, so before we get started, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct, unless you, by testimony, can show that the assessor's valuation is incorrect. In other words, the burden of proof is on you as a taxpayer. Do you understand that? All right, so before we get started with testimony, I need your full name and address.
Oh, I'll swear them in, and then we can skip
Oh,
that.
I'm sorry.
Nope, that's okay. I'll swear them in, and then you don't have to do that part. Okay. Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in this matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who is just sworn please state your name and address for the record?
You can put your hands down. Can you hear her?
No.
Yeah.
So are there any witnesses for the property owner who was just sworn in?
Are you going to call any witnesses, anybody else, or?
No.
Okay.
Okay. And assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for 2025 is presumed to be 100%.
And Kathy, you gave us your name and address. Jennifer, what's your address? All right, so.
Is that mic on?
Is your microphone on?
Yours you may have to pull it close.
Is there a green light on?
No, it's not.
It's not.
Hello.
Is it on now? I think so.
Okay.
Seems better.
Seems better.
All right. So for the record, for the taxpayer, what do you believe is the value, the appropriate value for your property?
Can you tell us what was submitted?
Oh, you don't have the objection?
The objection?
I don't have them in front of me.
Your objection says 350,000 for this property, I believe.
Can you repeat that? I didn't hear.
For the first hearing that we have listed, number 10, it's 350,000 is listed on your objection. Is that still what you're claiming it is?
Yes. I don't have it open up.
All right, so are you ready to tell us? Go ahead, it's your turn to present evidence.
Yeah. So the subject property is a vacant lot with tree constraints and requires prep work for any development on it. It also additionally has no frontage on it. So the city provided no direct comparables, and we only have the land methodology to work off of. And we additionally have no comparables as well within the city of Muskego. So the parcel, as stated, has tree barriers, unlike other marketable comps in the area. And the assessment is just not supported in our opinion.
And you don't have any exhibits or anything that you want to submit?
No, ma'am.
So is that all that you wanted to say? Did you want to have anyone else make any statements?
No.
Okay. So for the assessor, do you have questions for the taxpayer?
I do. You mentioned that there were some restrictions on the land?
Yeah, well, there's tree barriers that are on the frontage that is not part of the property. And again, it's just an undeveloped piece of lot that would, if sold, would require development work.
But there are no setbacks or restrictions technically legally making it unbuildable?
Well, the only
knowledge.
physical. Yeah, only knowledgeable thing I have, and I don't have evidence toward it, is previously, the previous owners were going to develop it with multiple, or parcel it out in multiple lots, and the city denied it having multiple driveways. So that was the only other type of restriction that I knew about. So if it was going to be parceled into different lots, there was going to have to be one shared driveway. Which in my opinion would affect, obviously, the market value.
Okay, thank you.
Mm-hmm.
And I see that originally the property was purchased, it was purchased from Muskego Beach Resort LLC in 2017.
Correct.
For $300,000.
Mm-hmm.
And then I see a series, Howard Lee Properties LLC. Are you related to that business in some way, shape, or form?
We are, yes.
Okay. And then it went to the name of Kathy LeMaster and then Kathy L. LeMaster.
Yep, correct.
Okay. I have no further questions.
Questions from the board to the taxpayer? You said that if it was going to be developed into multiple lots, it could only have one driveway. Are you aware of any restrictions on just building something there?
I'm not.
Okay.
And again, that was just disclosed in the sale from the previous owner to the current owner.
Did you go to the open book to talk to the assessor?
I did, we did.
Okay. All right, anybody else have questions?
I guess I'm going to have one. Just you've indicated you believe the value of the property to be $350,000, but you purchased it for $337,500. How did you arrive at the $350,000?
Obviously, there's some increase in value over time, but there's been no development on the property. There's been nothing else. So it's hard without having any comps within the city, but based on outside of the city, fair market value would get us to that number.
Was it a random calculation, or did you use a percentage or anything like that?
I'm a commercial property manager, so I'm in real estate, so I have an idea of markets and stuff. So, but there's no true comp within Muskego to provide.
So there were no real actual computations to this number. It was just your experience.
Correct.
This property's worth around $350,000.
Yes. Correct.
All right. The assessor, can you present your evidence?
Yes, Nick is passing out the Assessor's Exhibit A. It's the only exhibit that we have, is the property record card for the subject property.
Yeah. That's this.
The house is on it.
Yeah.
They know that.
We can make that clear.
The subject property is currently assessed. We have it broken into two types of land. We do have a primary side of 16,516 square feet, which is assessed at 128,800. The primary side is considered the buildable portion of the property. We have the residual at 46,700 square feet, which is currently assessed at 364,300. As has been stated, it is a unique lot. It is a lake view. It is adjacent to the lake, but there is no lake frontage. There is a small sliver from the connecting property that does cut off the subject property from the lake frontage. The comparable sales that when we analyzed it, we took a look at. There's not anything similar that we have through comparable sales, but I will explain the increase that we had for the land values. Through the market update, whenever we analyzed our vacant land, there were insufficient sales to adjust individual neighborhoods, but we did see a trend that our assessments were approximately 30% below market value in the majority of the neighborhoods that we had vacant land sales. So we did adjust the land rates by 30%, just taking the general assumption that since the assessments throughout different neighborhoods had been 30% below, that we did make adjustments to the land in that fashion. But again, we don't have comparables for this individual property itself. Also, it took a 47% increase. There were some influences that were removed from the property that were pertaining to restrictions that we could not find any legal restrictions on the property itself, which is why I questioned the restrictions on the property that she was referring to. With the increase in the land rate, that is standard across the city, and that is how we arrived at the current value. The property does contain 1.45 acres.
Does that complete your testimony?
That's everything that I have, yes.
Okay, and so for the property owner, do you have questions for the assessor?
The only question that I had that came up was, you mentioned Lakeview, and is it noted or impacted that that's impaired by those trees? That's the constraint I'm referring to?
So the lake view would just be adjacent to the lake with no direct lake frontage. So there would be.
It's owned by somebody else and they don't.
So the trees are on that frontage that are not controlled by us?
Trees, big
I understand. Yes, I understand.
Okay.
But basically, it doesn't have direct lake frontage itself, so there's no direct access. That is taken into consideration why it's not considered a lakefront lot.
But you can't fix the view because the owner won't let us touch.
Well, and it's just kind of the process that we go through. We call it the lake view, even though the view may be distorted by the trees. It is adjacent to the lake. There is somewhat of a view of the lake, but it is close to the water, but without the actual lake frontage.
So I guess how is that considered in the increase when you stated that there was a general assumption applied of 30%?
Because the vacant land sales that we analyzed were approximately 30% below, the assessments were 30% below the valid vacant land sales that we had citywide. So the general assumption was that across the city, our land values were 30% below value, and we increased neighborhood land rates by 30%. If we had more vacant land sales within this subject neighborhood, we could have increased it more or less, depending on if we had a sufficient number of sales that had occurred.
Okay. Also, how is the Lakeview?
Wait, this is your chance to ask questions for the assessor.
Yeah, I'm asking.
Okay, good.
Yep. So can you explain how the Lakeview is, right, that it's impaired, it does impact the value? I don't understand that.
So if it's physically obstructed, it could impact the value. What we were looking at for the influences that were removed, and so it's not assessed as a lakefront lot. It is considered Lakeview because it is close, it has no water frontage. The additional influences were due to restrictions that we could not validate if there was restrictions from the city for zoning or setbacks and things of that nature. That's why the additional increase, because we did remove the previous influences that were on the land. So the property value could be impacted by the view, depending on the amount of tree coverage, how tall they are, and what that would cut off from the view of the lake.
I can't control it.
Yeah, so the value of the property was assessed with the lake view. So I guess I'm still not understanding how the impairment is being considered in your assessment value,
Somebody else owns.
or if it's not being considered.
Yes, we're simply calling it a lake view just because of the location to the water. Not because it has an expanded view or a minimized view. It's just the different breakout that we have because we have different rates for actual lake frontage lots and then the lake views that are close in proximity to the
So you have a value for the lake view properties. That
Yes.
is different. It adds, right? It increases the value.
No,
for
it
lake
actually,
view.
well, depending on the comparison, if it's lower than lake frontage lots, so those are a higher assessed value per square foot or per acre. The lake view
Right.
is a reduction in value, yes,
A lake view is a reduction in value to
from when
mark.
compared to a lakefront lot.
Correct. So I guess I'm still not understanding if the lake view is impaired, how that's being considered in your evaluation.
The adjustments that we had were for what appeared to be legal setbacks or legal restrictions on the property, which we could not validate, so we did remove those at that point in time. There was no on-site inspection to take a look at the physical barrier of the trees.
So it's
that
not
were blocking
considered,
view.
correct?
At this point, no.
Okay, great. That's what I wanted to make clear. Okay, thank you.
Any other questions?
I think that's it.
Questions from board members?
I guess I have the same question that I had for that young lady, is she's arriving at a price that she basically said she didn't use any percentages or anything other than her experience to say, yeah, the natural climb of the value of the property went to the number they're asking for. I'm having problems now because, we've been through these all day now. We've seen comparables, we've seen all this. Where are you getting your number?
The land rate or, so.
Well, where are you getting the 493.1?
The 493 is the primary site square footage assessed at a certain rate, and then the residual is the remainder of the lot that's assessed at a different rate. Those rates existed previously from the 2021 market update, but when we analyzed the vacant land sales throughout the city, we saw that on a majority of those sales were coming in 30% low. So we had insufficient sales within several neighborhoods, but in the conglomerate, our assessments were presumed to be 30% low. So we did increase land rates accordingly, looking at the city as a total as opposed to individual neighborhoods.
Okay, so what I'm to understand from you, you said you had earlier rates for these types of properties.
Yes.
But you saw a trend in the city that caused you to increase?
Yes,
the rates?
so we started on the current land rates before 2025. So those were the rates that had been established at the last market revaluation in 21. Those assessments, when we looked at the valid vacant land sales that had occurred, our assessments were approximately 30% below the estimated, or not the estimated, but the sales price for those properties. We would make adjustments individually by neighborhood if there were sufficient land sales. So in a neighborhood of 200 lots, if we had 10 sales, that would show us a trend within that neighborhood. That neighborhood may have been trended 5%, 30%, depending on what the variance was to the market. We had to take a look at, through a lack of valid vacant land sales, we had to take a look at the city in total and made the assumption that the general vacant land sales were coming in 30% below. So we assumed the previous rates were 30% below and have made those adjustments before we applied any new factors or models.
All right, so then now you've got this one value you said for part of the classification of that land. Now there was something to deal with the lake. Is that
So it is.
Does that change? How did those percentages change? On the same
The
basis?
percentages
or-
didn't change. The amount of the lot, so the lot is 1.45 acres. The primary site is considered the buildable home site if there were to be an improvement that was on that, and that's 16,516 square feet. That's assessed at a total value of 128,800. The remainder is considered residual land, so it's undeveloped and it's not usable in a buildable fashion without some work being applied. So that is being taken into consideration outside of any adjustment for the view that we're calling a Lakeview front, or Lakeview lot.
All right, so you're saying basically you used a rate, you felt from what you saw that there was a 30% increase from your earlier rate for vacant land.
Yes.
So you applied that and then you subtracted a certain amount of money for the land that is, or part of the land that is not usable. Is that how you arrived at the number?
That is correct, but also instead of this taking just a 30% increase, there were influences applied for restrictions. The restrictions were not noted that we could see. Typically, those would be legal restrictions like setbacks, things of that nature, flood zones, something along those lines. We could not see any notation for any legal restrictions outside of that, so that we did not adjust that, but we are taking consideration that part of the lot is buildable and part of the lot would need further development to be considered buildable.
All right, and how did you arrive at what you deducted for that?
The breakout of the portion of the lot, the square footage of the lot that would be used to build an improvement. So the ratio, we have it 16,516 square feet that we're considering to be a primary buildable site. And then the remainder of the property is 46,700 square feet that we are adjusting or using a lower rate because it's not as valuable as the primary building site, because it would take some necessary work to be able to develop that to build or use that portion of the lot.
All right, so you basically have said, look, I'm dealing with a unusual situation, an unusual lot in the city of Muskego, correct?
Yes, that is correct.
Now, and you've used this formula that you've explained to me, the way you did it, which I understand, I think. And are there any other methods that could have been used to evaluate this property? I mean, in your business or in your experience?
So we can use the amount of road frontage, so the amount of frontage on the road. This one is being assessed more on an acreage basis. So we feel that the adjustment on the acreage basis between the two rates for the usable and the unusable portion of the lot gives a better reflection of the market value, as opposed to just valuing it as a front lot with footage or with a linear front foot on the adjoining road.
And if you did it with the linear, it'd probably be more money then, or a higher assessed value?
I believe that it's assessed lower through the method that we're using, yes.
All right, are there any other methods that could have been used?
Just a straight acreage rate, as opposed to two different acreage rates and two different acreage sizes. We could just do an overall rate with an adjustment, but we feel that this breaks out what we've considered to be the buildable, usable portion of the lot versus the unusable, or the portion that would take more intensive development to be able to use.
So I'm not understanding what the difference is between what you used and what you just explained.
So we are using the two different pricing methods, two different land rates for the different type of the land. The entire lot is 1.45 acres. The primary site that would be buildable is assessed at a higher value per acre, but that is at a smaller portion of the lot. The majority of the lot, the 46,700 square feet, we feel it would take a substantial amount of work to develop that, and it's being assessed at a lower value because of the necessary cost to use to develop that lot to be able to use or utilize the full lot.
So it'd be fair to state that of the methods that you're aware of in your expertise, that you chose frankly, the best way to figure out the value of that land.
For this particular lot,
that
yes.
particular lot.
Yes.
I thank you. I don't have any further.
Do you have any questions? You? All right, I have a few questions.
Yes.
You'd be surprised if I didn't. On this record card, Exhibit A, value flag says 5, cost suppress. What does it mean?
So we are using the cost approach. The cost approach is used for all land. So that is just using whether it's a front foot method or an acreage method, or a square foot method that we can use. The cost suppress, this property at one point in time had been considered commercial because of the possible development of a business that was either there or there was a commercial use that had been changed a few years ago. That is just, the cost approach for the commercial or for the residential properties is the same approach. We're still looking at the values of the land and the characteristics that are being priced. But it would be no change in value if we had a cost suppress or if we just had cost. The cost suppress is typically used on a commercial property where we're ignoring the income approach. But there is no improvement here that would generate income.
Okay. So then, looking at the property notes, 125 says OB, and it looks like no change. What does that mean?
That is, they had an open book meeting in 2025, and the determination of that meeting was that there was no change in value.
And right below that, 125, it says land INFL removed. What does that mean?
Yes, that refers to what I was speaking about. There was some influence on the land for restrictions that we could not find any legal restrictions that would affect the value of the property, such as setbacks or zoning limitations. Those were removed through the review process for this year.
Do you know, or can you look up what the fair market value for this property was in the 2024 tax bill?
Yes.
This right here.
Do you have it, Carrie? Or I have it pulled up on GIS. I just need to get to the tax file.
I printed out. So that's from the county.
But I don't see, it doesn't tell me.
2020. Not as quick as you want it.
It doesn't have the fair market value, it only has the tax value.
Okay, maybe that one didn't have that, okay, so he might have to.
Yeah.
And our testimony's over, though, we can't provide any more
I
testimony.
did, I asked him if he could look it up,
Which I thought that's what.
but I don't know if he has it.
The estimated fair market value of the property, according to the Department of Revenue, was $441,800 on the 2024 tax bill.
All right, and when you said that you used a 30% increase, you were using 30% of what number?
Of the previous land rate. So the neighborhoods were established and they had the previous assessment land rate for the land calculations. We adjusted those rates 30%. So if it had been $100 a front foot or such, we would increase that to $130.
I'm just confused. I'm looking at the 2024, it says the property value was $334,500. And if you increase by 30% of that, I don't get the number that you have.
This one took a 47% increase because we also removed the additional influence that I was speaking about. So instead of just a 30% increase, we removed the negative influence for the restrictions that had been applied that we could not verify.
And was that, the negative influence, was that quantified somewhere in your system previous to this assessment?
Yes, it was. I can look that up if you would like. It will take me a moment.
-10 on the primary, -40 on the secondary. We couldn't find out why.
Okay, so it was -10 on the primary site and -40% on the secondary site, or the residual site.
14?
I'm sorry?
What was the residual?
The residual was 40.
I don't think I have anything else. Does anybody else have anything now that I asked these questions? No? All right. Now we go to, do you have anything else that you would like to add from the taxpayer?
Well, he did bring up that this was a 47% increase instead of the 30% that's referenced. So we would just like to add that comment. The only other comment I have is the vacant lots determined that 30% assumption, but I guess I don't understand why there wasn't comps. So, I know I can't ask a question, but that's my statement.
Would you like me to answer that?
Sure.
Okay.
Thank you.
So we don't have similar locations, we don't have vacant land sales of similar types of lots within your area. So we can't take a vacant
Neighborhood.
lot and use it as a sales comparable that's in town in a subdivision versus the lakefront lot or the Lakeview lot. Our determination was made that
Got
of
it.
all the vacant land sales that we were analyzing, they were consistently 30% below the market value, so we were looking at a 30% adjustment of rates across the city.
Can I ask you why that's a rule?
I'm sorry?
I'm just kind of curious, why is that a rule? You can't use other within the city as a
I
comp?
can, but a buildable lot in a subdivision without lake frontage or lake view would not be a
Is not
comparable
comp-
sale. Yes,
Okay.
if we had a sufficient number of similar lots that you sold within the time frame that we were looking at that were similar to yours, then we could use those as comparables.
Okay, so
Yes.
that general assumption isn't a comparable percentage, really?
Well, through the analysis of all the vacant land sales in
Yes.
total,
But this is a unique lot.
this is what, I'm sorry?
A unique lot.
It is, yes, I understand that.
Okay. Anything else?
I think we covered it.
I think
Thank
that's it.
Probably inappropriate to ask more questions at this point.
You're the board, you can ask any kind of questions that you.
Okay, so this is for the assessor. We're looking at the prior records of the assessments, and it appears that there was an increase in the fair market value from 23 to 24, and now we're looking at another increase. So what I would like to know is the 30% that you're assuming something that was from 24 to 25, or was it over the period of several years?
The 30% increase was to the rates that were used from 2024 to get the rates that we are currently using in 2025.
Maybe I can clarify something about just to clarify something about the fair market value that you refer to. The fair market value is the assessed value. If the current ratio was at 100%, the ratio has been declining over the last 4 years. That way, this year we estimated it was going to be around 70%, so that fair market value is going to change with the decreasing assessment ratio, if that makes sense. So from year to year, the assessment ratio in Muskego has shown a decrease. Everything is selling for more than the current assessed value. That fair market value on your tax bill is what the assessed value would be if the ratio was at 100%.
Okay, so when I see that last year, their assessment was 334,500, if I did the math, that would be the assessment ratio, which was, I think, last year 75%.
Right.
We'd figure it out to be what the fair market value is.
Yes, so the ratio changes, the estimated fair market value changes. It's all based on the assessment.
All right. Two other questions. One, I think I forgot to ask you, what is the expected assessment value for 2025?
I'm sorry?
The assessment value, the percentage for 2025?
The assessment level?
Yes.
It's presumed to be 100%. It's not been determined by the Department of Revenue at this point in time, but we just went through a market update where we're adjusting to market, so it's presumed to be 100%.
Right. I just forgot to ask you earlier.
Sure, no problem.
And then oh, you did? Okay. Then the other thing that we would have to determine at the end of this, because this is undeveloped land, I believe, we have to determine whether the proper fractional assessments have been used for undeveloped land. Is that what you're referring to about the buildable and the not buildable having different values?
This doesn't classify as undeveloped if you're comparing that to swamp or agricultural forest. Those are fractional assessments that are assessed at, I believe, 50% of market value. That does not apply to this property.
Vacant and undeveloped aren't the same.
Undeveloped
Depending on what you're looking at. The Department of Revenue has an undeveloped, which includes like swamplands, and there's a special assessment for that. There's undeveloped land, which is raw land, that's typically at 50% of market value. This is a lot in a subdivision, so that it would not be considered undevelopable through the assessment means, but we are taking into consideration that there is some work that would need to be done to the lot to make it at full value.
The two questions you're looking at wouldn't
They
come
don't
into play.
apply. I just wanted to make sure.
Perfect, same thing.
So, all right, so now is there anything else that you wanted to add?
No, I believe we've explained our assessment and the
Okay.
increases to the land rates, and we have nothing further to add.
All right. And for the taxpayer, do you want to do a summary or say anything to wrap up?
Can I just
Sorry.
ask one more question? You've heard now what the assessor has said. They have a method
Yes,
that they arrived at their number.
understood.
You haven't really given us a method.
Understood. I would just like to point out that the impairment on the Lakeview hasn't been considered in their assessment.
Excuse me, I didn't get that last part.
So the Lakeview impairment on their assessment has not been considered. And then, based on what they're describing with the general assumptions of the 30%, I would argue against that, I guess, as well, but I don't have anything.
I'm not sure if she understood, you're asking what's the method she came up with her number? I'm not sure if you
Well, she
I
kind of
agree
answered
with him.
it.
I think that's what.
Yeah, I
okay.
understand his
Oh, you
question.
did, okay.
Yeah,
I got that, but that's basically making an assumption regarding Lakeview impairment. I mean, is there a percentage?
I'm
Is
not
there
an
a
assessor, I don't
percentage?
know, I don't know what that method would be to calculate that, I just want to note that it wasn't considered.
All right, and that wasn't considered in your number of $350,000?
To me, it was, yes.
But again, it was not a percentage or a calculation?
Correct.
All right. Thank you.
Do you want to do a summary or wrap up?
I feel that we've made the adjustments for the land rates, even though they were based on citywide assumptions, I feel are supported by the market that we have. It is a unique lot, and there are no comparable sales directly in the neighborhood or the rest of Muskego to compare to this lot. So, I feel that the assessment is fair, and I have nothing further to add.
All right, so we'll close the evidence, and then the board can discuss. Thoughts?
I'll just throw out, I think the assessor has calculations and numbers that he's given us based on some facts that the city had versus the resident does not, and as a result, they haven't met their burden of proof.
Kind of agree? All right, so anything else we want to talk about? Kind of agree with that statement? Yeah? All right, so we have to fill out this form. We start with C determinations, Carrie?
So usually what people do,
Yeah, I
yes,
can.
he's gonna start.
Yeah.
Right, you can fill in all the other stuff, she can start with C.
She'll go through it. So
All right. So number one, the assessor's estimated level of assessment of the municipality is determined to be 100%.
Go back one page, sorry. Go to number.
Are you on B?
B.
Flip it back.
Okay, the testimony, you have the people who were sworn in.
Okay, so Jeremy goes through this and he'll
okay.
say,
B1.
there was that the property owner
Yep.
gave recent sale, yes or no?
No. No. But I mean, that's here too.
He usually goes through this. And he'll go through it.
Okay.
But if you get it all marked up.
That's fine.
You want to
Let's
jump,
just do it.
you go and I'll take, you're going to start there?
Nope, I'm gonna do what you just told me. All right, B. We know who got sworn in. Sworn in testimony from Jennifer. Did not include a recent sale of the property, did not include recent sales of comparable properties. But instead listed other factors, that this is vacant land. There's a tree barrier that prevents the landowner from having a lake view. It's undeveloped. If sold, much of the land would require reworking, and there's no comparables in Muskego. The assessor then testified that the estimated level of assessment for the current year is 100%, no recent sale of the property, no comparable properties, and the other factors that were listed were there were no comps in Muskego. There is a lake view, but no lake frontage. The lake view is impaired by trees they can't cut. This year in 2025, a negative factor was removed because it had previously been presumed to be commercial. And now that was removed from the assessment. There was an increase of 30% to represent the trend in the city of Muskego for the sale prices of vacant land to be 30% higher than the assessments. A portion of the lot is buildable. 16,550 square feet were determined to be buildable. The remainder was not, and was used in a lower rate was used. The acreage method and not the road frontage method was used, resulting in what the assessor believes to be the best possible way of determining the value was set forth. Anything else that I need to put in there?
Can I object to something or ask?
No, I'm sorry.
Okay.
You have an appeal right, but what, their decision's their decision.
Just one of the things stated,
Oh, it was
incorrect.
30% versus,
No.
if you wanted to correct, if.
I do want to correct something,
if she made a
potentially.
Why don't you ask us?
Okay, so you stated that the removal of the limitations was because it was commercial, but I believe it was removed because it couldn't be proven.
The restriction in negative influence was removed because we could not verify a legal restriction such as setbacks
All right.
or building restrictions.
Thank you for that, because that
problem.
was misstated. And you may have heard it sounding like a question. So yes, the testimony then would be that the negative factor was removed because the restrictions on building were not able to be verified.
That's correct.
Okay, so the only other thing that I want to add, that the assessor did testify that the method used to determine the value of the vacant land was, in his opinion, the most favorable method to the taxpayer.
That's correct.
All right, so then we get to the determinations. The assessor's estimated level of assessment has been determined to be 100%. Board finds that there was not a recent sale of the property. The board finds that there are not recent sales of comparable properties. The Board of Review finds that the assessment should be based on other factors, and we have to check that as yes. And the other factors would be the buildability, the location.
Basically, yeah.
Buildability and location.
Yeah.
Other factors from the board.
No.
Uniqueness of the property. Okay, most credible evidence presented would be, I'm going to suggest the assessor unless somebody's going to tell me something different. Okay, so for a decision, I'm looking for a motion under either 1 or 2 to either state that the assessor's valuation is correct or incorrect.
I'll make the move, exercising his judgment and discretion pursuant to Wisconsin Stat 670.47, print 9, print A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of the fair market value of the subject property, the assessor presented evidence of proper classification of the property using methods which conform to the requirements that are outlined in the Wisconsin Property Manual, that the property owner did not provide sufficient evidence to rebut the presumption of correctness granted to the assessor by law, that the assessor's valuation is reasonable in light of all the relevant evidence, and sustains the same valuation as set by the assessor. It is not relevant to present assessments of other properties as basis for market value of the appeal property.
All right, so Henry's made the motion. We need a second.
I'll second.
So then we take a roll call vote.
Yep.
Gary Boycitz,
Aye.
oh, Jim is not here. Henry Posberg,
Yes.
Cindy Schmier,
Yes.
Mara Spring.
Yes.
That's it, then usually use the system.
All right, so that's, we're closed this one. We'll take a second and we'll start up with the next one.
Are you ready, Mara, or do you want me to go ahead and introduce the case?
Go ahead.
Okay, we're gonna go ahead and introduce the next case. Mara has already explained the procedure, so we're gonna move forward. I will introduce and then I will swear everybody in, and then she will move forward from there. The case is Kathy L. Lemaster Revocable Trust, Jennifer Lemaster here as agent. The property owner resides at South 76 West 18004 Janesville Road. The address for the property in question is South 76 West 18004 Janesville Road. The tax key for this property is MSKC 2193.970.029. The property has been classified as residential. The value in the assessment roll for the current year is land at $804,700. Improvements are $1,386,200, and the total being $2,190,900. And then I will go ahead and swear everybody in. Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony which you shall give in this matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who has just sworn please state your name and address for the record? Can you speak into the microphone, please? Do you have any witnesses, the property owner? Okay. Assessor, please state the estimated,
She's the witness.
but wouldn't she be the agent though? Oh, because you, okay, I'm
We need her
sorry.
name and address on the record.
Agent, I'm sorry. Okay, so as the agent, would you go ahead, please? Name and address.
Jennifer Lemaster was 192 South 65 16 Longwood Drive, Muskego, Wisconsin, 531.
You're in Hillendale, because I have your other records, because I didn't get that, right?
That's right here.
Okay, all right, thank you. All right, will the assessor please state the estimated level of assessment for the current year?
The estimated level of assessment for 2025 is presumed to be 100%.
All right, before we get started, I have to say, again, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is on you as a taxpayer. Do you understand that? All right, so please state what amount, in your opinion, is the fair market value for this property. It says $1,800,000. Thank you. So now it is the taxpayer's opportunity to present their case.
So this property is a lakefront home, older estate style property with dated finishes and no major improvements since 2017. So the grade.
We're having trouble hearing.
I don't know if it's on.
That's,
Yeah,
that
just
doesn't
talk.
If you
sound
put
It's not on?
There it
Is it on?
is. There
Okay.
you are.
There we are.
So older estate style property with dated finishes, no major improvements since 2017. The comparables used are the same as the cities, what the assessor provided: Bass Bay Lane, Island Drive, Kurtz Lane, Janesville Court, and Kieran Court, which range from 1.1 million to 1.77 million. So the subject property is older and not remodeled to the comp standards. And the assessment at 2.19 exceeds the market supported range. I don't know if I stated this either, but the grade I have questions about the grade and how that's determined.
Do you have any other evidence that you wanted to present?
No.
No exhibits or anything like that that you want to hand out to the board?
Do I need to provide the comps that the assessor is using?
The comps that you've discussed in your testimony are the ones that you obtained from the assessor?
Or from the city, yes, they're the same comps.
All right, so assessor, do you have questions for the taxpayer?
So you're basing your opinion of value on the comparables that we have provided for the property? And
Yes.
are you taking all of the comparables into consideration, or a portion of the comparables?
All of the comparables.
All of the comparables, okay. And I see the property was originally purchased in 2017 for $1.8 million from Michael H. Dilworth to the Lemasters. I'm assuming that is you or you as a group?
Yes.
And was there an appraisal at that point in time on the property for the purchase price?
I don't believe so. It was just.
Not that we're aware of.
Okay. And then I see there was another transfer. Now, this one looks like we have the next three sales listed as related as invalid sales that were related to individuals or corporations. So it went from the Lemasters to Kathy Lemaster to Kathy L. Lemaster. But there was in 2021 in March there was a sale for $1,900,000, and then the preceding sales were $1,637,000. Was there an appraisal at that point in time, or how was the sale price determined?
Fair market value, we're not aware of appraisal.
Okay, so the fair market value is, how was that determined? If there was an appraisal, you had comparables, did you arrive at that value yourself?
No, I did not arrive at that value. I'm not aware of how that value was determined.
Okay. I have no further questions.
Questions from board members for the taxpayer? No?
Not at the moment.
No? All right, so assessor, please provide your evidence.
Yes, Nick is handing out his Assessor's Exhibit A, which is the two-sided property record card containing the assessment data for the subject property. And also, he is handing out Exhibit B, the comparable sales for the subject property. I will make one note as he's passing this out. This property, we are using the cost approach, and we won't have to go through all of the comparables because due to the size and the style of the home, once you have the comparable sales, or we can look at those now, comparable number 3, 4, and 5 are multi-story homes. There's a 2-story colonial, a 2-story contemporary, a 1.5-story modern half-story. And if you look down at the bottom of the comp sheet, comp number 3 was determined to be not comparable. Comparable number 4 was not used, and comparable number 5 was not used due to the variation in size and style of the home. Also, there was this is why we are using the cost approach on the home itself. The comparables that were generated were not sufficient to arrive at a sufficient market value for the subject property. Going through the assessment card, the home is a one-story ranch property built in 1993. We have it listed as an average condition on the kitchen and bath factors. It does have a full basement. It is centrally heated and air conditioned. We do show that the physical condition is average. Interior versus exterior condition is the same. There are 2 fireplaces in the home. It is listed as an X- grade in average condition. There's a total of 8 rooms, 3 bedrooms, 1 family room, 3 full baths, 0 half baths, 7 additional fixtures, and 18 total fixtures within the home. There is approximately 5,373 square feet above grade. And there's also a residential detached garage built in 1993. That's approximately 2,010 square feet. And there's a residential pool built in 1993 that's approximately 1,000 square feet in area. Due to the lack of solid comparables, we are using the cost approach. The cost approach is simply the starting factor that we have. So every property starts with the cost approach. This takes into consideration the grade, the quality, the condition of the home, the square feet, upstairs, downstairs, plumbing fixtures, bathroom counts. That information is then used to generate a value on the market approach. But with the size of this property, we had issues finding comparable sales within the jurisdiction to rely on the market approach. We did point out the previous sales of the property. Originally, the valid sale in 2017 for $1.8 million. The subsequent sales were deemed invalid sales because there were related individuals involved, and the property does sit on 2.54 acres, which is assessed as a portion is 60 front feet of primary water, 60 front feet of secondary waterfront, and then waterfront residual. So it is a waterfront lot. And that concludes the assessor's evidence.
So questions from the taxpayer to the assessor?
Why was the cost approach chosen over fair market value, I guess?
So the cost approach, we didn't have sufficient valid comparable sales. It's a ranch home, and it was trying to pull in 2-story homes to get to the same size.
But you did have 1 comparables.
We had 2 ranch sales, or we had 2 sales
2.
of ranch homes, yes. And they statistically are feasible for the market approach, but the other 3 sales were not deemed comparable, and therefore we did not use it because we could not substitute other ranch sales of similar size.
So I mean, you do have comparables, you do have 2 comparables, so I guess I still don't understand why the cost approach was used if you do have comparables.
The cost approach, we had 2 comparables. Generally, we try to use between 4 and 5 before we feel that it generates a good market value from the comparable approach.
Okay. And then I'm questioning the grade. I don't know how that's determined. Can you tell me how that's determined?
The grade is based upon the quality of the materials. It also takes into consideration any design features on the property. If you have tray ceilings, double crown, triple crown molding, different types of flooring, differences between linoleum, carpet, tile floors, granite floors, things of that nature. X is one of the larger grades, or the higher grades that we have on the property, and that was not changed through the revaluation. That has been the grade since the home was built in 1993.
So I guess how am I supposed to object to the grade if I don't know those details either? Because that does affect the assessed value, correct?
Yeah, it does. It affects the cost approach, and it also is taken into consideration on the market approach. The grade is a factor, so a average home is a C grade, and then as you supplement or go higher quality or design, then the grade increases. So it would increase from a C to a C plus to a B minus to a B to a B plus to an A grade, and then ultimately to the X grade. So the grade is showing that it's a finely built home and it's high-end quality.
But I'm asking, how do I object to that and show evidence for that?
Do you have photos of the home? Do you have anything to show the interior quality of the home? Because at one point, the home being built in 1993, there would have been an interior walkthrough to determine that. or it would be information that would be pulled from the plans if we saw significant factors to believe that there was an adjustment for the grade itself. So
How do you determine the grade? I mean, like, more specifics than what you had previously said. So what are the specific things that would make it an X factor? And I just don't think that it has all of the things that you listed.
The property assessment.
So I'm struggling with that.
Well, so there are guidelines in the property assessment manual, but the things that would be physically looked at would be design factors. So if there were angled wall cuts, if there were rounded walls, if it was poured concrete, if it was framed. You'd also take a look at differences between standard carpeting, higher grade carpeting, higher floor finishes, trim amounts, things of that nature, fireplaces. I mean, anything that could be taken a look at, whether it was drywall or plaster or if it was paneling, each component of the home, a higher grade would result in a higher quality of finish and design for the home.
We couldn't hear that
As
question.
far as I know, it's all the stuff from.
It can't be louder, we got, because
It's, it's all the things from 91, but I mean 93 when it was built.
Well, the grade of the home wouldn't change over time. It's
Because there's no crown molding, there's no round ceilings.
Well,
It's
you
a
could
vaulted ceiling.
You could change things, but the vaulted ceiling would not change.
Right.
You can change the flooring, so you may have downgraded the flooring that was there. The last time that
It was pretty cracked.
taking a look here to see.
Oh,
The
they did
last
rate it?
time that we were
they said
inside the property, looks like it would have been 2012, so it's over a decade ago, 13 years.
Oh.
And that would have been the last time that there would have been a determination on if the grade was correct, if there was a permit or something that necessitated an interior inspection.
And that was when, 17, did you say? Or
2012.
Oh, 2012.
So, I mean, we don't have evidence ready right now to submit for that, so. I'm just saying, I don't know if I can say this or I have to ask a question, but we just don't have evidence to prove the grade we think needs to be lower. I just don't have that ready right now. Additionally, I'm mad at myself because I used the city comps. I did have comparables that were outside of the city that I feel prove the lower rate also, but my mistake.
Well, I would make the comment that you are allowed to go outside of the jurisdiction for comparables.
Right.
I mean, if it's a similar location or something along those lines.
Right, I just don't have that in front of me or prepared.
I understand, but I mean, it is acceptable to go out if it's a unique property, yes.
Right, so I did look at other comparables to determine my objection amount.
Do you have other questions for the assessor?
No.
Okay. Questions for the assessor from the board? I guess I'm still stuck on the grade. It sounds to me like the grade has to do with the initial construction quality of the home.
The initial construction quality of the materials and the design. So the more intricate the design, the more customized homes have a higher grade. The higher quality floor finish, wall finish, plumbing fixtures, designs such as tray ceilings, vaulted ceilings are all things that are taken into consideration with the grade. So with the grade being an X grade, it's considered to be one of the finest grades possible. So we're looking at high-end construction.
But that's the original construction, that's not the current condition. That would be CDU, correct?
The CDU would be condition, desirability, and utility. So that would be more of a physical or a locational adjustment. But through the cost approach, we start with the cost to reconstruct the property as is, less depreciation for the age. So at the older that it would get, it would accrue more depreciation, but the grade would change. Typically, a grade won't change. If it does change, it won't change much. So if we have an X grade home based on physical features or design or the quality of the materials that were used, the materials can be changed, but part of that would still be the design of the house. If it was a custom-built home with finer quality finishes, those finishes could change over time, but it would be a significant change to go from an X to an A or a B grade home.
I just want to make sure I understand it completely. I think what you're saying is you can have an X-grade home that's in terrible condition.
That would
They're
be
just completely different analysis. What's the grade versus what's the condition?
Yes, the condition is a physical quality, and so if there's a lot of deferred maintenance, or if there's a lot of wear and tear on a property, if the property was built in the 60s and had never had any type of repair of the original quality, or original carpet, that would be worn out, things of that nature. So the condition of the home is more of a physical nature, but not to be confused with the CDU, which is part of the condition, but also desirability and utility.
So on this Exhibit A on the back, there says dwelling computations, and I think that's how you came up with the cost approach of the dwelling value of $1,340,600, correct?
Yes.
There's a thing that says percent good 85. Can you tell me what that means?
The percent good is the depreciation, so that it would be receiving 15% depreciation, but the percent good is the inverse, so it's 15% bad and 85% good.
So when you came up with your subtotal for the value, you took 85% of that to come up with the dwelling value?
That is correct.
All right, I got it. Anything from anyone else? All right. Taxpayer, do you have additional evidence you want to present?
I don't, no.
Assessor, anything else?
I have nothing further to add.
All right, so taxpayer, would you like to present a summary or conclusion statement?
Just that this is an older estate style property with dated finishes and no major improvements since 2017. The city comps show a 1.1 to 1.7 fair market value, and the subject is older and not remodeled up to those comp standards. So the assessment at 2.19 exceeds the market supported range.
Assessor, would you like to make a summary or a conclusion?
Just briefly, that we are using the cost approach because we did not have sufficient comparable properties to estimate the market value of the property. We feel that it has been quite some time since, excuse me, quite some time since we've been inside the home, so to verify the information, the grade has been X, at the X level, as far as I can tell from the time it was built.
All right, so that'll conclude the evidence, and now will be time for the board to discuss. Anything?
I don't think the resident has met the burden of proof. Again, only information of any statistical nature is what was provided by the assessor. And we are to presume that the assessor is correct unless we find reason to believe he's not. And I don't think evidence has been submitted to indicate that.
I agree. Okay. I'm hearing a lot of I'm seeing a lot of nodding, so we'll just start going through the paperwork. Sworn testimony was presented by Jennifer Lemaster, did not include a recent sale of the subject property or recent sales of comparables other than the ones that the assessor provided. The property owner relies on additional factors. She states that it's a lakefront home with no updates. The home has dated finishes, and that the comps that the assessor used were newer homes. The taxpayers questioning the grade that was assigned to the home and states that the assessment exceeds a market-supported range. The sworn testimony of the assessor is that the estimated level of assessment for the current year is 100%. There's no recent sale of the subject property. There were recent sales of other properties, but they were not comparable. Comparable sales were considered, but they were all ultimately ruled out as being insufficient to be truly comparable. And they could only find two and that might have been comparable, and that would be insufficient to support a market approach. And therefore, the cost approach was used. Other factors that were used by the assessor include the size, defining features, and different rates were used for the dwelling and I believe it said primary and secondary land use. The grade is
Frontage use,
frontage use.
frontage use,
right.
yes.
The grade is X minus, which reflects the initial quality of construction, and the CDU is listed as average. So then we go to the determinations. Determination number 1, the assessor's estimated level of assessment of the municipality has been determined to be 100%. The board finds there was not a recent sale of the subject property. The board finds that there are not recent sales of comparable properties. The Board of Review finds that the assessment should be based on other factors. Those other factors would be the lack of comparable sales, the size, defining features, and the lakefront nature of the property, the average CDU condition, desirability, and utilization, and the original construction grade of X minus. The most credible evidence presented would be by the assessor, and then I would be looking for a motion regarding number 1 or 2.
I'll move that in exercising its judgment and discretion pursuant to Wisconsin statute section 70.47, parens 9, parens A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of fair market value of the subject property using proper methods, that the assessor presented evidence of proper classification of the subject property using proper methods, that the property owner did not present sufficient evidence to rebut the presumption of correctness granted by the law to the assessor, that the assessor's valuation is reasonable in light of all relevant evidence, and sustains the same valuation as set by the assessor.
I'll second.
Do we want to check the last box or no?
We can add the last box if you wish. I'll add that to my motion.
Yeah.
The last box says that it's not relevant to present assessments of other properties as a basis for the market value of the appeal property.
Right, and then
Did
we'll go
Henry
to...
second? Yeah.
We got a second.
Okay, so now we'll,
Roll call vote.
Then we'll go to the roll call.
Gary,
Well, we have to, did we put the values down? Did
that's
we?
only if it's a,
this
Oh,
is number
that's
2.
right, that's right. Okay.
Gary Boysetts,
Yay.
Henry Posberg,
Yay.
Cindy Schmier,
Yes.
and Mara Spring.
Yes. All right, so that will conclude hearing number 2. Do you need a minute before we can go on?
Yeah, I was going to say, can I have just a moment to speak with the homeowner about the last property?
Sure.
It's nothing pertaining to the case, but, so one of the things that we can do, and it wouldn't be anything that would affect the hearing today.
Yeah,
but
just
it would-
call.
What did I do now?
Which one are we on?
We're on number 12.
Say submitting Jeff, I'm assuming she's complaining about something. What did I do now?
All right.
I got my stuff messed up.
Uh-oh.
Instead of it going
We're on 12.
No. All I can do, I have a headache, we gotta do this tomorrow.
Well, tomorrow's gonna be quick.
Let's hope so. Now you said it, yeah. There'll be 10 more show up and.
You need a lot of people.
Okay.
Are they done? Should I?
Can we just call it? Let's go.
Maybe there's one loose here.
Wisconsin Property Assessment Manual
I
online.
wasn't asking her because she's the agent.
I just thought you would give everybody who raised their hand
I'm on board with that.
Okay.
Ready?
Mm-hmm.
I do have.
Here we go. Okay.
So all the recordings are working?
Yes, everybody.
Everybody's microphones should be working now.
The next one.
All right, so the recordings are working, so now we'll call the next case for hearing.
Okay, and I just want to double check that we're still all good. Okay, all right. Video and audio is recording. I'm introducing the case of Kathy L. Lemaster. Revocable trust, agent is Jennifer Lemaster. The property owner resides at South 76 West 18004 Janesville Road. The address for the property in question is South 76 West 18006 Janesville Road. The tax key for this property is MSKC 2193.970.028. This property has been classified as residential. The value in the assessment roll for the current year is $765,300 for the land. Improvements are $422,100, with the total $1,187,400. Then I think I'm going to go swear in right away, right, Mara?
Yes, please.
Okay. Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who was just sworn, please state your name and address for the record?
Kathy Lemaster, South 76 West 18004 Janesville Road, Muskego, Wisconsin, 53150.
Thank you. And would the agent/witness please state her name and address?
Jennifer Lemaster, West 192 South 6560 Hillendale Drive, Muskego, Wisconsin, 53150.
Assessor, please state the estimated level of the assessment for the current year.
The estimated assessment level for 2025 is presumed to be 100%.
Mara, did you give the fair mark,
I will.
oh, I thought we were jumping ahead here. Thought you did that before in the past. Sorry.
And Carrie, you're done?
I am.
All right. So before we get started with testimony, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand that?
Yes.
I do. All right. So we need to know from the taxpayer, what amount, in your opinion, is the fair market value of this property?
Can you tell me what's stated on the objection?
It says $1 million.
$1 million.
Great. So at this point, it is the taxpayer's opportunity to present evidence.
So this house is rated in fair condition with no substantial update.
Can you go closer to the microphone?
The comparables used are Bass Bay Island, Island Drive, Janesville Court, Kurtz Lane, and Karen Court, which sold for $1.1 million to $1.77 million. Those comparables are in good or very good condition versus the subject's fair rating, and our assessment is the $1.18 million is too high.
Do you have any exhibits that you'd like to present?
No.
Any other witnesses you'd like to call?
No.
All right. So for the assessor, do you have questions for the taxpayer?
I see that the other properties that we've been looking at, looks like a lot of these properties were purchased in 2017 from Michael Dilworth. The last valid sale that we have was 6/12/17 for $1 million. Was there an appraisal on the property at that point in time? It was just.
Not that we're aware of.
Just an asking price and an offer to purchase? Okay, and then, again, it went from Sunfish Development in 2021 to, I'm sorry, yes, to Kathy Lemaster for 1.4 million. Again, was that based on an appraisal?
Related party.
It was related party that we're not saying it's valid, but,
Yep.
okay.
That we're aware of.
Okay, and I believe that's all the questions that I have.
Any questions from the board?
No.
No? All right, so for the assessor, your chance to present your case.
All right. Nick is passing out Assessor's Exhibit A, the two-sided property record card containing the assessment data for the subject property. And he's also presenting Exhibit B, the comparable sales. As he's passing those out, I will go ahead and make a note that, like with with the last property, we are not using the market approach. We are using the cost approach on this property as well. We can go through the comp sheet if you would like, but I will point out that, again, there were only two valid ranch comparables that were within range. The comparables 3, 4, and 5 were multi-story contemporary colonials and a 1.5 modern half-story. Due to the differences, we feel that the market value based on the comparables that were used to arrive at that would come in on the low side because it is comparing the ranch home to two-story or multi-story homes. We are also using the cost approach through some information that I'll bring up here in just a moment as I go through. The subject property sits on 2.06 acres of land. It is considered a waterfront lot. We do have 60 front feet of waterfront prime. We have 60 front feet of waterfront secondary, and we have 59 feet of waterfront residual. The subject property is a ranch home built in 1990. The kitchen and bath ratings are listed as average. It is centrally heated and air conditioned. We do have the physical condition as poor, the interior versus the exterior as poor, which means that the interior is showing more wear and tear than the exterior of the home. The grade is an A+. The condition, desirability, and utility is listed as fair. So we are showing that also, not only did we have insufficient comps, but also there were large adjustments that would be made because of the physical condition of the property in comparison to the sales. The home consists of 10 rooms, 3 bedrooms, 1 family room, 3 full baths, 1 half bath, 8 additional fixtures. We're showing that there is finished basement living area of approximately 1,500 square feet. There is a prefab fireplace, and the main floor of the home is listed as 3,193 square feet, with a total living area, including the finished basement area, as 4,693 square feet. There's also a detached garage built in 1992 that's listed as a 40 by 30, or approximately 1,200 square feet. That is assessed currently at $900. So based on the condition ratings of the subject property and the lack of ranch homes of the similar size and the comparables being multi-story contemporaries, colonials, and half-stories, we did feel that the cost approach was a more accurate representation of the market value of the subject. And that concludes the evidence for the assessor.
Taxpayer, do you have questions for the assessor?
So this property specifically, at one point before it was purchased by Kathy, was posed to be condemned, I guess, at some point. I don't have record of that to prove that, but is that considered in your assessment at all?
The only thing that I have that was taken into consideration is that as of 1/17, the Muskego Beach Club was not happening, house still in poor condition. I have no notes that it was set to be condemned or raised.
Okay. Does that get considered in your evaluation? And we just don't have record of it, but would
We
that
don't
be
have,
considered?
it would be something that we would take a look at, that it may be substandard on the condition of the home, but we have no notes showing that. We are reflecting that it is in less than average condition, and it is, the interior versus the exterior and the condition, we do have that below average, yes.
Okay. The only other question I have is, you used the cost approach only because you had 2 comparables. 3 comparables would have made you use the fair market value instead?
We usually try to use somewhere between 4 to 5 if possible.
Okay.
With it only being 2 ranch sales or 2 comparable properties, we don't feel that that gives a good representation of the market approach. But also, we're using the cost approach because of the condition of the property.
So you can't give your opinion on the fair market value based on the 2 that you have and the condition of the property?
I think that the fair market at 920,100, I feel would be low for the property, and that's why because of the condition and the other amenities, the lack of comparables, we feel that the 1.187,400 cost approach is more representative of the actual market value.
So you said the 900,000 amount would be low. We're objecting and saying a $1 million amount is more fair than what you've determined with the cost approach. Would you feel that that's fair?
I believe that the cost approach is appropriate in this situation due to the lack of sufficient comparables and the condition of the property.
Any other questions?
No.
Any questions from the board?
No.
I'm going to just ask, I think it's a computer question. Your last comparable from the previous case indicated on the comparables that it printed not used, not comparable. This one doesn't have that on there.
Yes,
are there different programs that you use?
No, it's the same program. It was just an excessive amount of adjustment. So to arrive at a market value, there was more than a 50% adjustment in the sales price of that property due to the size or the condition of the other home. This one is coming in statistically a little bit more usable, but it's still, we don't like to compare ranches to multi-story homes because they sell within different, they sell under different factors and in different markets. The ranch style homes are going to sell more per square foot because everything's on one level. So the 2-story homes will sell a little bit cheaper per square foot because it's cheaper to build vertically than it is horizontally. When you build horizontally, if you were to add on to a home, it's cheaper to build up because you're not increasing the footprint and you're not increasing the roof line. So those are factors that are taken into consideration for homes, so they do sell at different rates, and it's not appropriate to compare ranches to multi-stories, bi-levels, things of that nature. We try to keep it as simple as one-to-one on style as we can.
All right, so the fact that you're using the same comparables really is because you got a different property? Is that, are those the only ones you could find?
It's a large ranch home, and the condition on this one is, I believe, lower, or I would have to look at the previous case to see which is in the worst shape. But typically, it's the same program that we're using. We just try to keep it more similar, the most comparable with the style and the condition and the size. So it's a large ranch home. There are a lack of sales of ranches of that size to give us 5 comparables. So it's reaching out and trying to find the most comparable size, which it is then turning to multi-story homes.
Thank you.
I have a question for you about this property record card. On the property notes, it says from 117, Muskego Beach Club not happening, house still in poor condition. I'm trying to figure out why you have fair listed under the CDU instead of poor.
So the CDU is not a direct representation of the condition of the property. It's the condition, desirability, and utility. So there's 2 non-physical factors that are taken into consideration with the CDU factor. The actual physical condition for this property is listed as poor, and the physical condition of the interior versus exterior is poorer, meaning that the interior is more deferred, or run down than the exterior of the home. But the CDU, again, an average condition home in a nice neighborhood may have a CDU rating of good or very good, because it's also taking into consideration the aesthetics and the location of the home. So it's not just a straight condition rating. The physical condition is listed as poor, the CDU is listed as fair.
And then when I look at the other exhibit, which shows the comparable sales, it also lists information about the subject parcel. And we have K rating and B rating, and they both say average. What does that mean?
So the kitchen and bath ratings are ratings that we can adjust for adjustments for remodeling. So at average or fair, that would show that there would be some deferred maintenance. The route that we have chosen is to adjust the CDU down and the physical condition to poor. So it, again, with this property, the last inspection we had was in May of 2012, so we have not been inside the property for over a decade.
I just am trying to figure out why the kitchen and bath ratings are average as opposed to fair or poor.
They could be lowered if we had sufficient information. So we feel that everything is captured in the CDU of fair and the physical condition of poor. We would not necessarily have to adjust all the condition factors. Typically, what we would use those for are severely dated kitchens that have not been updated, or older homes with updated kitchens and baths that we would apply a factor to increase the value due to the remodeling.
So then if you go back to the record card, under the dwelling computations, you have the percent good 77. And I think that means that you're saying 23% of the property is not good.
So the percent good is 77%, it's 23% depreciation, but if you come down 2 lines to economic, it's also receiving 55% due to the condition ratings of the home as well. So there's an additional reduction in value.
Okay, so in addition to that 23%, you also took another 55% down?
Yes.
And that's why you get all the way from 926 down to 421,000?
That's correct, yes.
Okay, I think I got that. Any other questions from anyone else? All right. Did you have anything you wanted to add, taxpayer? No? Assessor, anything to add?
I feel we've provided everything that we have to provide.
Taxpayer, would you like to do a summary? You don't have to, but if you'd like to,
We would object that the cost approach should not be used and fair market value should be used, and the property should be assessed at 1 million based on the comparables provided.
Assessor, would you like to make a summary?
I would just summarize that we are using the cost approach due to the condition of the subject property, and also a lack of sufficient comparables to use the market approach.
All right. At this point, the evidence is closed. Time for the board to discuss. Any comments, discussion?
I'd say let's go with the assessor. We have nothing else to.
I can say that I don't think that the property owner provided, what am I supposed to say?
All right.
Provided enough foundation for their assessment.
All right, so I'm seeing nodding in response to that comment, so we can go through the paperwork. The sworn testimony was provided by Jennifer Lemaster. No recent sale of the subject property, no recent sales of comparable properties were presented. The taxpayer relied upon the assessor's comparables that were provided, I believe, at open book, and all of those were in good or very good condition, while this property was noted to be in fair condition. The assessor testified that the estimated level of assessment for the current year is 100%. There was no recent sale of the current subject property, and while there were comparable properties identified, the differences between them and this property were too significant to make them usable. Only 2 were found to be within the range, and the assessor would like to see 4 to 5 properties in order to use the market approach. Because of this, the assessor determined that market value would not reach an accurate value and instead used the cost approach. Other factors considered by the assessor include the waterfront footage of the property, including waterfront prime, waterfront secondary, and waterfront residual. There was further reduction in the cost, using the cost approach, because the interior and exterior condition were noted to be poor, and that resulted in a significant reduction due to the property's poor physical condition. So we go to the determinations. The assessor's estimated level of assessment of the municipality has been determined to be 100%. The board finds that there was not a recent sale of the subject property. The board finds that there were not recent sales of comparable properties. The Board of Review finds that the assessment should be based on other factors, and that would be the cost approach presented by the assessor, the waterfront footage that the property has, and the physical condition of the property being poor. The most credible evidence was from the assessor, and then I'm looking for a motion.
I'll go. Exercising his judgment and discretion pursuant to Wisconsin Statute 970.47(9)(a), the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of fair market value of the subject property using assessment methods which conform to the statutory requirements were outlined in the Wisconsin Property Assessment Manual, that the assessor presented evidence of proper classification of the subject property using assessment manuals, that the property owner did not present sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the assessor's valuation is reasonable in light of the relevant evidence and sustains that the same as value is set by the assessor. It is not relevant to present assessments of other property as basis for the market value of the property.
Need a second?
I'll second.
So we'll do a roll call vote.
Gary Boycitz,
Aye.
Henry Posbrig,
Aye.
Cindy Schmier,
Aye.
Mara Spring.
Aye. All right, so that will be closed, and we'll just take a short break for
Just the stamp.
just a couple minutes.
Introducing the case of Kathy L. Lemaster Revocable Trust, Jennifer Lemaster as agent. The property owner resides at South 76, West 18004 Janesville Road. The address for the property in question is West 187, South 6938 Gold Drive. The tax key for this property is MSKC 2175.983. The property has been classified as residential. The value in the assessment roll for the current year is land at $403,800, improvements $357,300, with a total of $761,100. Would all the persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in this matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would the property owner who just sworn please state your name and address for the record?
Kathy Lemaster, South 76, West 18004, Janesville Road, Muskego, Wisconsin, 53150.
And as the witness and agent for the property who was just sworn, please state your name and address for the record.
Jennifer Lemaster, West 192, South 6560, Hillendale Drive, Muskego, Wisconsin, 53150.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for 2025 is presumed to be 100%.
Okay, before we get into the testimony, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as a taxpayer. Do you understand that?
Yes.
And what do you, as a taxpayer, believe that the proper fair market value of the property is?
Can you tell me what's on the objection?
$720,000 is on your objection.
$720,000.
Thank you. Now it is the taxpayer's opportunity to present their evidence.
I just want to note you, for the record, that you stated this was Kathy Lemaster Revocable Trust. It is not. It's only under Kathy Lemaster.
I'm moving it into the.
It's moving into the trust, but that's not.
Your objection says revocable trust, so you just want that corrected?
It's in process, so I just
Okay.
want to make that noted.
Okay, go ahead and present your evidence.
Lakefront home with recent water damage from the storm that occurred, and additional HVAC deficiencies that I don't think were considered. In addition to the city comparables, I do also have some of the recent comparables to utilize. The city comparables are larger, more updated, and in superior condition in addition to what I can provide. And the subject's condition issue justifies a lower value.
Okay, before we go any further, I want to clarify something with the city attorney. When we are talking about the value of these properties, we are talking about their value on January 1st of 2025. Is that correct?
That's correct.
So if they sustain damage during the course of 2025, that is not to be considered?
That would not be considered.
Okay. So is there any other evidence that you would want to present?
So I have comparable addresses that I can provide that would justify a lower assessment value that were outside what the city provided. So South 75 West 17553 Harbor Circle.
I'm sorry, can you repeat the address? I got to write it down.
I know, I don't have it printed. South 75 West 17553 Harbor Circle. The sales price was $649,900, and this is lakefront. West 183 South 6558 Jewel Crest Drive.
I'm sorry. You have to say that one again.
West 183 South 6558 Jewel Crest Drive. I'm sorry, people tell me I'm loud, so I'm just like scared I'm being too loud. This is another lakefront with frontage. West 177 South 7495 Harbor Circle. This is a townhouse with recent upgrades at $959,900. And then West 188 South 7598 Oak Grove Drive. This is a renovated waterfront home at $1,199,000.
All right, so with respect to the first one, S75W17553 Harbor Circle, you said $649,900?
Correct.
Do you know the date of the sale?
I don't.
Then the Jewel Crest Drive address, you didn't give us the number, the value.
Oh, I'm sorry, $599,000.
$599?
Yep, lakefront with frontage.
Do you know the date of that sale?
I don't know any dates.
With respect to the second Harbor Circle, $959,900?
Mm-hmm.
And do you know the date of that sale?
I do not.
And the other one was Oak Grove Drive?
Oak Grove Drive.
And that was $1,199,000?
Mm-hmm.
You don't have the date of that sale either?
I do not.
Those are all located in the city of Muskego?
I believe so.
Any other testimony that the taxpayer would like to provide?
The only other testimony I can provide is on the HVAC deficiencies. So it's an original boiler. The home has partially part of the original home from 1923, and there's a boiler system that is deferred maintenance. There was pipes freezing this past winter, and the HVAC does not go throughout the home. It's only partial to the home. So I just want to make sure that's considered and make sure that was addressed in the assessment.
So the assessor, do you have questions for the taxpayer?
Yes, I do. The properties, the comparables that you listed on Harbor Circle, are those condos or freestanding single families?
They state townhouses.
They state townhouses?
Correct.
And you don't have any of the sales dates, you just have the last, most recent sale for those properties?
Yep.
Okay. I have no further questions.
Anything from the board? I have one question. On your objection, you indicate that there was the sale of, or your acquisition of the property December 23, 2023, or December 22, 2023, and the price was $917,900. Was that an arm's length transaction or a relative?
That was an arm's length transaction.
All right.
So the original purchase of the home was in '87, which is listed on the property sheet or the record card. But then all of the subsequent transactions were arm's length.
I don't have anything else to do. Any other questions? All right, then the assessor, it will be your turn to present your evidence.
All right, I have Nick passing out Assessor's Exhibit A, which is the two-sided property record card containing the assessment information for the subject property. And he is also passing out the Assessor's Exhibit B, which is the comparable sales analysis with the comparable sales used to value the home. I will make note as he's passing out the information that this property we are using the market approach. The subject property currently resides on 0.52 acres. We do have that as 50 feet of waterfront primary land, and we also have a secondary waterfront of 2 feet, so slightly below, or not, the majority of the waterfront is primary. I was going to point out that the last sale on the property, we have it listed as invalid because it's related to individuals or corporation, but it was listed at $917,900 for the land and the building in December of 2023. The subject property is a colonial two-story home built in 1929. We're showing that it was remodeled significantly in 1989. We have the kitchen and bath are listed as average. It does have a full basement. It is centrally heated and air conditioned. We have the physical condition as average. The interior and exterior are the same. No fireplace. It is listed as a B- grade. CDU rating is very good. 7 total rooms, 4 bedrooms, one family room, 3 full baths, 0 half baths, 1 additional plumbing fixture. We are showing that there is a rec room of approximately 1,968 square feet. I'm sorry, 660 square feet, the value of that being 1,968. And the ground floor of the home is 1,172. The total living area is 3,345. Moving to Exhibit B. Comp number 1 is 166 South 8362 Kurtz Lane. The subject, or that property has 0.31 acres of ground, is a 2-story contemporary home built in 1995. It has 9 total rooms, 4 bedrooms, 4 full baths, 0 half baths, 2 additional plumbing fixtures. It does have a full basement. It is centrally heated and air conditioned. The grade is considered to be a B+. It is in very good CDU rating. The above grade square feet is 2,424. We are showing that there is 680 square feet of basement finished, which brings the total square feet of living area to 3,104 square feet. Kitchen and bath ratings are listed as very good, and that property sold for $1.3 million in July of 2024, approximately $418 per square foot, and an adjusted sales price of $810,400. Comparable number 2 is 76 West 18160 Janesville Court. This property contains 0.41 acres of ground, is a 2-story contemporary built in 1984 with 6 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 3 additional plumbing fixtures. It has a full basement. It's centrally heated and air conditioned. The grade is A- and it's in very good condition. The ground floor is 2,818 square feet. We show no finish in the basement for a total of 2,818 square feet of finished living area. Kitchen rating and bath rating are listed as average. That property sold for $1,180,000 in June of 23, approximately $418 per square foot, and an adjusted sales price of $717,900. Comparable number 3 is 75 West 18642 Kingston Drive. The property is on .21 acres of ground. It is a 2-story contemporary built in 2000 with 6 total rooms, 2 bedrooms, 3 full baths, 1 half bath, 5 additional plumbing fixtures. It does contain a full basement. It is centrally heated and air conditioned. The grade is considered to be a B in very good condition. The ground floor is 2,057 square feet. Finished basement area is listed as 552 square feet for a grand total of 2,609 square feet of finished living area. Kitchen and bath ratings are listed as average. That property sold for $1,250,000 in July of 2024, approximately $479 per square foot, with an adjusted sales price of $728,800. Comparable number 4 is 66 West 18515 Jewel Crest Drive. The property is a 2-story colonial sitting on .18 acres of ground. It is built in 1994 with 5 total rooms, 3 bedrooms, 3 full baths, 1 half bath, and 3 additional plumbing fixtures. It does have a full basement, is centrally heated and air conditioned. It is listed in a B grade and very good condition. The ground floor is 1,835 square feet. There's 987 square feet of finished basement living area for a grand total of 2,822 square feet of finished area. The kitchen and bath ratings are listed as average. That property sold for $1,150,000 in June of 2023, approximately $407.51 per square foot, with an adjusted sales price of $782,500. Comparable number 5 is 208 South 10650 Karen Court. This property contains 1.18 acres of ground, is a modern 1.5 story, built in 1988 with 8 total rooms, 3 bedrooms, 3 full baths, 1 half bath, 3 extra plumbing fixtures. It has a full basement, is centrally heated and air conditioned. It is a B grade in good condition. The ground floor is 2,936 square feet. There's 800 square feet of finished basement for a grand total of 3,736 finished square feet of living area. The kitchen and bath rating, the kitchen rating is listed as good. The bath rating is listed as average. That property sold for $1,135,000 in May of 2024, which is approximately $303 per square foot. The adjusted sales price for that comparable is $586,600. We had previously discussed, and we did mention this, the previous sales price from December 22nd of 2023 for $917,900. We are looking at that as an invalid sale due to the related individuals or corporation. The owner or the appellate has mentioned that that was an open market transaction. We feel that the assessed value of $761,100 based on the comparables is a fair assessment for the property.
Taxpayer, do you have questions for the assessor?
I do. What do you consider, can you define the full basement, fully finished basement?
The what, I'm sorry?
The fully finished basement, can you define that for me?
The fully finished basement, the basement is approximately 660 square feet. A finished basement is going to be finished commensurate to similarly to the first floor, so it's going to be a similar quality of finish.
Great, can I show you a picture of the aged mechanicals and unfinished part of the basement?
We'll do that when it's your turn to give more evidence.
Okay.
Right now it's questions for the taxpayer.
That's all.
That's it? Okay.
Any questions for the assessor from the board? No? All right, looks like none. So now, taxpayer, do you want to present any other evidence?
I would. I have a picture of the aged mechanicals that I was referring to. Additionally, that I don't know how that's defined for you guys, but the HVAC does not go throughout the house.
Okay.
So it's only on the main level and exhaust to the attic. And then the basement is not fully finished. there is a section that is not finished.
We are currently showing 660 square feet of finished basement, so it's not.
That's why I was asking what the definition, I don't know the square footage, obviously, so.
Right. Well, we're not saying it's a completely finished or finished
Okay.
basement.
Okay, but I do have a picture of the
Okay,
aged
so
mechanical.
it sounds like you have a photograph, but it's not printed.
It's correct.
So is there a way we can do that?
It's on my phone, but I can get it on my computer. I mean, I can bring my phone.
Can she email it to you?
The other option is Jenny says that it can be emailed, Jenny suggested that it
So we're assigning the air conditioning, do we put it in that area, or we just click yes or no?
Are you guys gonna need this to, because you could just go look at her, phone like we do in court.
Please send it to me, please email it to me, I'll give you my email address.
Some systems.
I think we'll want it for the record.
I mean, eventually, right.
Yeah.
Yes, absolutely.
Okay.
As long as you've got a copy of it that we can keep with the record.
She'll email it to me, I'll bring it up on the screen.
Great.
And then I will also have it to sign.
Okay.
But you don't need it.
I don't think we need a printed out copy right now, just so that we have it with the record.
Ready?
Ready.
K, R-O-L-L-E-R, at Muskego, .wi, .gov.
Got it. Thank you. Done. Yeah, I can have evidence now, yeah.
I just wanted to add on the air conditioning, the house is heated hydronically, there's no ductwork throughout the house. So the only way we could get any air conditioning was through an attic, which only drops down into the upstairs. So the main floor, basement, it doesn't reach any of that other than heat rising and air colder
There's your
dropping.
picture.
There's my boiler.
There it is.
All right, so,
That's just the boiler.
is that all we got?
That's all I got.
Okay, no, I didn't mean it like that.
That's okay.
We just want to say,
You guys let me know if I need to move around the picture.
that's not going to show you much. But anyway, the house is.
Oh, you can see it,
hydronic,
you can see
there's
it here
no
too.
duct.
It's one picture.
Yeah, it's one, just one.
In fact, it's actually an email on it. If I click on the picture, it actually gets smaller. You done?
Take the picture that you get a little further up.
That's aluminum tape.
Yeah.
You know what year the boiler system? You know the year of that?
Of the boiler?
Yeah.
You guys are gonna have to speak up. If
I don't
you
know
gave
I do
testimonies,
not,
yeah, so
I
we
do
gotta
not
have it
know the
recorded.
year of the boiler. No, I don't.
Thank you.
I could probably find out.
Okay, anything else from the taxpayer?
No.
Go ahead.
I'm simply going to ask you, what is the purpose of you providing us with this picture? What are you trying to show us or tell us?
There's deferred maintenance and HVAC that should be considered when considering the fair market value. So it's, in its state as of January 1st, 2025. There's a lot of work that needs to be done, not only on the mechanicals, but the home in general to be sold at the assessed value that it's currently
Are you
assessed at.
claiming that this is not working, or?
It's working, but there's many repairs on it.
Okay. Anything else? No? Anything else from the assessor?
Nothing, thank you.
Do you want to do a closing, any kind of closing remarks, taxpayer?
Just to reiterate my previous statements of the HVAC deficiencies, not only the comparables that the city provided, but the ones that ILS provided show that they are larger, more updated, and in a superior condition, and that the subject property justifies a lower value.
Any summary or conclusory remarks from the assessor?
Excuse me. I feel that we've provided the comparables to establish the market value of the assessment of the subject property. I feel that the assessment is fair and equitable, and we've used market information to determine that assessment. So I have nothing else to add.
Thank you. Oh, go
Just
ahead.
one question for the assessor.
Yes.
Were you provided with the comparables that the owner referred to at this hearing?
The comparables that she provided?
The addresses, were you
the only
provided those at open book or before the hearing or anything like that?
I don't believe so. We have some notes about the HVAC and the water in the basement, but I don't see any additional documentation of any comparables that were provided at open book.
Thank you.
All right, so evidence will be closed, and it'll be time for the board to deliberate. Any discussion?
I'm good. Broken record, but unfortunately, I think the burden of proof hasn't been met in challenging the assessors.
In addition, just in case anybody's curious, these same 5 comparables we've seen before today, and all of those appear to have used the same approach that this one did. So they all resulted in a value that was roughly around the same as their cost estimate. Unlike some of the ones we saw earlier today that seemed like they were off. This one seems consistent with the others. All right, so we'll go through our paperwork. Sworn testimony was provided by Jennifer Lemaster. It did include a recent sale of the subject property, but it was to a related party. The subject property was sold for $917,900 on December 22nd, 2023. The taxpayer presented recent sales of 4 comparable properties. Those addresses we have written them down on Harbor Circle, Jewel Crest, Harbor Circle, and Oak Grove Drive. The other factors that the taxpayer relies on is the fact that the condition of the property is poor, that she stated there was recent water damage, and then we clarified that it should have been the property's status as of January 1st of this year. There was reference to the 1923 boiler system and the fact that the HVAC system is partial, doesn't provide service to the whole residence, and it also needs an upgrade. There was then sworn testimony by the assessor that the estimated level of assessment for the current year is 100%, that there was a recent sale of the subject property for $917,900 on December 22nd of 23, but that it was to a related party and therefore it was not considered. There were recent sales of 5 comparable properties that were provided, and they are listed in the Exhibit B that the assessor presented. The assessor also mentioned other factors, including the fact that this building was originally built in 1929 and remodeled in 1980. The kitchen and bath had an average kitchen and bath were average, and the CDU was very good. Because of that sale in December of 23 was not an arm's length transaction, that was not valid, and the market approach as indicated in Exhibit B, was deemed to be the appropriate method for valuation. We then go into the determinations. The assessor's estimated level of assessment for the municipality has been determined to be 100%. The board finds there was a recent sale of the subject property, but A, the sale was not an arm's length transaction. The sale was not representative of the value as of January, and the board finds that the sale does not support the assessment. The Board of Review finds that there are recent sales of comparable properties. The property owner did present testimony of recent sales of comparable properties in the market area. And then under B, if yes, were the attributes satisfactorily adjusted for their differences from the subject and their contribution to value? And we didn't hear any testimony about that, so that would be no. The assessor did present testimony of recent sales of comparable properties in the market area, and their attributes were satisfactorily adjusted for their differences from the subject and their contribution to value. In E, list the properties and values that the board relies upon. Those would be listed in Exhibit B from the assessor. Number 4, the Board of Review finds that the assessment should be based on other factors, and I would say no, we've got the comparables. The most credible evidence presented came from the assessor. So now I'm looking for a motion under D, either 1 or 2.
You want me to do it?
I'll move that, exercising its judgment and discretion pursuant to Wisconsin statute section 7.47, parens 9, parens A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of fair market value of the subject property using assessment methods which conforms to the statutory requirements, that the assessor presented evidence of the proper classification of the subject property using assessment methods which conform to the statutory requirements, that the property owner did not present sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that assessor's valuation is reasonable in light of all the relevant evidence and sustains the same valuation as set by the assessor.
So we're looking for a roll call vote.
We need a second on that.
Oh, sorry.
Second.
Now we have a second. Now we need a roll call vote.
Gary Boyces.
Yay.
Henry Pasbrig.
Yay.
Cindy Schmier.
Yes.
And Mara Spring.
Yes. Okay, so that matter will be concluded. Just one moment, we'll move on to the next one.
I am ready if you are.
Okay. Okay, the recording equipment's working, so we can go ahead and introduce the case.
Okay, just double checking everything. Oh. Okay, introducing the case of Jennifer Lemaster. The property owner resides at West 192 South 6560 Hillendale Drive. The address of the property in question is West 192 South 6560 Hillendale Drive.
Wait a minute. Do we have Gold Drive?
Did I skip one?
No.
No,
No, we just did Gold Drive.
Okay, I'm sorry.
No, that's okay. We've been here a while.
Stop yelling at Mara, everybody.
Okay, so the address of the property in question is West 192 South 6560 Hillendale Drive. The tax key for this property is MSKC 2177.939.005. The property has been classified as residential. The value in the assessment roll for the current year is for land, $135,800, improvements, $852,400, and the total is $988,200. It was brought to my attention that the property owner's name is, the other property owner on there is Brandon Lemaster. It's just Jennifer that is here today. I'm going to swear in objectors and the assessor. Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Would the property owner who just sworn please state your name and address for the record?
Jennifer Lemaster, West 192, South 6560, Hillendale Drive, Muskego, Wisconsin, 53150.
And do you have any witnesses that were just sworn?
Yes, I do.
Assessor, please state the estimated level of the assessment for the current year.
The estimated assessment level for 2025 is presumed to be 100%.
Okay, before we take any evidence, the Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as a taxpayer. Do you understand that?
Yes.
All right, so please state what amount, in your opinion, is the fair market value of your property.
Can you tell me what's stated on the objection?
It says $800,000.
$800,000.
Okay, so now taxpayer, it's your opportunity to present your evidence.
So this property is a large colonial built in 1994 with modest updates. The one update that did occur under my ownership was a bathroom remodel. The subject is older than the comps provided or utilized by the city, and has limited updates. The finishes within the home are a lower grade than what it's assessed at. And due to that and the comparables, in my opinion, not being a comparable, the cost approach should be considered instead as the better approach.
Do you have any exhibits that you'd like to present?
I have one I can email.
And it's not the same picture that we already have, it's from this?
Correct.
Okay. Why don't you go ahead and work on emailing that over? Do you have other witnesses that you'd like to present?
Kathy Lemaster.
Okay.
I'd like her to just speak to the finishes in the home. So the finishes are laminate, there's no granite, there's no marble, nothing like that.
No granite.
All right, so you're sending over a photograph? We'll do the same thing. We'll just show it on the screen and keep a copy in the file.
So the comparables used for this, the subject property has more bathrooms and bedrooms. So in my opinion, the comps don't match up to that. And the cost, fair market value, if I was putting it on the market today, it would not be $988. And in my opinion, the cost approach should be utilized instead to determine the assessment value.
Is this the picture you wanted?
That just shows the condition of the kitchen.
Okay.
Okay, so we've received your exhibit. Anything else that you would like to add?
No.
Okay, so Assessor, do you have questions for the taxpayer?
Yes, the picture that was displayed there, is it more of a condition or quality of finish that you're you're going for?
It's a quality finish, you're correct.
Okay. I mean, it looks like it's the sound, the kitchen's not deferred, it's just dated, is that the point?
The flooring is cracked. I mean, there's definitely deferred parts of the home.
Okay. And I saw that again, it's listed as it related to individuals or corporate affiliates, purchased the property in March 16th of 2020 for $625,000.
Yeah, correct. That is incorrect. I have no relation to Thomas Samodi, so I don't know why that's noted. Last time the city assessment occurred, I had noted that as well. So I believe it was 2021 when I came in and noted that that was not an arm's length deal, and that was supposed to be removed. So.
Okay. And I believe that's the only questions that I have.
Any questions from the board? Okay. Seeing none, Assessor, it's your turn to present your evidence.
Thank you. Nick is currently passing out 3 exhibits. Exhibit A is the the property record card. Assessor Exhibit A contains the assessment data for the subject property. Assessor Exhibit B is the 5 comparable properties that were used through the comparable sales analysis. And Exhibit C is the return sales questionnaire from the purchase in 2020 for $625,000.
March 16th of 2020.
The subject property resides on 1.98 acres of ground. It is a 2-story colonial built in 1994. The kitchen rating is listed as average. The bath rating is listed as good. It has a full basement. It is centrally heated and air conditioned. The physical condition is listed as good. Interior versus exterior is listed as the same. There is 1 prefab fireplace that is a grade of B. The CDU rating is good. 10 total rooms, 7 bedrooms, 4 full baths, 1 half bath, 10 additional plumbing fixtures. There is a rec room size of 900 square feet, and there's a finished basement living area of approximately 1,686 square feet. Moving down the dwelling information right-hand column, there's also an economic factor of 90%, which means that we are removing 10% for the design of the home. The ground floor of the home is 1,400 square feet. The total living area is 5,737 square feet. Moving to Assessor's Exhibit B, the comparable sales analysis. Comparable 1 is 189 South 9055 Creekside Drive. The property sits on 0.41 acres of ground, is a 2-story colonial built in 2007 with 9 total rooms, 4 bedrooms, 3 full baths, no half baths, 3 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned, is a B+ grade in very good condition. The above ground area is listed as 3,412 square feet. We're showing that there is no basement finish. The kitchen and bath ratings are listed as average, and that property sold for $717,000 in July of 2023, approximately $210 per square foot, with an adjusted sales price of $974,400. Comparison number 2 is 155 South 7308 Westfield Way. That property contains 0.37 acres of ground. It's listed as a 2-story colonial built in 2006 with 9 total rooms, 4 bedrooms, 2 full baths, 1 half bath, 8 additional plumbing fixtures. It has a full basement. It's centrally heated and air conditioned. It's a B+ grade in very good condition. The ground floor is 3,292 square feet, or above grade area is 3,292 square feet with no basement finish for a total of 3,292 square feet. The kitchen and bath ratings are listed as average. That property sold for $790,000 in June of 2023, approximately $239.98 per square foot, with an adjusted sales price of $1,056,700. Comparable number 3 is 87 West 17881 Edgewater Court. That property contains .62 acres of ground, is a two-story colonial built in 2017 with 8 total rooms, 4 bedrooms, 4 full baths, 1 half bath, 6 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. It is an A grade. It is in very good condition. The above grade area is 3,775 square feet with 1,800 square feet of finished basement living area. Excuse me. And for a total square footage of 5,575 square feet of finished area. Kitchen rating is listed as average. Bath rating is listed as average. That property sold for $1,075,000 in June of 2023, approximately $192.83 per square foot. That has an adjusted sales price of $965,800. Comparable number 4 is 130 South 9665 Jimmy DeMart Drive. That property contains .33 acres of ground. It is a two-story colonial home built in 2004 with 8 total rooms, 3 full baths, 2 half baths, 1 additional plumbing. 8 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 7 additional plumbing fixtures. It does have a full basement. It is centrally heated and air conditioned. That is an A- grade and a good condition. The above grade area is 3,268 square feet. We are showing that there's no finished basement for a grand total of 3,268 square feet of finished living area. The kitchen rating is listed as good. The bath rating is listed as average. That property sold for $710,000 in July of 2024. That is approximately $217.26 per square foot, with an adjusted sales price of $893,900. Comparable number 5 is 73 West 15102 Cherrywood Drive. That property contains .59 acres of ground, is a two-story colonial built in 2004 with 11 total rooms, 5 bedrooms, 3 full baths, 1 half bath, 5 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned. It's a B+ grade in very good condition. The above grade finished area is 3,217 square feet. We're showing that there is 1,500 square feet of finished basement living area for a grand total of 4,717 square feet of finished area. Kitchen and bath ratings are listed as average, and that property sold for $820,000 in October of 2023, which is approximately $173.84 per square foot, with an adjusted sales price of $964,900. I will make note again that we are using an economic factor of 90%, which is removing 10% of the overall cost value for the design of the home, and we've provided the comparable properties. We feel that the assessed value at $988,200 is the appropriate value given the comparable sales. The other point that I was going to make, we had the sales validation that was returned from the March of 2020 sale for $625,000. It's Assessor's Exhibit C. As we move down, we see that the property was listed for sale on the open market. It was listed as yes, listed by a realtor. Approximately how long was the property listed for sale? The answer there was E, more than 1 year. What was the asking price at the time of the sale? Was $750,000. Was the property a foreclosure sale? The answer was no. There was no foreclosure related to this sale. Question number 5, are the buyer and seller related parties? I brought this up just because the questionnaire that was returned said that yes, there is a buyer and seller that do have a business or personal relationship, and this was filled out by the buyer. And that concludes the assessor's evidence for the property.
Any questions for the assessor from the taxpayer?
Does the price history get considered at all?
The price history does get considered, but we're taking a look at, that's why with the other situations where it has been clear that there's been a related party or a related organization, typically we don't use those as valid sales because there may be some considerations or discounts that are given to the purchaser from the buyer. And that was, with this one, we did have a return sales questionnaire, so it did say that the asking price back in 2020 was $750,000, but the $625,000 purchase price we have as an invalid sale because there is a buyer-seller relationship or business relationship that was reported by the buyer.
Do you go further back than that?
We do show that the home was originally, there was an asking price from November 2019 for $749,900, which was only an asking price. And then we also show that there, in August 28th, 2019, the house had an asking price of $799,000. We don't show any sales data prior to that.
Can I submit data for prior to that?
You'll have a chance for that, but right now it's questions for the assessor.
So can you tell me how the comparables relate, or why the others, like on the other properties we discussed, some of them were not comparable and not considered, and that's where I'm landing in my opinion. Can you just tell me why these were considered, even though the size differs?
So what we are looking at here is that they are 5 comparables. They are all 2-story colonial homes. They are built in roughly the same time frame ranging between 2004 and 2017. The subject property was built in 1994. They all have full basements. The grades do differ, but that is something that's taken into account for the adjustments to the sales price. The total square footage of the living area is calculated including the finished basement area, but when you look at the above grade area, the subject property is 4,051 square feet. The other homes range from 3,217 up to 3,775. So they are approximate in size to the subject property.
Do you consider the age at all? Because the subject property is at a minimum 10 years older than the other comparable properties.
The age comparison between the comparable and the subject property is taken into consideration in the adjusted sales price.
Can you explain how that's taken in consideration? Because the sales price seems high considering the age of the home and the comps.
The age of the home would be adjusted to the age of the home, the subject property. So it would value the subject properties that were built in 2017 or in the 2000s as if they were built in 1994 through the depreciation that's applied.
I don't understand the details of that. If the price is still higher than some of those subject properties, I guess. It seems like
the current price of the home is $988,200. The adjusted sale prices of the comparables range from $974,000. I'm sorry, the low end at $893,900 to the high end of $1,056,700. It's not a comparison of the straight sale price. It's adjustments applied to the adjusted sale price. It's the subject property falls within the range suggested from the comparables.
Can you state that again? I didn't understand.
The adjusted sale price from the 5 comparables range from the low end $893,900 to the high end of $1,056,700. The value of the subject property is $988,200. When we're coming up with the market value of the subject property, we were looking at the adjusted sales prices, not the sold prices.
I know, I'm not understanding how it's adjusted for the age of the home, since this is quite a bit older and it's still coming in higher than some of the comparables.
It's adjusted for the age. The other adjustments, the first comparable was a sale of $717,000. It was adjusted to $974,400. It's listed in a very good condition and a B+. The second comparable is a B+ and very good. That was a $790,000 sale that was adjusted up to $1,556,700. The comparable number 3 is an A grade in very good condition. That sale price was $1,075,000, which was adjusted down due to the condition and quality of the home. to $96,500. The comparable number 4 was a $710,000 sale that was adjusted to $893,900. That is a difference in the grade and the condition in comparison to the subject property. And the 5th sale was an $820,000 purchase price in '23. That was adjusted up to $964,900 for the overall size. The larger adjustments were for the larger size of the home when taking into consideration the total finished area.
I just don't understand how is that calculated?
There's a dollar amount adjustment for each variable or for a percentage that's allowed. So we're looking at adjusting all of these comparables either up and down in grade or condition to make them comparable to the subject property. We're also looking at making size adjustments.
Is that information provided in that PAM that you were the guidelines you were talking about?
It may show the information, but these calculations are adjusted at each market update. So this is something that would be relative to Muskego, the city of Muskego, and not other jurisdictions because.
So it's a generalization, correct, across all properties?
It's
adjustment?
Yes, there is. Yes.
Okay, so it's not considered in the unique situation.
I'm sorry?
It's not considered in the unique situation. The adjustment is a general adjustment based on the citywide information.
The adjustment varies depending on the difference between the grades. So the difference between the higher grade and lower grade, there is a more adjustment. The difference in conditions, there's a different adjustment. So it's not a standard adjustment. It's an adjustment between the data points.
Is that public information? Can I have that information?
I can provide that information.
Okay.
Any other questions for the assessor?
I just would like you to consider looking at the additional price history that I can provide.
We'll get back to that. This is questions for the assessor, right?
Well, will they consider that?
I won't take into consideration anything before the 2019 asking prices that we have. Those sales are too old.
Why well, it's not sales, it's price listing information?
It's price listing information. We look at market data for what properties actually sold for.
So you don't consider what it was listed at and what it eventually sold at?
No, I do not.
Because wouldn't that dictate more market information?
The property
and dictate
sold,
the grade of the home, really. No one was willing to purchase it at a price, and so they continued to lower the price. So wouldn't that dictate?
that would not result in a change of the grade. The grade is a physical and subjective adjustment that's made to the property. We would take into consideration that it was purchased for $625,000 in 2020, but we have a return sales questionnaire that says that there was a relationship between the buyer and seller of a personal or a business relationship. So it would not be an open market valid sale.
Board have any questions for the assessor? No? No? I want to make sure I understand correctly. This subject parcel has 7 bedrooms, and the other ones all have 3, 4, or 5, correct?
That is what the data is showing us, yes.
And then when you calculated at the bottom, it says the market value per square foot, I believe. Toward the bottom, for this property, it's 172.25.
Yes.
How are you calculating that number?
I believe that would be the market value of $988,200 divided by the total finished area of 5,737 square feet.
And then you did a similar calculation for all of the comparisons using the actual sale price versus their square footage, correct?
Yes, it's the sales price of the comparable. So that is the unadjusted sales price to the finished living area. That does not include rec room area, but it's just the straight price per square foot of finished area.
And so if I'm reading this correctly, the subject property has the lowest per square foot value of all of these.
That is correct.
Okay, thanks. All right, any other questions from the board? Additional testimony from the taxpayer.
I would just like to submit that price history.
And are you talking about the price history that's in the exhibit that we already have? The exhibit shows.
No, it's past what he stated, so it's additional price history.
You're talking about going back beyond 2019?
Correct.
Are you talking about actual sales or just some?
No, just price listing
Asking
history.
prices?
Yeah.
Do you have it with you?
Yes, I'm gonna send it right now.
I got an email.
Oh, you did, okay, I sent it already.
And does the email show have any documents showing it, or is this?
It's just dates and, it's just dates and price listing and the changes that occurred.
Okay.
Going past what was stated or provided.
You've submitted this, and I see there's a price history. It says date, event, price, and it says source, public record. Where did this information come from?
Zillow.
Zillow?
Yeah.
Okay. Is there anything more that you wanted to say about that exhibit that you've submitted by email?
I consider it affecting the market value of the home. If I were to put the home on the market as it stands right now, it would not sell for what it's assessed at. Based on the price history and it being lowered continuously from 2018 to when it sold in 2020.
Any other evidence to present?
No.
I would note that the person with you, Kathy, was sworn in, and you asked her to testify, and then you said what she should say. So is there any actual testimony that you want to present from Kathy? I'm sorry, I can't hear you.
I know that she didn't have granite countertops. I think that's what she wanted me to let you know. Then she showed you a picture. It's fine.
Okay, I just wanted to make sure that there was nothing we were missing, that everybody had an opportunity.
Appreciate it. Thank you.
All right, so any additional testimony from the assessor?
Just one question, if I may. Is there additional price listing from Zillow here? Because I have the two asking prices.
If you scroll down.
I have the set price for 2020.
Yeah, it goes back to 2018.
It goes back to 2018.
Correct.
And
The original
2018
listing.
was listed at 947.
Yeah, the original listing price was where it was at, and the previous owner lowered it that point in time.
I just wanted to see
Mhm.
since it was being provided, and I had, what I could see, I already had the information.
Yep.
No question.
Any other testimony from the assessor?
No other testimony from the assessor.
All right, so we'll close evidence.
Thank you.
And at this time, the board can deliberate. Any discussion? Everyone's tired, but we've got to get through this. So I think I'm just going to go through it as approving the assessor. If somebody wants to make a motion later on to do it differently, we can go that route. All right, so we'll go through the paperwork. Sworn testimony was presented by Jennifer Lemaster. Recent sale of the property was not provided. The homeowner did not provide any recent sales of comparable properties. The other factors relied upon by the taxpayer were the fact that the subject property is older than the comparable properties used by the assessor. The only update on the subject property is a bathroom remodel. The finishes are a lower grade than what is being assessed. In addition, the subject property has more bedrooms and bathrooms than the ones listed on the comparables, and for those reasons, the taxpayer is advocating for the use of the cost approach to determining value rather than the market approach. Sworn testimony was provided by the assessor, including that the estimated level of assessment for the current year is 100%. There were no recent sales of the subject property, but there were recent sales of 5 comparable properties, which are listed in Exhibit B. Other factors that the assessor noted was a reduction by 10% as for the design of the home. Then we go to determinations. First, the assessor's estimated level of assessment for the municipality has been determined to be 100%. The board finds that there was not a recent sale of the subject property and that there are recent sales of comparable properties. The property owner did not present testimony of recent sales of comparable properties, but the assessor did. The testimony of recent sales of comparable properties presented by the assessor included the attributes that were satisfactorily adjusted for their differences from the subject and their contribution to the value. The properties and values that the Board of Review relies upon to make its determination are indicated in Exhibit B that was submitted by the assessor. The Board of Review does not believe that the value should be based on other factors, and the most credible evidence was presented by the assessor. I'm looking for a motion either on number 1 or 2 under D.
Okay. I make a motion, I don't know, exercising judgment and discretion pursuant to Wisconsin statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct. The assessor presented evidence of the fair market value of the subject property using assessment methods which conform to the statutory requirements and are outlined in the Wisconsin Property Assessment Manual. That the assessor presented evidence of the proper classification of the subject property using assessment methods which conform to the statutory requirements and which are outlined in the Wisconsin Property Assessment Manual. The property owner did not present sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the assessor's valuation is reasonable in light of all the relevant evidence and sustains the same evaluation as set by the assessor.
You need a second?
I'll second.
Roll call vote?
Gary Boycitz.
Aye.
Henry Posbrig.
Aye.
Cindy Schmier.
Aye.
Mara Spring.
Yes. So that will conclude that hearing. And I think at this point, we're looking for a motion to adjourn till tomorrow.
I'll move to adjourn till tomorrow. 10 a.m.?
10 a.m.
Second?
I'll second.
Okay, all those in favor?
Aye.
Aye. Right, then we're adjourned till tomorrow morning at 10 a.m. Oh, we're adjourning at 8:12 p.m.
All right, we're going to call this meeting of the Board of Review to order. It's September 5th at 10:01 a.m. We will start with the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we start with the roll call.
I'm getting there.
That's right.
I thought I was all ready, but guess not. Gary Boycitz.
Present?
Jeremy Kyle.
Present.
Henry Posbrig.
Present.
Cindy Schmier.
Present.
Mara Spring is absent. She should be on her way.
Yep. And then the statement of public notice.
This notice was posted in accordance with this meeting, was noticed in accordance with the open meeting law on September 3rd, 2025.
There we go. We will proceed to the order of business, which is objections, and we have Daniel Hefts. He'll tell me how to pronounce his name. Come on out, come on down. Hefts, okay, thank you. Good morning.
There is a microphone there. There's a button on the top. You want to push that towards like the microphone head. Yep, push it up.
Then just tap it to see if you're, there we go.
There you go, thank you.
And make sure you speak into the microphone because this is recorded.
Oh, okay. Yeah.
This is number
First tab on number
15.
4, number 15.
After the yellow tab 4.
All the way, yeah. There you go.
Thank you.
Okay, we are going to make sure we are recording. I see 2 red buttons. That's a good thing. All right. And the clerk will read the hearing into the record.
This is the case of Daniel Hafes. The property owner resides at West 204, South 8336 Pasadena Drive. The address for the property in question is West 204, South 8336 Pasadena Drive. The tax key for this property is MSKC 2229.054.001. The property has been classified as residential. The value in the assessment roll for the current year is land at $57,600, improvements $373,200, the total $430,800.
There you go. Well, I'm gonna make note that Mara Spring
Yes,
is
perfect.
here.
Thank you.
Okay.
I don't think, we haven't heard anything, so she can certainly be part of the panel.
Okay, thank you.
All right. Good. Well, just to give you overview how it's going to work, we'll swear everyone in, and then you'll be able to present your testimony and evidence. The assessor and then us as the board of review can ask you questions. Then the assessor will present his testimony and evidence. You can ask him questions first, and then we can ask him questions. Then you'll have a chance to provide further testimony or further evidence with further questions of you. Then the assessor can do further testimony, further evidence with further questions of him. Then you'll be able to summarize your position. He'll be able to summarize his position. We'll close the testimony, and then we will deliberate and make a finding.
Okay, thank you.
All right, thank you. So we will swear in all witnesses.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Would the property owner who is just sworn please state your name and address for the record?
Daniel Hafes, address is West 204, South 8336 Pasadena Drive.
Are there any witnesses for the property who was just sworn?
Do you have any
Are there
witnesses?
any witnesses?
No.
Yep, there you go.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for the tax year 2025 is presumed to be 100%.
Can you put his mic up? Whichever one's his. All right, I'll read out statements, and then I'll ask you to state the, I'll just get started. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you, by testimony, can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as a taxpayer. Okay. Do you understand?
Yes.
Thank you. Please state what amount, in your opinion, is the fair market value of your property.
My property was assessed when I bought it 3 years ago at $386,000.
And what's your opinion of the assessed value, fair market value today?
I'm not an expert, but that's why I'm here. $430,000 seems like a huge jump from that number.
You had written down $386,000 on your form?
Correct.
That's what you'd like it
Correct.
to be listed as?
I've gotten some more information since that, and so I can.
All right.
Okay.
So 3 to 6 is your opinion of assessed value, and we'll take your testimony.
Okay. And again, forgive me, I haven't been in this sort of situation before, so I'm not exactly sure. It started as a fact-finding mission, and I guess it still is, because I've got a lot of unanswered questions as to why. My points being, 48% increase from the last assessment is alarming. The median increase in Muskego we know is 26%, so I'm wondering why mine almost doubled. The comps that I was shown are all condominiums on the lake of Little Muskego. It's all lakefront property. The assessor, the person that I spoke to when I came here originally a few weeks ago, kind of said, yeah, that doesn't make sense. And to me, it doesn't either.
I live at what's called a condo. It's a two-family structure. I'm surrounded by two-family structures, and the information that I've gotten is that those other properties, again, similar structures and similar land, did not go up anywhere close to the 48% that mine did. And so I guess I'm looking to understand why mine did, and specifically in the building. My building assessment went up 51.3%, and I did no appreciable changes to that structure. So I'm not real sure why that would be assessed at 51% increase when nothing's really been done for improvement.
That, does that complete your first testimony?
Yeah.
All right, thank you. Assessor can ask you questions, and then we can ask you questions.
Okay.
I just wanted to confirm, I see that you had the purchase price. It was purchased in May of 2022 for $382,000.
Correct.
And that was an open market sale, that there was no undue influence?
Correct.
Okay. And I believe that's the only question I have.
Okay. Any questions from the board to the taxpayer? Seeing none, we'll move to the assessor who will present his testimony.
Thank you. Nick is passing out the Assessor's Exhibit A and B. Assessor's Exhibit A is the property record card, two-sided, containing the assessment information for the subject property. And Assessor's Exhibit B is the comparable sales analysis and the sales used to value the subject property.
Thank you.
As I just previously stated, the subject property was purchased in May of 2022 for $382,000 for the land and building. It was a valid open market sale. The subject property is a condominium, a two-story condominium built in 1999. We have it listed as an average condition for the kitchen and bath. We have it listed as a full basement. It is centrally heated and air conditioned. The physical condition is average. The grade is a B-. The CDU rating is average. It contains 7 rooms, 3 bedrooms, 1 family room, 2 full baths, 1 half bath, and 3 additional plumbing fixtures. The total living area is 2,457 square feet. Moving to Exhibit B, the comparable sales analysis. Comparable number 1 is 75 West 17720 Harbor Circle. This is a 2-story condominium built in 1993. Contains 8 rooms, 4 bedrooms, 4 full baths, 0 half baths, 2 additional fixtures. It has a full basement. It's centrally heated and air conditioned. It is a B+ grade and very good CDU. The above ground area is 2,265 square feet. We are showing that there is 649 square feet of finished basement area for a grand total of 2,914 square feet. The kitchen rating is average. The bath rating is average. That property sold for $650,000 in July of 2023 at a sale price of $223.06 per square foot, with an adjusted sales price of $174,500. Comparable number 2 is 176 South 7511 Harbor Circle. This is a 2-story condominium built in 1991, containing 7 rooms, 3 bedrooms, 4 full baths, 0 half baths, and 2 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. It's a B+ grade and a good CDU. The above grade area is 2,139 square feet. We showing that there is 800 square feet of finished basement for a grand total of 2,939 square feet of finished living area. The kitchen rating is average. The bath rating is average. That property sold for $820,100 in March of 2024, approximately $279.04 per square foot, with an adjusted sales price of $488,700. Comparable number 3 is 75 West 17678 Harbor Circle. This is a two-story condominium built in 1992. It contains 5 rooms, 2 bedrooms, 3 full baths, 1 half bath, and 1 additional plumbing fixture. It has a full basement, centrally heated and air conditioned. It's a B+ grade with a CDU of good. The above ground area is 1,940 square feet with 690 square feet of finished basement area for a grand total of 2,630 square feet. Kitchen and bath ratings, the kitchen is good, rating is good. That property sold for $785,000 in August of 2024, approximately $298 per square foot, with an adjusted sales price of $440,500. Comparable number 4 is 75 West 17647 Harbor Circle. This is a 2-story condominium built in 1989. Contains 6 rooms, 3 bedrooms, 3 full baths, no half baths, and 2 additional plumbing fixtures. It has a full basement, is centrally heated and air conditioned, is a B+ grade, a very good CDU. The above ground area is 1,961 square feet. We're showing that there is no finished basement in this particular sale. The kitchen and bath ratings are listed as average, and that property sold for $610,000 in March of 2023, approximately $311 per square foot, with an adjusted sales price of $390,300. Comparable number 5 is 177 South 7495 Harbor Circle. This is a 2-story condominium built in 1989. It has 6 total rooms, 3 bedrooms, 3 full baths, no half baths, 2 additional plumbing fixtures. It has a full basement. It's centrally heated and air conditioned. The grade is a B+. The CDU is very good. The above grade area is 1,961 square feet. No finished basement living area. Kitchen rating is good. The bath rating is average. And that property sold for $820,000 in October of 2023, approximately $418 per square foot, with an adjusted sales price of $460,900. And that concludes the assessor's exhibits A and B.
Okay. Thank you. Daniel, do you have any questions of the assessor?
Just some procedural things. What does CDU, what is it?
CDU is a piece of data that we use. It's called the condition, desirability, and utility. So it takes into account the physical condition of the property and also the location and desirability of the design of the home and the location of the home.
Okay. All right. Was there a reason that all the comps that were used on the same street on lakefront property?
So through the comp selection process, we are looking for the most similar style, which would be the condominiums. We have a model that's built just for condominiums.
Oh.
And we're also taking a look at similar size and ages and other amenities for that property. So they're automatically selected based on the criteria that we set, and those were the closest comps that we had for your condominium.
Okay, so it's based, you say condominiums are a totally separate thing. That answers my question of why, to me, the similar structure two-family homes that surround my home, because they have a single owner, they're not considered condominiums.
Well, they could be considered a condominium. They could be considered a townhome. There's kind of there are some similarities between those, but we do have them listed as, or we have you listed as a condominium.
Okay, but is that what makes, if the entire structure is owned by one person, then it does not count as a condominium? Because again, I'm wondering why the comps weren't in my neighborhood of the homes, including 2 homes that were sold in the last 2.5 years.
So within your neighborhood, are there single-family homes and individual ownerships?
There are, yes,
okay.
further down the street.
So those would fall into a different model. Basically, with all the comparables that we're looking at, the selection process is normally, first of all, we're trying to do similar styles. So we're comparing ranches to ranches, colonials to colonials, to multi-story to multi-story, split levels to split levels. So we have it listed as a condominium. So we pull from the comparable sales come from the pool of condominium sales within the jurisdiction.
Okay, and that's, I guess, really is the crux of my whole reason for being here, is to say, in my neighborhood, three other homes, structure-wise, very similar to me, acreage-wise, very similar to me, didn't go up 48%. But you don't count those because they're not counted as condominiums. You're not gonna
Yes,
compare.
we're comparing the condominiums to other condominiums. So the single-family homes in your neighborhood would be, their comparable sales would be drawn from a different pool of sales for single-family residences.
Okay. Is it fair to say, though, that those condominiums, because they are lakefront property, their estimated values would be higher, their assessed values would be higher?
Their assessed values would be higher. Their sale prices are higher, but taking it through the comparable process, there are a series of adjustments that are made for size, grade, condition, the CDU rating, and the finished basement versus rec room, things of that nature.
Okay.
That's how we arrive at the adjusted sales price. So when they make the comparable sales similar to your property, that we're seeing a downward adjustment. So they did sell at a higher value than you're currently assessed at. But when the sales are adjusted, they come in at the adjusted price as a lower or a decrease from their sales price.
Okay, all right. I do have something to turn into the record.
We'll have you
if I-
turn that in the next
Okay,
round of it. Thank you.
okay.
Do you have further questions for the assessor?
No.
Okay.
Any questions from the board to the assessor?
Of course.
Looks like Mara, yes.
Of course
start
I
with you.
do. I note that on your sheet, on Exhibit A, you have market approach, you have the cost at 370, 500, and the market at 430, 800.
Yes.
And you chose to use the market value. Can you tell me why?
We used the market value because we had good comparables. The cost approach and the market approach can vary in value. And we have 5 condominium properties that are comparables, and we're using the market approach because it's drawing directly from the market information.
And you believe that even though all 5 of those comparisons are in the same condominium association, that's an adequate number of comps?
I believe so, yes.
And did you do anything to adjust for the additional amenities that the Harbor Circle condominiums have by being in an association that it's on the lake and it has other amenities versus this condominium, which is a standalone and doesn't have an association?
There's no consideration given to that necessarily. We are just using the sales of the condominiums as comparisons.
So when you decide whether it's an adequate comparison, that's not something you take into account?
So can you elaborate on the amenities are there additional things that are offered from the condominium association, or?
It's my understanding that Harbor Circle, maybe I'm wrong, I think Harbor Circle's on the lake, and they have a private beach and a private lake access. And that wouldn't be available to somebody in a standalone condominium that doesn't have an association, especially this this is like the most exclusive condominium association in Muskego, and all 5 of the comps are there.
Yes.
So that's my concern. So you didn't do anything to adjust for that?
The adjustment for that, again, would be more in the land value that's associated with the condominiums. So by taking a look at it.
At least 2 of these land values are the same or less. So that doesn't seem like that's taken into consideration when I look at it.
Well, they do vary. The lowest value there for the land that's associated is $55,000 up to $105,000 for those the comparables from the Harbor Circle. But that is just the standard process that we don't take a look at unless there's certain amenities. I understand that they may have access to the beach, and that may make them more valuable. We feel that the sales information and the adjusted comparables, adjusted sale prices reflect the market value of the subject property.
All right, thank you.
And, yeah.
So Harbor Circle is unique in that most condo subdivisions have equal land values. Harbor Circle has different adjustments based on if they're in a multi-unit building, where they are positioned according to the lake. There are location adjustments made for, positive adjustments made for those beachfront properties. So our adjustments are taken into account where they are located in Harbor Circle.
That being said, are the ones that, where would I know what you just explained from your Exhibit B? What properties, where is it that it would show that those adjustments are made?
So on the property record card, under land information, you'll see influence factors. It is located in there. Also, I don't have a property record card for Harbor Circle present, but under the economic influences, there are adjustments made for location. So say they are directly in front of the beach, it might be 125 versus something in the back would have a lower than 100, perhaps 80. Those are economic adjustments that were made years ago based on the location, views, that kind of thing. If you look on the comparison number 1 sheet, below the total SFLA of 2914, you'll see a number of 125. That's an eco percentage for location, so that property has a positive adjustment based on their location.
All right.
Same thing with comps 4 and 5.
All right, that's what I was looking for. Thank you.
The subject property in that same line says NBHD factor. What does that mean?
So due to location of the subject property, they have 2 influence factors that are lowering their land value. Under land information, due to shape and size, economic misimprovement, it was determined that they took a 60% reduction in the land value. Also in their economic factor based on the neighborhood, perhaps because it's a unique structure in that neighborhood, a decrease in value was applied as an 80% economic factor.
So 80%, you only took 80% of the value?
That's taking 20 off, right? Yes. Yeah, it's taking 20% of value off the structure based on the neighborhood.
And that's for the structure?
For the subject property.
And then the influence factor, it says minus 60, and that's for the land?
Correct.
I'm curious on comparison 1, it says excess adjustment, and it's got an adjusted price of 174, so curious why that's such an outlier, and if it's such an outlier, why it would be included in the comps?
So statistically, the comp is comparable. It is excessive adjustment, which is just a warning, because you'll see that the sales price of $650,000 was adjusted down to $174,500. So we're showing that it is a difference between the grade of a B plus and a B minus, the condition of very good versus average for the subject, and then the also the adjustment for the basement and the neighborhood factor. So it's taking those into consideration, and it's just telling us that it's adjusting that sale more based on some of the additional factors from the property itself.
Okay, got it. For 2022, 2023, and 2024, do you have any data related to the average increase in market value in the city of Muskego? You basically have 3 calendar years between the purchase price and the date that we're valuing this.
I don't have those numbers in front of me. I can make an estimate of what I believe it
I'll
to
take
be.
your estimate.
So in 2023, I believe it's decreasing, but it's still a positive increase in value. From the other communities that I've worked in and Muskego, from the sales, starting back after COVID in 2020, we saw significant increases of about 15 to 20%, depending on the jurisdiction and real estate value. That slowly declined. I would say from 22 to 23, we're probably about a 12% increase in average market value. 23 to 24, I would say it would have declined to about approximately 9%. And then we're also currently looking at about 24, still an appreciation in value, but the values are backing down a little bit. I would say there's probably around 5 to 6% average increase in annual value.
So adding that up in the fair market value, not assessed, but in the fair market value for that 3-year time frame, roughly a 25% increase in fair market value within Muskego is what you're seeing? Approximately,
in a general way, I would agree,
Yep,
yes.
okay. Thank you. I'm looking at the 4 properties, 2, 3, and 4. I'm going to ignore the excess adjustment one on number 1. But looking at those properties, those 4 were valid sales at 820,000, 785, 610, and 820,000?
Yes.
Okay. And then the subject property, the comparisons is based on the sale price of those properties?
The adjusted sales price.
Adjusted sales price?
Yes.
Okay, got it. And then all 4 of those properties, their assessed fair market value appears to be 23% lower than their sale price. Is that correct? So the comparable to the fair market value is listed at 540,000 on the city website. Number 3 is listed as 547,000 on the city website. Number 4 is listed at 504,000, and number 5 is listed at 587,000. Is that correct?
And you're looking at that from the current listing?
The
of
2025 parcel listing. I suppose I could get to the open book even quicker, but
I can't verify it off the top of my head necessarily. If that is what they are assessed at, then if that is what you pulled it from, then I would say that is accurate, but I don't have their cards in front of me to confirm that.
Thank you. Any further questions to the assessor?
Do you want it?
Yeah, we'll try to find Harbor Socorro. Yep. Any further questions to the assessor? All right. You can present then any further testimony or evidence that you might have.
I will. I'll pass out this, and I realized counting I'm short a couple. So.
Harbor Circle. Is it by parcel? So tax key by Harbor. Tax key 21939.
Oh, we have this.
9-3.
Some of these Harbor Circle ones. Yeah, it's in like 2193. Right.
So it looks like you all have the front page already. That was my original, the questions that I had. Some of them have been answered through this, but the second page especially, and I guess I am going to continue to talk about the comps being lakefront property versus the similar homes and acreage that is in my own neighborhood. These are the 3, my property is the first one on the left, and then the 3 other ones are the homes that surround me. I looked at the 2021 versus 2025 land, building, and total assessment differences. The greatest thing that sticks out, my total was 48%. The person right next door to me, extremely similar, building structure and size, land size, only went up, less than 12%. Across the street from me was 42%, and then across the street and one over was 34%. The biggest issue that I have, I guess, or the biggest question that I have is why did my building appreciate an assessment 51.3% when there was no changes made? So that's I guess my biggest question, and I dispute that.
Can I respond to that?
Let's do that. Yeah, go for it.
Okay. So basically, you purchased the property in 2022, which was after the last revaluation.
Correct.
So your assessment was significantly below your purchase price, which is the market value. You may not have made any changes to that property, but the value was based on sales from 2019 and 2020 at the last revaluation. So the increase now, we're looking at an updated model using new comparables, and we're capturing the change in value of properties over that period from the last revaluation. So the previous revaluation was in 2021 using 2019 and 2020 sales. We're now using 2023 and 24. We're realizing an increase in assessed value from the comparison of the assessments to the market, and the market has considerably increased over the last 4-year period.
Certainly. I'm no debating that whatsoever. Trust me, I know. But I guess I'm still wondering why, out of these 4 in my neighborhood, if the 4 similar building structure homes, similar land size, why did mine and mine only, the building assessment increase so largely? It just doesn't seem correct.
Again, it's the sales that we're comparing you to. So if we're using the condominium sales and your condominium, if those are townhomes or if they're duplexes, then they would be looked at as other duplexes.
Okay.
We don't typically look at condos versus duplexes because they're kind of they are very similar in nature, but there are differences between condos and duplexes. So
Okay.
they're pulling from a different pool of sales, and they're being valued differently than a condo would be.
Okay, so I guess that really does get to the crux then of my being here, is that really a fair assessment, the comps that were used versus, if you will, the comps that I'm showing here, that are similar structures in my neighborhood, right next door to me? Why do we not use those comps versus ones that are on lakefront property? Regardless, and I respect what he's saying about, that there's an adjustment made. I don't know what that adjustment, how that's figured out, what the formula is. Is that formula fair versus where I live off the lake or not?
Yeah.
That's really the end of my argument.
It sounds like you've completed that part of your testimony.
Correct, yes.
Any questions from the assessor to the taxpayer?
So, and I just want to clarify, the second page of the handout that you provided here, these are the comparable sales, or these are the properties around you?
These are the assessments of the properties around me.
you, okay.
Yeah.
And with that, you're just looking at the overall percentage of increase in their assessed values versus your assessed values?
Correct.
Okay.
Correct. Yeah, I'm not looking at sales, I'm not looking at anything, I'm looking strictly as the assessments that were done in 21 versus 25.
Okay, or no, I just wanted to make sure I
Yeah.
understood that.
Yes.
That's the only question I have.
Yeah.
Any questions to Daniel?
I have one.
Go for it.
I just wanted to make sure I understand this is a condominium on Pasadena Drive. Do you have like a is it just that one individual structure is the condominium?
On all of Pasadena Drive, even though the buildings are the same, where I am is the only two, they're side-by-side condominiums. It's the only ones considered condominiums because we're separate owners.
Okay.
The other buildings that I'm showing on here are, like I said, they're two-family, but they're owned by one person.
Okay, and then do you pay some kind of HOA fee or some kind of general condominium?
But
Do you have
between,
like
yes, between the two of us, the side-by-side, yes, we have our own HOA, if you will, and that we contribute monthly, $300 monthly to the cutting of the grass, snow removal, things like that.
So you have official condominium documents for your building?
Yes, correct.
And are there any type of, what do we call them? The benefits or the general,
No,
nothing?
no,
Just, okay.
nothing.
Just.
It's just,
I
yeah,
understand how
it's a pool of money that we keep to share for the
Right. So
combined
you have
cost of things.
you have the reserve fund set up for things like the roof and the big things that
Correct.
have to be paid for
Yes,
jointly?
correct.
Okay.
Yeah, we just found out we had radon, so we had to buy radon removal, so that came out of that fund.
Okay,
Yeah.
thank you.
I have a quick question, doing some math here, though. Right, so you're talking about the assessment change, which is understandable. At the same time, you did purchase the property for $382,000.
Correct.
$382,000, which you purchased it for 2.5 years before the assessment date, to $431,000. That's a 13% increase. Would you say that 13% increase is fair?
Say that again, I'm sorry.
So if you look at the purchase price compared to the 431, that's a 13% increase over
Correct.
that 2.5 to 3 year period.
Okay.
Is that
I'll trust your math,
13%?
yeah.
Yeah, is that 13% increase fair in your opinion?
Compared to what I'm seeing as just simply assessed. Purchase price is one thing to me, assessment is a different thing. From the assessment standpoint, it doesn't seem to make sense.
Got it, thank you. Second testimony and evidence from the assessor?
Yes, actually.
I'm sorry, we had
Oh, yeah.
further questions.
Maybe it's been answered, but.
To Daniel? Questions to Daniel? Okay, thank you.
Oh, I thought it was.
Well, I guess I can ask the same question.
Okay.
Item 4, the two-family home across the street from you. How different is that home from what you have? Is that a condominium?
No, I'm in the only condominium structure on the entire street, but they're all two-family homes, side-by-side two-family homes, what you call a townhouse or what have you. They just have one owner, and so from what I'm understanding, that omits them from being considered a comp to mine, even though the building itself is similar, the land is similar.
All right. And that's all.
Yeah.
I have one more. Did you get an appraisal done when you purchased the property?
Yes, I did.
And it came in at value
It came
at
in
what you purchased it at?
382, I believe.
I see it listed, you have it at 386 listed.
Oh,
on your
386, yes.
property
Purchase
assessment.
price was 382, assessment was 386.
Mara, do you have a question for Daniel? No. Then we'll have the assessor with his testimony.
Yes, so I was just going to point out, and you kind of beat me to the punch on that one. I did want to correct one thing. The prior assessment, and you may be describing your appraisal, but you called it the assessment. The assessment
appraisal,
prior
yeah.
to this increase was $291,000. So the difference between the $291,000 and the current value of $430,800 is a 48% increase. But as you stated, he has an appraisal and he purchased it in 2022. When you look at that, it is a 13% increase, which averages out to about 3 to 4% a year, which would be kind of typical for the increases that we're seeing within the community. But also, I would point out that the basis of the opinion of value is based on market information. So the comparison of my assessment versus this assessment, this increase versus that increase, it doesn't establish a market value for the property itself. We rely upon the actual sale prices of the comparable properties, and to look at homes that had not sold, just the increase or the decrease in the assessments themselves is not an indicator of market value. It's just the differences. And as we discussed yesterday, we don't do a blanket increase across the jurisdiction. Not everybody goes up 25%. Our average was 25%, but a lot of the cases that we heard yesterday were 60 to 70% increases because those neighborhoods were severely undervalued considering the sales that we had. So it's not a apples to apples comparison to look at assessment increases percentage wise to a subject property without looking at the market value information.
Any questions from Daniel to the assessor?
No.
From the board to the assessor?
I have one. It sounds like the neighborhood where he lives is numerous two-family dwellings. This one happens to have converted to a condominium structure versus a side-by-side where one's being rented. Would you be able to tell whether those other two families are assessed similarly or if he's being treated differently because it's a condo versus side-by-side rental?
Well, so we could, what I would point out is the information provided by the owner. If you look at his home, even though he is similar, his assessment is the $430,800. The other three properties that he provided are listed at between $533,400 and $640,000. So they are assessed differently. We are keeping him in the condo pool and treating him as a condo. But from the assessed value, a condo, in our point of view, the market value would be lower, even though they are significantly higher value on the neighboring properties. They are being treated differently and they are arriving at a different value or market value.
I guess maybe I'm not asking my question correctly, but if I'm seeing a row of buildings that all look physically the same on the outside, they all have the same layout on the inside, building one is owned by one person and rented out to two people. Same for 2 and 3, but now building 4, they've decided to sell each one as a condominium. I would expect the value of 1, 2, and 3 to be similar to number 4. Is there a reason that they're different?
Do you want to answer that, or?
I believe you're describing a duplex versus a condo situation?
Yes, he's saying that his neighborhood is basically all duplexes.
Well, if you have a duplex, you are generating income if it's owner occupied. You are covering your mortgage with the rent next door, whereas with a condominium, you're paying extra fees for your association. There are pros and cons when in the market when people look at those factors. So they are valued differently, and the market shows that.
Do you know if these other three that are listed are the side-by-sides that are in his neighborhood? I guess I should have asked him that.
Yeah, they are, all those are. There's actually 5 of them in the neighborhood, so I wanted to correct you when you said the entire, no, it's 5 out of the 31 lots are.
Any further questions for the assessor? Go for it.
I have, just to make sure I'm clear, so the other 3, I don't know if this is for the assessor or the owner.
You can ask me.
The other 3 that are listed by the owner on his exhibit, the 640, 610, and 533, those are for the whole duplex, correct? That would be for both units.
Exactly, yes. So when you say that, then it's almost as if my building structure should be doubled, and it would be 861. So that's quite a bit higher than what the assessments would be for the similar size building and similar acreage.
Okay, I just wanted to make sure I was understanding that correctly. Thank you.
Good. Then you can summarize your position if you'd like.
Yeah, just to summarize again, just to repeat myself, I feel very strongly that the comps that were used don't reflect the area where I live and my building structure. It's much closer, comparable to the 3 that I've listed here in my exhibit. And so I would ask the board to take that into account and maybe rule in my favor.
Thank you. And the assessor?
Yes, I would say that the analysis that's been performed, the value that we've generated is based off of comparable properties. They may be in a different location with different amenities, but they are condos to condos. The previous purchase price from 2022 of $382,000, again, is a 13% increase to the current assessment of $430,000. We feel it's an accurate reflection of the current market value, and we feel it's a fair and equitable assessment.
Thank you. Thoughts and deliberation?
Evidence is closed.
Yes, thank you. Testimony and evidence is closed. Go for it. Yep.
Thank you.
Oh, you're still here. You want to hear how we do? Yeah. We're going to tell you quickly.
Oh, right here. Okay.
Comparables that are duplexes, item and a half, you know, to what he is. Don't have it
Yeah,
on.
because it's on the open record. Yeah.
Okay, so if we look at the 3 that the property owner has provided as comps, they're duplexes. If we divide those in half, each duplex is worth, or each side is worth between $280,000 and $320,000. So that is quite a bit different than what his one unit is assessed at.
I say, though, it's tough
But that's
for us to
hard
make.
because it's a different type of property.
Yeah, it's a different type of property, and it's assessment. It's he hasn't presented any comparable sales
Right.
at all. I mean, the only comparable sale we have, which is out of date, is his purchase, and it's only a 13% increase from the purchase price.
Correct.
Which is where I'm personally leaning towards.
That's kind of what I'm looking at. I agree with your confusion, okay? You have 2 of the same buildings, they're just a different name only, and then you're using these comps. But if you do the math, like was both stated by the assessor as well as you, when you question him, it's only a 13% only. It is a 13% increase. And maybe if the comps were used right, wrong, or indifferently, I think they arrived, Mara just indicated, and we agree that they arrived at a comparable number that appears to be justified regardless of the comps that they've been using. So from that standpoint, their number is correct, at least from my standpoint.
Yeah, I mean, I agree with Gary. I think the number is right based on the increase from the previous sales. But I don't think it's right at all to use 5 comps from Harbor Circle to compare to this 2-family home on Pasadena. I don't think they're comparable in any way. I mean, it's a condo really in name only. It's a two-family with none of the other features of a condominium association. So I feel like wrong method, right answer, and I don't know how that puts me for voting. Like, what do you do?
I feel like you got something, Henry.
I kind of think I'm on this same leg, that you're using, you know, you have a two-family condo that you're renting out a half, and you got the other half that two people own. What, in reality, what is the difference? But now, is this the methodology that's used for assessing that's the problem?
Yeah, I just think.
You know, are we back in that category?
I feel like we have a couple of these where we've got a couple of these condos that.
And we're starting to sit, this is the second or third one of these we've seen.
Right. I'm wondering and thinking that in the future, maybe it's against the statutes, but if there could be understandable exceptions made of this should be classified as a duplex and not a condo. And maybe I'm wrong, but it's been feeling like that.
Or vice versa.
The duplex is more fitting for this one in particular and a few of the others.
Maybe it's hard because it should be a condo, but there should be similar without an association. If there's enough of them out there without an association, maybe there's a way to do that. I don't know.
Just you guys can't do that because you're stuck with just these two numbers.
Right, yep.
If you feel though that based upon what the taxpayer said, that the comps aren't right, then the answer would be, if you feel that way, he has possibly proved the assessor is incorrect. But you're struggling again, as we did yesterday, with the entire situation.
So if we say that he has proved the assessor is incorrect, we don't have to go with his number, or we do? That's the problem.
It would be difficult. The answer is you don't have to go with his number, but it would be difficult to justify that, especially on an appeal. We feel that he proved his case, but now we're going with the assessor. So you're now picking your own value, and that's what you can't do. If you feel he's correct, it's his number. If you feel the assessor's correct, it's the assessor's number. I know it's difficult, but the law is the law.
Yep. I'm looking at the decision.
So there's no, I'm sorry to interrupt, so there's no.
We'll just hold on. Yeah, thank you. I'm looking at the decision we get to make, and we can check one or more of these boxes where we can say that the assessor's valuation is correct, that he presented evidence of the fair market value using assessment methods which conform to statutory requirements, which I believe he did. We don't have to check that he used the proper classification unless.
That is correct. Then now you're making a case for why you're saying that the taxpayers might be right, but the assessor's number is wrong based upon what you're saying. So now you're making a case, is what I just said. How do you prove?
When we say classification, I'm just going to ask the assessor this quick. When we say classification, is that agricultural, land, resident, commercial, or is this like anything beyond that?
So the classification to us is more the property type, so it would be residential, commercial, or agricultural, but I think that would be more, I think it could be expanded to if you were using the correct classification of the property itself, the condo versus the duplex.
Okay, thank you.
But Jeremy, isn't it also possible that you could go under number 2 and not check all the boxes? And not check the box that the property owner's valuation is reasonable in light of the evidence?
So you want to say he's correct, but then apply the same number? Now I want to say he's mostly correct, but apply the same number? Yep. I think the valuation, the first box, is what matters most in my mind. So I think we need to make a decision on whether the evaluation is correct or not correct.
That's the crux of the whole, that's the main one, is correct or incorrect.
Personally believe the valuation is correct. And I haven't seen any comparable sales that have dissuaded me.
Yeah. I agree.
Okay. I'll make the motion and go through the findings of fact. All right, we have here under the findings of fact, determinations and decision, the property ID and owner. There was a timely notice of intent to file. There was no recent sale of the subject property presented by the property owner. There was no recent sales of comparable properties presented by the property owner. Other factors presented were related to the condo versus duplex classification. Then the estimated level assessment for the current year is 100%. There was no recent sale of the property. There were 5 comparable properties presented by the assessor. I don't think there was any other factors. It was all through the property comparable sheet. So I'm saying no there. There was no recent sale of the subject property. There are recent sales of comparable properties. Did the property owner present testimony of recent sales of comparable properties in their market area? I do not believe so, no. Did the assessor present testimony of recent sales of comparable properties? Yes. Were the attributes satisfactorily adjusted for their differences from the subject and their contribution of value? I think I have to say yes with what we're going to do. Should the assessment be based on other factors? No. What was the most credible evidence presented? For me, it's the subject property sale and the comparable sales. So I will move that exercising its judgment and discretion pursuant to Wisconsin Statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that they presented evidence of the fair market value using assessment methods which conform to statutory requirements. I am not going to check that the proper classification was made. I'm going to check that the property owner did not present sufficient evidence to rebut the presumption of correctness. The assessor's valuation is reasonable, and that we sustain the valuation as set by the assessor, and that it is not relevant to present assessments of other properties as a basis for the market value of the subject property. So I'll make that motion and take a second if anyone would like.
I'll second it.
Cindy seconds, and we'll do a roll call vote.
Gary Boycitz?
Aye.
Excuse me, sorry. Jeremy Kyle?
Aye.
Henry Posbrick?
Aye.
Cindy Schmier?
Aye.
Mara Spring?
Aye.
Thank you. All right, the assessment stands at the 430,000.
Okay, thank you.
Thank you. I see Brian here, and you were at 11, but we have a 10:30 we need to get to. So, thank you for your patience.
10:30 a phone call?
Mm-hmm.
Yep. It's a phone call.
Yep.
And he is number 16, next one. Yep. Chad is listed. He's got his objection, and he had his requests to testify by telephone already approved by us.
And he has not been notified?
About that?
Yes.
Yep. All right. Thank you.
Hello, this is Chad.
Hey Chad, this is Jeremy Kyle. I'm the chairman for the Muskego City Board of Review.
Very good. Hey, hello.
Hello, thank you for your patience. We just finished our 10 o'clock hearing. You had requested to testify by telephone, and we have approved that request. So we will proceed with your hearing here through the telephone.
Okay.
All right.
Sounds good.
There's a few things we need to do. The first is our clerk will read the hearing into the record.
Is your recorder on over there?
Oh, yes, let me check on the recordings. Yep, we have recorders on.
Chad, can you hear me okay?
I can hear you.
Okay. I'm introducing the case of Chad Getz. The property owner resides at West 219 South 10445 Kelvin Court, The address of the property in question is West 219, South 10445 Kelvin Court. The tax key for this property is MSKC.
That's correct.
The tax key for this property is MSKC 2282.996.007. The property has been classified as residential. The value in the assessment roll for current year is land at $153,000, improvements $559,200, the total $712,200.
Okay. To give you a preview of how this will go, you will get to first present your testimony and evidence. Then the assessor can ask you questions and the board of review can ask you questions. Then the assessor will be able to present his testimony and evidence. You'll be able to ask him questions first, followed by the board of review. Then we'll repeat that. If you have further testimony or evidence, you can present that and we can all question you. Then the assessor can present further testimony and evidence, and you can first question him, followed by the board of review. Then you will get the chance to summarize your testimony, followed by the assessor summarizing his testimony. Then we'll close the testimony, and we as the board of review will deliberate and come to a finding.
Okay.
All right.
I'm going to be swearing all the...
So first we're going to swear in the you as a witness along with the assessor who is here.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? And that's you too, Chad. Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Would the property owner who has just sworn please state your name and address for the record?
All right, my name is Chad Getz. Property address is West 219, South 10445 Kelvin Court, Muskego, Wisconsin.
Thank you. Do you have any witnesses for your property that have been sworn in?
I do not.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for assessment year 2025 is presumed to be 100%.
Chad, could you hear him okay?
No, I couldn't hear anything.
He's coming, just a moment.
Okay.
The estimated level of assessment for the assessment year 2025 is presumed to be 100%.
Perfect. Now, Chad, I want to read a statement to you to make sure that we all understand the basis of our decision. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as a taxpayer. Do you understand?
Yeah.
All right. I'll ask you, Chad, to please state what amount, in your opinion, is the fair market value of your property.
$550,000.
I have you listing down $545,000 on your objection to real property assessment. I'd like to confirm which of those two you believe your assessed value is worth.
Sure. Sure. I'll say $550,000.
All right. I'm just gonna mark on there, $550,000. Excellent. I'll have you then present your testimony and any evidence that you have.
Okay. Sounds good. Well, I guess I'd like to first start off. I know you guys do comparables and you know, you have to do something to get your assessment. But my property is very unique. When I bought it 14 years ago, I bought it for a few reasons. And one of the biggest thing with my property is 5 acres, which everybody says, oh, that's great, 5 acres. But I have 4 acres of it is pretty much unusable. So I have a Trans-Canada gas line, three pipelines that run from the whole length of the property, over 1,000 feet, all the way through my property, the whole length of it. And that takes up over 50, well actually it takes up 100 feet of my property right in the middle where I can't build anything, I can't plant a tree, I can't do anything with it. The only thing I can do, and it works for me because I have animals, I have a pasture, and I have animals in there in the pasture. And then, so that takes up quite a bit of my land base, like I said, the whole length of my land. Secondly, I have about 4 different wetland areas in my property that are, again, unusable and works for me because I use it for animals and so forth. And so when you do comparables, none of those other properties have anything even close to that, which I looked at. And so that leaves 1 acre with my house and around it. So that's about all I can do. And I put 1 acre, so I have a house, and then I have a barn that I use that has gravel in it that I use for the animals, for hay, for storage, tractors. And that's it. And then my property itself, it's a non-approved, it's an undeveloped lot, so I have no water, no sewer. I have a well and septic. We have a private drive to get in, so we have to pay or do all of our own plowing to get in there. We don't have, not like everybody else that you had on there, where they could just walk out to the end of their driveway and it's already plowed. We have a quarter-mile driveway that we have to take care of, so that means asphalt, sealing, plowing, and any maintenance that's on it at all. So that's another unique part of the property. The other thing is the thing is I built the house myself, and so I know what the value of it is, and I did it to save money. I did all the trades on it, and I basically built my house and land lot for $388,000. So now you're trying to say that it's worth $712,000. And then besides that, what else? Oh, and then the other thing with the house itself is, so it's over 13 and a half years old. No improvements in the house except for maintaining it. So, I mean, I basically painted it, same roof, same siding. I have a gravel driveway. There's no concrete. So there's no improvements there. So that is why I believe that my property is overvalued, and I don't want to be overvalued, and I plan on staying there. We plan on staying there for the rest of our life. So that is my reasoning.
All right, thank you. The assessor is here. He can ask you questions.
Sure.
Thank you, Chad. I just have one question. I believe you've kind of already answered my first question here. You did say that you do have some animals that you keep. We do have 2 acres of tillable grade 2 land on the property, so it's not actively being farmed, but you are raising animals. Is that correct?
Yeah, no, it's being farmed, so it's hay. It's hay and pasture.
Hay, okay. Thank you. And another question, you had mentioned the value of $388,000. That was the cost to build the home?
That was the total cost.
I'm sorry, that was what?
That was the total cost, home and lot package.
Oh, so you purchased the lot and built the house for $388, or I'm trying to understand. $388 is not what you paid to build the home. That was to purchase the land and to build the home?
That's correct.
And that does not, you built the home yourself, so that does not include any labor costs?
I built the home myself, so it's all my labor.
Okay. I believe that's the only questions I have.
All right, any questions from the board to the owner?
Just for clarification,
Real quick, can you hear Gary there? I think just.
Faint, but I can hear him.
Yeah, come on, come on closer. We'll just all ask questions.
Did I hear correctly that you have some pipelines running through the property? Is that correct?
Yes, I have, major natural gas lines. They're 10, 12, and 14 inches in diameter, and they run the whole length of the property. And that's on, if you look on my survey, I sent the survey and it shows on there.
Are they above ground?
No, they're below ground, but again, we can't do anything. I can't even detail it because there's so many restrictions on it.
Are you receiving any income from anybody?
No.
For those?
No, I'm not.
All right.
It would be the same thing as like a gas or electric easement from We Energy.
All right. Just asking. Thank you.
Sure.
Any further questions for Chad?
Carrie, did you get that survey? My only question is what did he send materials in that we didn't get?
Do you have a copy of that survey, Chad? Have you sent that in at all?
I sent it in. I sent it in to you because when I originally talked to Dean, he asked for it.
How did you send it? Did you email it to me? I'm Carrie, by the way.
Okay. Hey, how are you? Wherever I believe I sent it to the assessment. I'm not sure. Wherever he told me to send it, that's where I sent it.
Okay.
But the survey is on file.
Yeah, we're gonna see if we can pull it up, I think, but.
Sure.
Is that all he sent?
Say again?
Is that all he sent?
Is that all you sent was the survey?
That was after my discussion with Dean, I believe his name was. That was the only thing he asked for.
Okay.
I just want to make sure we got everything.
Well, we'll do that later. Any other questions for Chad?
No.
So we're next going to have the assessor present his testimony and evidence to us. I'll let you just speak up real quick if you don't have a chance to hear him.
Okay.
Thank you. I have Nick passing out Assessor's Exhibit A and Exhibit B. Exhibit A is the two-sided property record card containing the assessment information for the subject property. And Exhibit B is the comparable sales analysis and the homes that were used to value the subject property. So beginning on the first page.
Those are the same comparables that were sent to me.
Yes, those are that would be, is it the 5 comparables?
Yes, the 5 comparables. Sure. Did you receive those through your open book?
I did, yes.
Okay, yes, that's the same sheet that I'm referring to. Okay. So I would refer first to Assessor's Exhibit A, the property record card for the subject property. This property does sit on 4.98 acres of ground. We have that listed as a 1 acre home site for the improvement. We have that listed as 1.98 acres of residual ground, which is undeveloped ground. And we also have 2 acres of tillable grade 2 for the agricultural use established on the property. The subject property is a 2-story colonial home built in 2011. We have it listed as average condition on for the kitchen and bath ratings. We have the centrally heated air conditioned. We have it in a good physical condition. We're showing that there is 1 prefab fireplace. It is a grade of B+ and is a CDU rating of very good. Total rooms are total 7. 3 bedrooms, no family rooms, 2 full baths, 2 half baths, 4 additional plumbing fixtures. The total living area of the home is 2,814 square feet, and we are also showing a pole building built in 2020 that is 32 by 60, or approximately 1,920 square feet. Moving to Assessor's Exhibit B, looking at the comparable sales. Comparable 1 is 101 West 21488 Maney's Court. This property resides on 1 acre of ground, is a 2-story colonial built in 2023 with 4 total rooms. 7 rooms, 4 bedrooms, 2 full baths, 1 half bath. It's a full basement, centrally heated and air conditioned. It is a B grade in very good condition. The above grade area is 2,620 square feet. Kitchen and bath ratings are average. That property sold for $770,000 in July of 2024, approximately $293.89 per square foot, with an adjusted sales price of $717,200. Comparable number 2 is 125 South 8370 North Cape Road. That property resides on 0.93 acres of ground, is a 2-story colonial built in 1999 with 8 total rooms, 3 bedrooms, 2 full baths, 1 half bath, 5 additional plumbing fixtures. It has a full basement. It is centrally heated and air conditioned. It is a B- grade an average CDU. The above-ground area is 2,605 square feet. Kitchen and bath ratings are very good. That property sold for $600,000 in July of 2023, approximately $230.33 per square foot, with an adjusted sales price of $669,400. Comparable number 3 is 216 South 10891 Crowbar Drive. That property contains 3.79 acres of ground, is a 2-story colonial built in 2000, 7 total rooms, 4 bedrooms, 2 full baths, 1 half bath, 3 additional plumbing fixtures, a full basement, centrally heated and air conditioned. It is a B grade in very good condition. Above grade area is 2,338 square feet. Kitchen and bath ratings are average, and that property sold for $770,640 in May of 2024, approximately $329.62 per square foot, and with an adjusted sales price of $783,640. Comparable number 4 is 91 West 13933 Boxhorn Drive. Property contains 0.92 acres of ground, is a 2-story colonial built in 1999 with 11 total rooms, 5 bedrooms, 3 full baths, 1 half bath, 5 additional plumbing fixtures, has a full basement, centrally heated and air conditioned, is a C+ grade in good condition. The above grade area is 2,994 square feet. Kitchen and bath ratings are average, and that property sold for $530,000 in June of 2023, approximately $177.02 per square foot, with an adjusted sales price of $659,300. Comparable number 5 is 99 West 14923 Keeley Court. That property contains 2.76 acres of ground, is a 2-story colonial built in 1994 with 7 total rooms, 3 bedrooms, 1 full bath, 1 half bath, and 5 additional plumbing fixtures. Has a full basement, is centrally heated and air conditioned. The grade is a B- in good condition. Above ground area is 2,100 square feet. Kitchen and bath ratings are average. That property sold for $650,000 in April of 2023 at approximately $309.52 per square foot, with an adjusted sales price of $705,300. And that concludes the assessor's evidence.
All right, thank you. Chad, do you have questions for the assessor?
I do. What is an adjusted sales price?
The adjusted sales price, whenever we're using the comparables, we're taking into consideration differences between your home and the sold property. So if your home is larger, we are adjusting the sales price up. If there is a better, greater condition between the sale and your property, we're making adjustments to the sales price. So after all differences are accounted for between the properties that sold and your property, there are adjustments that are applied to either adjust up or down on the sales price whenever the sell properties are brought to be comparable to your home.
Okay.
What other questions might you have for the assessor?
Nope, that's all.
Anyone from the board, questions for the assessor?
How much effect does this pipeline easement have on the land value?
And then real quick too, we're just gonna, we have a survey from the city from 2011.
I thought it was 2021.
It says 2011. From 2011, so it's the official survey from 2011, I assume, from when you, because it says proposed. We're gonna put that evidence into the record. I assume it'll be towards the, I don't know if you have to mention the property owner's evidence.
The document says that the survey was done in 2011, but there's writing on it from 2020.
Oh, there it is. So there's writing. Okay.
He did not get any.
Okay.
Adam just pulled this.
Sure.
Yes,
All right. So to give you an update, we don't see record of receiving the survey email from you, but we do have this plat of survey prepared for Chad and Jenny Getz from Edgeworth Surveying. Is that the survey that you're referencing?
That's the survey, yeah.
Okay. All right, I assume you want us to put that into the record as evidence on your behalf?
Yes. Yes, because I know it shows 1.9 acres of tillable land. That's pretty much that whole area of that, where that gas line runs through.
We'll send it to you as well, just to confirm, but we've got a question for the board to the assessor. Yes.
So the question was, that there's clearly an easement depicted on the survey through this property. How much effect does that have on the land value?
So the easement would affect the area that would be built upon, so there are adjustments made. We do have, as I gave in the land breakout, the 1 acre home site for the home and any improvements. We do have 1.98 acres of residual ground, which is undeveloped and considered to be unbuildable. And we also have the 2 acres of tillable grade 2. So the easement itself would just dictate the positioning of any improvements that would be placed onto the property itself. There would be a minor adjustment, which is what we've taken care of through the residual land pricing.
So I guess my question then is, we have almost 2 acres of residual and almost 2 acres of tillable grade 2. What's the difference between those? How do you judge what's tillable grade 2 versus residual?
So we're looking at it as the 1 acre home site, which is the area that is improved and supports the improvements. From the GIS review that we've done on the property, it appears that there are 2 acres that is what he's referring to as like a hayfield that is being used in an agricultural fashion. The remainder of that has been put into the residual to account for the pipeline and the ground that is not usable at this time.
And the tillable grade 2 is lower in value because of the agricultural use?
It's an agricultural use value that is set by the Department of Revenue within each municipality, and that rate, I believe, is $350 per acre.
So am I correct then to say that his additional 2 acres that he really can't use for anything has a higher value than the agricultural use?
It does, yes.
Were there questions from the board to the assessor? All right, well, then we'll have Chad, it's your turn then. If you have further testimony or evidence to present, you can do that now.
Don't have further evidence, but looking at all those, I mean, a lot of these are newer construction, and like I said before when I talked to the dean originally, you know, I would compare my place closer to that box horn place that actually sold for $530,000, not with no adjustment. So that's where I got the $550,000 from, with a little bit of improvement. That was an actual sale.
All right. Thank you. Any questions from the assessor to Chad?
Just a moment, please. Chad, the one question I do have, I do see that there was a permit issued for the pole barn, which I believe you said you used to keep the animals. Is that correct?
Yes.
Okay. Was there any issues with the pipeline when you were adding in the pole barn, the placement or location on the property, or anything that restricted you from building that barn?
The location, yeah, I would have put it more towards my house in the middle of the yard, but I couldn't put anything in there, so I had to put it right edge of wetlands, adjacent, right in front of my house. So it did affect where I would have put it if I didn't have restrictions for a gas line.
Okay, and I believe that's
You
all
know,
the
and
questions.
it's the same thing with my house. I mean, I would have put my house in the middle of the yard, so then in the middle of the woods, so I don't see anybody. But because because of that gas line, I had to go more towards the southeast part of my property to stay away from that and the rear wetland.
Okay, thank you.
Any questions from the board to Chad? I've got a question for you, Chad. You mentioned the comparison 4 at Boxhorn is the one you feel is the most comparable of those 5. Do you have that information in front of you?
I have it on my phone, but I don't have it in front of me.
Okay. I'm just going to highlight that the Boxhorn Drive was built in 1999. It's listed on there as C+, compared to yours at B+, and I believe that some of the factors I see that at the bottom of this comparable, that the adjusted price for that one comparison is $659,000. Do you see that or have access to that?
I don't, no, sorry.
Okay.
No, I'm sorry, yeah,
Yep,
I'm in
that's
the
right.
field and I only have limited access.
Sure. Yep. Any other questions to Chad? All right, will I hear any further testimony from the assessor?
No, I have nothing.
Okay. I'll ask you, Chad, if you'd like to make a summary at all.
Sure, well, like I said, just put it into summary, between my house and barn, I have an acre pretty much of usable land. The other 4 acres is between wetlands and gas line is pretty much unusable. Private drive coming in that added expenses for plowing, maintenance, all the extras added onto that. Undeveloped lot with no water and sewer, so pay for my own, pay to have to put a well in, pay to get my septic pumped, don't have the convenience of that. And then no improvements on my house, like I said, in the 13 and a half years that I owned it. So for an assessment to go up that extreme, it would have to be, in my eyes, you'd have to have some major improvements, and there have not been any major improvements.
Thank you. And then from the assessor, a summary?
Yes, I would say that the assessment is based on market value sales comparables of recently sold properties. The consideration that there's been no improvement to the property doesn't mean that it has not increased in value. There has been significant increases in property value since the last revaluation. We do feel that we've taken into consideration the usable nature or the unusable nature of the pipeline and easement. And we feel that the comparables that are used to arrive at our market value are comparable. They've been properly adjusted, and we feel that the current assessed value of $712,200 is fair and equitable assessment.
All right, thank you. I will close testimony, and Chad, I'll leave you on the line while we are deliberating, so you can hear our deliberation here as the board of review.
Okay.
What thoughts or questions does anyone have?
Nothing more.
I'm personally looking at it and I see, well, it's not a recent sale, but 12 years ago this house was built for almost $400,000. The median housing prices has more than doubled since then. That brings it closer to $800,000, above $800,000. The assessed fair market value is at $712,000, and I find these 5 comparisons to be reasonable. And the one in particular that he pointed out that he felt was the most reasonable, that is adjusted, it's listed as adjusted price of $659,000, which is not terribly too far from the $712,000. It's 8 percentage point difference. So I feel that the comparables have been shown to be useful.
And that one on Boxhorn, if you look at the size of the land with it, there's a big difference there.
Right, yes, that's 1 acre versus 5 acres.
And you put the shed with it.
Yep. Yeah, and I do see that it's listed correctly on the property card, the 2 acres as agricultural, and the other 2 acres is residual. So I don't see any mistakes on the property, how it's classified or. Okay. Good. We're going to do our findings of facts and determination for you, Chad. And I see that we've got in front of me, I've got a form in front of me, you'll get a copy of this down the road. But in front of me, I see we have your name and the property address that you did notice in a timely fashion, your intent to file objection. You filed an objection from you, the property owner. There was no recent sale of the subject property. I don't believe you have presented any sales of comparable properties to us. The factors that you listed in terms of why the assessment was perhaps incorrect is related to the pipeline easement and the increase in the assessed value. That you felt there was a higher increase in the assessed value. Then from the assessor, he stated that the estimated level assessment for the current year is 100%, so the assessment should be matching the fair market value. He states that there is no sale of the subject property recently. He did give us 5 sales of comparable properties. I'm going to say other factors or reasons were presented, and that he did point out to us that the pipeline and the 4 specific acres are accounted for in the land information and in the value. We do not find that there was a recent sale of the subject property. Yeah, let's see here. We did see that there are recent sales of comparable properties, but the property owner did not present any of those sales. The assessor did present sales of recently comparable sale properties, and the attributes were satisfactorily adjusted for the differences from the subject property and their contribution of value. So I will make a motion that exercising, last one, the Board of Review finds that the assessment should not be based on any other factors. The motion I'm making is that exercising its judgment and discretion pursuant to Wisconsin Statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is correct, that the assessor presented evidence of the fair market value of the subject property using assessment methods which conform to the statutory requirements, that the assessor presented evidence of the proper classification of the subject property, that the proper use values were applied to the agricultural land, that the proper, should we say, were those fractional assessments listed? Would we call it that?
The which? The
No
fraction?
forest.
I'll ask Henry, would those be fractional assessments listed for the residual?
I would say it's right. It's fractional. It's listed as residual land.
Right.
It could be going other ways, but I mean, all this is, it's residual. It's
All right.
not usable for any
I'll
other
check that
purpose.
box, because it's undeveloped land.
Yeah.
That the property owner did not present sufficient evidence to rebut the presumption of correctness granted by law to the assessor, that the assessor's valuation is reasonable in light of all the relevant evidence and sustains the same valuation as set by the assessor, and that it is, I don't think he presented other assessments of other properties. Yeah. So that's our motion.
I'll second.
Henry seconds. You're a good one for that, Henry.
Roll call vote. Gary Boycitz.
Aye.
Jeremy Kyle.
Aye.
Henry Posberg.
Aye.
Cindy Schmier.
Yes.
Mara Spring.
Aye.
All right, the motion passes. Chad, we are sustaining, we are keeping then the assessed value from the assessed value, from the assessor. And you'll receive that document with our reasons there sometime soon. All right, thank you, Chad. All right. Okay.
Can I have 2 minutes?
1 second, yep.
2 minutes for bathroom?
Yeah, so let's take a quick break for the bathroom so we can give our full attention to Brian. Red's on, is that one on? There you go. Okay, we are recording and we're back on record, and we've got the hearing for Brian Miller, the agent for Marion Miller Howitt. And
I will introduce the case. The case of Brian Miller, agent for Marion Miller Howitt. The property owner, well, this would be the agent. Are you on Ancient Oaks? So now I have a question. This is still the because I'm supposed to state where the property owner lives. She lives there, right?
yeah,
He's
state
just the
that, but
agent.
then also maybe ask for his,
Okay.
he'll state his name and
Okay,
address later.
Yes, you're correct.
Yeah.
So the property owner lives on Lannon, West 172, South 7341 Lannon Drive. The address of the property in question is West 172, South 7341 Lannon Drive. The tax key for this property is MSKC 2193.041. The property has been classified as residential. The value in the assessment roll for the current year is land at $343,700, improvements at $221,800. The total's $565,500.
Okay.
Swear in.
Well, you've seen this now perhaps, but you'll notice To confirm how it will go, you'll be able to present your testimony and evidence. The assessor first, followed by us as a board, will ask you questions. Then the assessor will present their testimony, and you can ask him questions first, followed by us on the board, and then do that again. Then you'll be able to present your summary. He'll be able to present his summary. We'll close the testimony, and then we will deliberate and make a finding. All right? We will swear in.
Would all persons intending to provide testimony for this hearing, including the assessor, please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony which you shall give in the matter at this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. So would the agent for the property owner who was just sworn, please state your name and address for the record?
Turn the mic on, sorry.
Up on the top, there's a button. Oh, hang on, it's because of me. Sorry, because we turned them off. Now try it, please.
Button.
No, you. Say hello.
Hello.
Is it on? Now the button.
There you go. Should be working.
Is it on?
It moved, though.
Hello?
Oh, he's just quiet, too.
There you go.
We can
I think we're good.
Okay, go ahead. Your name and address, please. No? Third try. Try it now.
It's on. There we go.
Gosh.
All right, thank you.
Sorry.
How about that? All right. No warm-up act for this microphone.
Yes.
So state.
Name and address.
Name and address, Brian C. Miller, address W193 South 7952 Ancient Oaks Drive here in Muskego. Acting as agent for my elderly mother, Marion M. Howitt. The address in question is W172 South 7341 Landon Drive here in Muskego.
Okay, I'm going to need to interrupt because we went right ahead a little bit too fast. Do you have any witnesses for the property who need to be sworn in?
No.
Assessor, please state the estimated level of assessment for the current year.
The estimated level of assessment for the assessment year 2025 is presumed to be 100%.
Okay.
All right, I'll read off to you then. The Board of Review wants you to understand that under state law, the Board of Review is required to uphold the assessor's valuation of your property as being correct, unless you by testimony can show the assessor's valuation to be incorrect. In other words, the burden of proof is upon you as the taxpayer. Do you understand?
Yes.
All right, thank you. Please state what amount, in your opinion, is the fair market value of your property.
I am looking for a rough decrease of $50,000, $516,885.
All right, so 516,885 is your opinion of the assessed value. We'll have you present your testimony and evidence.
All right, very good. The difficulties associated with this property span a couple of different areas. The evidence and testimony I'm going to provide today will focus on issues with the land, which involves an abandoned easement and spillway, which transverses the property, referred to in the assessor's document as a culvert. I will be looking for clarity from the assessor as to what the definition of a culvert is versus an extended spillway. I have some exhibits that I will share with respect to that. The second issue is the condition of the home and dwelling, which the assessor has indicated as average, which relates to some of the comparables. This is a home that was built in 1931. It's been occupied by family members of mine since then, and like most homes around the lake, was originally built as a cottage. It was last remodeled in 1974. My mother's lived there for the last 55 years. The last addition to the property was a garage addition, I believe, in the 1990s. To the best of my knowledge, there's been no assessment walkthrough since that remodeling job in 1974. I have some photos that will evidence that the interior of the property has deteriorated and requires some significant remediation. Finally, as I appreciated meeting with the assessor's agent during the open door session, the comps provided by that agent's own admission are a bit problematic. This property has some unique features, which includes this extended spillway and the easement. The comparable is provided, and I appreciate the difficulty of providing comps because I did call a couple of individuals looking to receive a private assessment. Was not able to complete that in time, but there are the unique features of the easement and the spillway make it difficult to provide a specific value. I'm basing my calculation on some evidence that I've heard from my family members as well as notes that they have from prior conversations with assessors here at the city with respect to the depreciation that should be afforded on the property due to this extended spillway. If this is an appropriate time, I have some exhibits to share with the board. Okay.
Just make sure the assessor has one. Absolutely.
You could just flip the top open. It's not sealed.
Oh, I'm sorry. Thank you.
There's an easier way to access it. I didn't provide a letter opener, sorry.
No, that's
All right, so I would like to review some of the exhibit documents. I did include a copy of the objection to real estate assessment as Exhibit 1. Exhibit 2 is simply the notice of the estimated increase in assessment. I noticed as I was sitting in the audience, I have some Scrivener notes on the bottom, but materially it doesn't change the overall number that I'm looking for. The third exhibit that I have marked up the comparables that were provided by the assessor's agent when I met with them last week. There are several areas that I'd like to highlight, which will also accompany we'll have some accompanying exhibits. The effective frontage of the property is listed as 50 feet. The actual reality, as I will exhibit in a later document, is more like 35 feet. There's a 15-foot easement, which I do not feel has been adequately documented, nor have the calculations transparently been shared. 50 feet minus a 15-foot easement results in a 35-foot frontage, and as the pictures and illustrations will demonstrate, there is no effective way of using that additional 15 feet. The second item that I have marked out is the grade, which is listed as C+, and average CDU. I'll be looking for clarification as to what CDU actually is, but the comparables are listed as good and very good, something that was pointed out to me in the open door session by the assessor's agent. I'll also be talking about the overall condition and grade of the home. I will stipulate that family members and I have painted the exterior within the last year or so, trying to maintain some upkeep, but there's significant work that needs to be done on the interior. There is a deck area listed. I'm not going to really address that. I don't feel that that's necessarily material, but right below that deck area notation, there are some abbreviated notes about drainage through the property. We'll talk in a moment about the drainage. As I said, the comps and finding comps, as I talked to some folks about getting updated assessment, difficult to do given the unique nature of the culvert and the ability to depreciate that. With respect to the next exhibit, Exhibit 5, here again, just pointing out that the year built was 1932. No significant updates since a remodeling done in around 1974. Bathrooms in particular require some reconditioning. Physical condition, I would say, is below average. I have had some questions about the square footage, total living area, but didn't take the time to measure those, so I'm not going to stipulate as to that. I guess I did these out of order. Exhibit 4 is the property record card for the land. Property has a drainage pipe running through the property. I'd like to obtain the assessor's definition of what a drainage pipe is with respect to size. When most people think of a drainage pipe, I think the average person thinks of something like a small culvert. This is a pipe that, just to illustrate for the board, stands nearly as tall as me, and that's just the drainage culvert. The spillway, to put this into context, runs approximately from where board member Posbrig sits all the way through to this chair on the opposite side. It's about 40 feet long. When I was growing up in this house, we often referred to it as the moat. So if I slip and I use the term moat, you can appreciate that this is a large concrete structure, which you will see evidenced in the pictures. Again, very difficult to assess, but based on some anecdotal evidence, I have appreciated that there's been depreciation allowed for that in the past. Exhibit 6 that I have included really focuses on the land value as well as the issue with respect to the lakefront footage. Here again, I have not received any information upon inquiry from the assessor's agent about how that easement is handled. This is an easement, 15-foot easement that runs the entire length of the property from Lannon Drive all the way to the lake. That easement was originally set up to serve as drainage for Freedom Square subdivision across the street. That had been redirected about 20 years ago by the city, and the easement and the spillway have subsequently been abandoned. The state of this spillway is beginning to deteriorate. The culvert inside is rusting. Separate issue to be dealt with in the city at another date. But as I noted, this is a very large culvert and extends very deep into the property at the lakefront level. The photos, now I'm on Exhibit 6. First photo, so page 2 of 4. Is the property overview from the city maps. Kind of difficult to see, but you get an assessment, you get an idea of where the home placement is relative to the property footage. This is a narrow lot to begin with, as most of the lots in the lake are, but you can appreciate that a 15-foot easement, which would be to the left of the dwelling, running the length of the property, inhibits the ability to do much construction if this home were ever torn down, replaced, remodeled. That places a significant constraint on the ability to utilize the property. Spillway extending into that white shaded area, which I tried to illustrate as best I could here, to the upper left of the property. Page 3 of that same exhibit gives you a sense of the lakefront footage. Not the best picture of the extent of the spillway, but the person standing with the pink jacket on is about 5 feet from the opening of that drainage culvert, that spillway extending all the way into the lake. The photo on the right gives you an extent of the length and depth of that spillway. There again, abandoned by the city. No railings were ever installed by the city, no safety features were ever installed by the city, so it is somewhat hazardous. Photo on page 4 also illustrates the nature of the culvert, some of the deterioration of the piping, and finally the photo on the right side illustrates the land survey and extent of the easement. I found no evidence in any of the assessor's documentation other than brief notes, and I didn't receive any additional information during the open door session about how that valuation was assessed. Rather, what I was told was it's kind of an estimate on their part. So there's no discernible or transparent documentation available with respect to that. With respect to Exhibit 7, this is a home that is nearly 100 years old, as I've said. Needs some considerable restoration and updating. I have family members that have lived there since 1934. My mother has lived there 55 years. We're trying to get in there and we're trying to do some updates, but there are areas that I would note are below average or below grade C+. Some photos follow. There has been some roof leakage damage impacting ceilings, water damage in the ceilings that require repair, drywall repairs that need to be done in a number of rooms because this is a lake home, does not have city water. A lot of iron in the water, as many of us who live in Muskego know, a lot of minerals in the water, iron damage in the bathrooms which require restoration. Page 3 of the documentation details photos of the basement which get to the nature and quality of the construction. Here again, this was originally a lake cottage. The materials used to build it. There's an old barn beam which serves as the center beam of the house, probably not uncommon 100 years ago. Deterioration in the basement, concrete cracks, leakage, etc., in need of updating and repair. Page 4 of 5, also more photos, illustrations of some of the concrete work and deterioration around foundation and settling. Exhibit 7, more photos of the interior requiring some additional restoration and repairs, which will likely be accomplished over the next several years. However, I believe we're here today to talk about the current assessment. So in conclusion, it's my belief, based on the information I was able to gather, that there are some circumstances here that warrant a reconsideration of the assessment. And apart from the statement of facts that are documented in the property cards and the comps, I look forward to hearing the assessor's comments.
All right, we'll take questions from the assessor to the taxpayer.
All right, thank you. My first question, given the state of the current improvements, the home, has there been any estimates for repairs or any estimated quotes of cost that what it would take to
recondition and fix it up? We're in the process of doing that, but I do not have any estimates to present today. Based on the drywall damage alone, based on some work that I've recently had done, my ballpark estimate is probably in the $60,000 to $70,000 for the interior work that would need to be done. I have not tackled any of the electrical wiring, basement, foundational types of issues yet, but I would anticipate that it's going to probably be considerable.
And this has been, you're looking at doing significantly more work currently. You've worked on it over the number of years, but you're kind of ramping that up to address more of the situation.
Right. In the next few years, my mother's 81 years old. Anybody who has elderly parents can appreciate, there's been resistance to doing repairs, but we're at that point now where it's a must-do kind of situation. Okay. So I anticipate over the next 2-3 years, there's some reconditioning that needs to be done, and fair to have some reassessment done at that point in time.
Okay, thank you. The next question, thank you for the information that you provided. Was any of this information, was this simply discussed at the open book, or were there pictures or any photographs that were provided?
It was discussed. I had some photos on my phone. Not all of the photos I presented. We took some additional photos. There was extensive discussion about the drainage culvert spillway, as well as the interior condition, and that's ultimately what led to that individual's affirmation that looking at the comps were as that person used the term problematic, because they use a condition of good to very good, and then also very difficult to assess the impact of the mode spillway and the easement.
Okay, I believe also you had mentioned you didn't have enough time for an appraisal. Have you talked to any realtors or anyone to give you an opinion of value outside of a full appraisal?
No realtors, because frankly, there is no intention to sell. This is a home that's been in the family for nearly 100 years, and I anticipate it will continue to be so. So there's no intention of a future sale. And frankly, it hasn't been sold since 1932 or whenever it was constructed.
Okay, thank you. That's all my questions.
All right, any questions from the board to Brian?
I guess, let me, how does this spillway affect access to the lake?
With a 50-foot frontage, the spillway and easement extend 15 feet from, if you're facing the lake, the left lot line. So the spillway is by my estimate, 7 to 8 feet wide. There is a 3-foot segment on the opposite side, which is a concrete pad. You can't access that because of the height of the spillway above the surface of the grass. There is an additional spillway under the water, which extends out 6 feet. It's probably 6 feet by 6 feet, so you really can't run any boats in that area because you bottom out and tear out the boat depending on the lake level. That leaves effectively roughly 35 feet-ish of shoreline access.
And I know you provided pictures. Is there a dock? Are you able to have a dock there?
We are able to have one rollout pier in that space, yes. In that 35-foot.
In that 35-foot space.
But because of the pie-shaped lots, which I don't think are fully represented here in the survey map that I had, the riparian rights are a little bit problematic because it's on an inside curve of Shoebring Bay, and the docks, because of the riparian rights, tend to be very tightly placed against each other so that the neighbors can get their boats in and out.
Does your testimony basically, in referencing this spillway, are you saying that spillway is no longer needed, or is it needed but not being repaired?
I believe, my understanding is that it is no longer. I'm going to clarify the definition of needed. Because I don't have a determination from the city as to whether or not it's still quote unquote needed. I would say it's no longer used. There's no longer effective drainage coming through it from Freedom Square. There is simply groundwater leakage that is flowing through that into the lake.
And you're basically saying that's seepage. There's nothing running from any other property?
There is water coming through it, but I believe it's mainly seepage, based on what I've heard. It largely has been abandoned by the city, as we have approached the city a number of years ago about having it removed. There's really been no action taken, but the fact of the matter is this is nearly 12-inch thick wide concrete walls and a fairly substantial structure that would probably require excavators to come in and remove it. It's pretty solid, yet deteriorating, cracks in it. So.
And there haven't been any repairs on that
spillway,
to your knowledge?
No.
For a really long time?
No, I would say it's been there since reverse engineer the math based on my age. It's been there probably at least 50 years.
And this was mentioned during your open book with the assessor?
Yes.
And it's your testimony that you weren't provided with any information regarding the status of that spillway, at least as far as who's responsible?
No.
Are you a member of any, is that property a member of any homeowners association? anything like that?
Along the lake, I don't believe they have homeowners associations. There is none there. However, there is the Lake Association, but they don't believe that they address that.
You're saying that they don't believe they have reason?
No, no. Technically, it's a city-owned easement, and technically, my understanding is that they would be responsible for that.
Thank you.
Good. Any further questions for Brian? All right, we'll hear testimony from the assessor.
All right, thank you. Nick is passing out Assessor's Exhibit A and Exhibit B. Exhibit A is the two-sided property record card containing the assessment data for the subject property. Exhibit B is the comparable sales analysis that was performed on the subject property. It was not used. We are currently using the cost approach. This is similar to two of the cases that we had yesterday. I will touch base. I won't go through all the comparables necessarily, but I will say that comparable number 1 is an old style, one-story old style. Comparable number 2 is a one-story ranch. Comparable number 3 is a two-story colonial. Comparable number 4 is a two-story old style, and comparable number 5 is a two-story old style. So there's a variance in style, first of all. Also, with the subject condition ratings that we have, you'll notice that each of the comparables with the adjusted sales prices, we are showing that those are excess adjustments. Since there were no good comparables, we feel that the cost approach is the most likely indicator of value for the property. Starting on the front property record card, Exhibit A, I will note that in 2017, there was an open book change, which is when the property was changed to the cost method. The cost approach was used due to the condition of the property. And in 2021, there was also an open book change that the kitchen rating was changed to fair, and there was a negative 10% land influence that was applied. The land information shows that the land is considered waterfront primary, and we do show the 10% negative influence for shape, size, and economic misimprovement. I'm showing that we are currently, the value flag is set to the cost approach. On the back of Exhibit A, the subject property is a 1.5-story Cape Cod, built in 1932. We show a year remodeled of 1998. Kitchen rating is fair, bath rating is average, basement is considered to be full basement. We're showing that it's centrally heated and air conditioned. Physical condition is average, interior versus exterior is the same. The grade is a C+, the CDU is average. I am showing that there's a cost and design factor of -5%. The ground floor, or the total living area is 1,969 square feet. And again, with the comparables, we show that the comparables are not comparable. They are not being used to adjust the market value. On the front of the Exhibit A, you will notice that the market value is generating a negative $17,400 on the improvements. So that's a land value of $343,700, negative $17,400 for the improvements, resulting in a market value of $326,300, which is why we're using the cost approach, because the sales comparison approach does not provide an adequate value to describe the market value of the property. And that concludes the evidence presented by the assessor.
All right, you can ask the assessor any questions.
Yes. So you mentioned that the year of remodel was 1998. I'm curious as to what evidence you have for that, apart from the addition of a garage, or if that is part of the assumption, because the home hasn't been remodeled since 1974.
That is just simply the year that we had on the record from our data. I don't show any notes that there was a remodel, and I don't show that there was any permit information from that date and time. It was just a legacy note that was carried over.
All right. So my testimony is that that element of the record is not correct.
Okay.
And we could perhaps talk, and I can follow up with the assessor about how to have some of these record elements corrected. Could you also describe the cost approach and how that works, especially in light of the condition of the home and the questions that were asked previously about the cost of repairs?
Yes, the cost approach is essentially if we were to rebuild the home with current materials and construction workmanship, what we would be looking at is reduplicating the home and applying depreciation back to the original cost, not to the original cost of construction, but the current cost to recreate the home, less depreciation for the age of the structures. Taking into consideration plumbing fixtures, finished area, unfinished area, and all characteristics of the property, whether it's crawl space, basement area, attic finish, things of that nature.
Okay, and I know you reviewed some numbers on that, went through that pretty quick for a novice. Can you kind of take me back through what that cost estimate to reconstruct that would be?
Yes, we are showing that the base price for the home itself would be $224,387. The value for the plumbing itself would be $10,050, and this is in the dwelling information. If you have the property record card and you turn to the back, the bottom right-hand corner where it says dwelling computations, this is where I'm going, so you don't have to jot it down necessarily.
Got it.
But the base price is $224,387. The plumbing is $10,050. There's no cost associated with the basement, and we are showing that the heating would be $5,950 for a subtotal of $240,390. And then we're looking at 70% depreciation, or 70% good, 30% depreciation, and then we're also applying an extra 5%, minus 5% for the condition and the quality, the condition and design factor, minus 5. We're also showing that there is an addition of $49,770, which brings the total dwelling value to $209,600.
Okay. And the base price for rebuild 224, is that a depreciated amount or is that the gross amount?
That is if it was built today for the size and the amenities, and then that is the after everything is summed up, then it is depreciated at that point in time.
Okay. I want to find a builder that would build for that amount. That would be awesome. All right. And then could you also cover thoughts about the spillway easement as long as we're on the property card, and where and how that computation is evidenced?
So I believe that the adjustments for the spillway is the shape and size and the economic misimprovement. It's the minus 10% influence that's given to the land.
Okay. And are there any standards or any evidence that are used to come up with those calculations? I have never been able to find any.
It's more of it's a subjective adjustment. It's what the appraiser believes that the effective value would be on the property. There's not a way that I can show you to calculate that. It's just more of a subjective approach to adjusting the value, which should be applied consistently. But yes, it's more of a subjective, what do we think the amount of adjustment would be to the land for the condition or the mitigating factor.
I think that, yeah, I guess that speaks for itself if it's subjective. Okay, I don't think I have any other questions.
All right, questions from the board to the assessor?
Definitely. I'm looking at your computations that you were just talking about. Starting with the 224, adding the 10, you get to the subtotal of 240, 390. You said then you subtracted 30% for the 70% good.
The depreciation?
You subtracted another 5% for the C&D factor.
Mm-hmm.
And you add back in the 49,770 for the garage.
For the dwelling computations, we're adding in the 49,770 for the addition, and the value of the garage is 12,200.
Oh, so what's the addition if it's not the garage?
It looks like it would be an additional part from the home that was added at some point in time other than the original home for the addition.
Is there a reason that that's not included in the base price when you first do it?
Give me just a moment. Whenever we're doing that, the additions, I mean, everything else is here just with the original.
The way that the sketching.
Microphone, thank you.
On page 2 of the property record card, you'll see that bird's eye view of a sketch, and below it, the additions. That first line with the area of 918, we call that the A0. That is the main section of the house. So if you're looking under the dwelling information, everything contained in that area is going to have a story height of 1.5 stories. The following codes below it, the 11 is an area of an open frame porch. The A3, the area of 92 square feet, is simply a 1-story frame over no basement. The A4 is 270 square feet of basement with living area above it. A code 12 is an enclosed porch and a 31 is a deck. So when you're looking at the property, some of these older homes, as they grow over time, you do not change the original structure. You add on additions as they were added onto the house or discovered through visits. So it's just a description in the sketch. I believe that additions in the dwelling computation reflects that.
Okay. Then I'm confused about one other thing. On the first page of the record card, in the assessment information, I know you're not using the market approach, but I have never seen where the building has a negative number. Can you explain why the building has a negative number in the market approach?
So the excessive adjustments that were at the bottom of the cost approach, it's valuing the property at a total value of $326,000. We have a land value for the property of $343,000. It's the adjustments from the market approach are telling us the total value should be 326. Starting with the land value of 343, it would be a negative value for the improvements to arrive at the market value of 326,300.
So the market value is basically the land and then tear the house down.
That is one way of looking at it, yes. Ultimately, the comparables are telling us it should be a sales price of $326,300 or market price of $326,300, but our land is above that, so it would be a negative adjustment for the improvements.
So if that's the case, then I see the physical condition on the dwelling information says average. Would you typically see a value of average for a house that's market value showing a tear down price?
Typically, no. But with the comparables, we also are taking into consideration the difference between those comparables and the subject. So even though this is listed in average, which is average condition for a home of that age, the CDU is what we take a look at for the condition, the desirability, and utility of the home. That's listed as average as well. That is something that takes into consideration the location as well as the condition. So we're saying that there's trying to think how to phrase this exactly. We are taking that into consideration. So an average condition, I would not anticipate seeing the negative improvement value, but it is from the market approach. So with the different comps, the varying sizes and styles, them being significantly higher in grade and condition, are leading to a negative improvement value, which is why they had the excessive adjustments, and that's why we're not using the market approach.
So if you were to change the dwelling information for the physical condition to be, we've seen a couple that had poor and poorer. If you were to change that, would that affect the cost approach value?
It would affect the cost approach, yes.
And there's no way to tell by how much, as when you're sitting here, you'd have to do some computations?
There would be some computations involved. Typically, the condition rating or the CDU also takes into consideration the depreciation. So the poorer condition applies more depreciation to the subject property. A good or very good CDU would take away or limit the amount of depreciation, and that's how we make adjustments to the property based on the condition, the location, and desirability.
So right now you have the 70% good and the -5 CDU. Both of those numbers would go up, or?
The percent good would be decreased. If we lowered the condition of the property, it would apply more depreciation. That would lead to a less percent good.
Is there a set percent that normally is attached to each? So like, for example, you have average, does that equate to 70, or is it house by house?
It's more tied to the age. We have depreciation tables, so there's roughly, and I don't have them memorized, but a new construction home will realize 2 to 3 years before a decrease or an increase in depreciation of about 3 to 5%. then it may remain at 3 to 5% for 10 years, and then it starts adding and accruing more depreciation the older the home goes. So it depends. You're not going to see the same amount of depreciation on a newer home, like a 1980s versus a 1920s home, in a change of condition. The change in condition would lead to a higher adjustment for the older home because it would accrue more depreciation.
If this were poor and poorer instead of average and same, would you expect the percent good to go down to, 60 or 50%, or do you not have any way to tell?
I would say that just as an estimate, I could foresee that being a decrease to approximately 60 to 55. I mean, for it to be completely depreciated, it's at the end of its life. It's unsound. At that point in time, we would be calling it an unsound or unstable structure, and that would maximize the depreciation.
Thank you.
What other questions do we have?
Do your notes reflect what was discussed in respect to the culvert or whatever you wish to call that piping or concrete wall that's on the property?
Yes, the adjustment that was made was the overall 10% negative influence to the land, and that was for shape or size and economic misimprovement.
And what, can you explain the numbers? There's a 50 there, and there's size 220.
So the type of land is waterfront primary. F means that we're pricing it as a front lot. So we're not using an acreage, we're using the actual lot dimensions. 50 is the frontage, the depth would be 229. The influence factors would be 4 is the number for the influence of shape or size, and the number 5 represents the influence for economic misimprovement.
You heard the homeowner testify that there's these giant, and we saw pictures of these giant slabs of concrete for that culvert or whatever it is. Did the assessors look at whether or not the city had a responsibility to remove that or not?
We did not look into the responsibility of that, and this is the first time that I'm seeing photographs of I have seen the notes, excuse me, pertaining to the influence for the land. This is the first that I'm seeing the spillway or the depth of the situation for that.
All right, and there were no, you're saying you never saw any photographs, number one, and number two, there's no reference to how large those concrete slabs were or anything like that?
I'm not seeing any notation for that information.
All right, in looking at the pictures, is there anything that goes into your arrival or of the assessment that takes into account the removal of those slabs? I mean, if say, for example, the assessor's office checked and found out it's the city's responsibility to remove it, I guess that wouldn't affect the price of the home because the city would have to remove that or take care of that. But if it becomes a homeowner's, either by the city's abandoning it or saying they don't have to do anything with it, would that affect the price? I mean, it just, to me as a homeowner's thinking that I have to remove slabs like that in order to improve my property or benefit from my lakes,
Yes. So I will say that if it were beholden upon the homeowner and it was their responsibility, it would impact the market value. I will give kind of a general example of if you have an older home on a lot that the lot is in a subdivision or an area where land really starts increasing and you see more and more high-priced homes, and this is a modest home, the market value for that would be calculated as the cost of the vacant lot minus the amount to tear down the older improvements. So it would have an effect on that.
And that wasn't done in this case. Is that a correct statement?
No, there was no analysis of what the cost to remove those slabs are. We have no notation of the slabs or the spillway, so there's not been an analysis to take a look at what it would take to remove any of the concrete slabs or to remove the spillway to make an adjustment to the market value.
But it was brought up by the homeowner, but there was no investigation as to what the city's position was on that.
Well, this was looked at in the 2017, the land influence in the last open book, well, not the last open book, the 2021 open book, there was the land influence applied for reasoning. We don't have descriptive notes, but we felt that it was applied, it was taken care of or adjusted through the negative 10% influence. We did not have the photographs in front of us whenever we were reviewing the property through the open book process to see that it may require a higher adjustment.
Okay, I guess I'm getting confused by the cost versus market when we start looking at this, because we're looking at frontage being affected by giant slabs of concrete that may or may not be the owner's responsibility to remove them if they're no longer necessary. Is it fair to state that the removal cost was not calculated in any of your assessments?
The removal cost of any concrete slabs was not taken into consideration with the assessment. We don't have any record of the concrete slabs. They're not currently being assessed. So therefore, we would not have any information unless it was brought forth to us that they existed, and then we could take a look at an adjustment moving forward at that point.
Do you know whether or not you would be able to get any information from the city if inquiry was made as to their position on those culverts?
We
at least
may
as far
be
as
able to make a request, but I do not know if that information would exist at the city level. They may have record of it, but we're not showing it as a record of our information.
But no request was ever made?
No request was made, no, that's correct.
Would, based on the information that you did get from the homeowner, would it have been appropriate for the assessor to look for what the city's position was on those concrete slabs?
So the information from the open book that I have from the meeting that occurred, the whole house is fair condition per owner. Lots of leaks and repair issues. If it is ever sold, it would be a tear down, abandoned culvert with 15-foot easement attached to it that intrudes on the frontage, and original Little Muskego Lake Cottage. There was no mention of any large concrete slabs that was brought to our attention. No discussion of the cost to remove those. Just, this is a brief summary of the information that was provided at open book.
All right, so it just was referred to as a culvert, basically.
Yes, an abandoned culvert, which encroaches on the 15-foot easement.
All right. And can you tell me whether or not your calculations took into an account that there's an abandoned culvert on the property?
That, I believe, is the negative 10% for the shape in size and economic misimprovement to the land.
How do you arrive at the negative 10% as opposed to a higher or lower amount? You understand, the homeowner's saying he's got, we're assuming he's got 50 feet of frontage?
And he's missing about a third of it.
Yeah.
Pardon?
And he's missing about a third of it.
Right. And so,
in effect, he's got 35 feet of frontage, not 50.
Right. And so, how do you arrive at the 10%?
The 10% is the adjustment that was applied through the open book in 2021. It was calculated by the previous assessor. We assumed it to be correct without the further information or the photographs to prove that there may have been need for a larger adjustment.
So you relied on the previous open book versus what the current owner brought up, or you just followed through with that?
So this year's reevaluation was an interim market update. A full reevaluation, which the city did not require, would require us to go and physically inspect every property. We have to rely on the information that we have on file unless the owner requests that we come out there or that a permit is pulled that would invite us to ask to come out there. So barring that, we are going to rely on the information that we have on file. Nothing was provided further as to who is responsible for this culvert, the scope of it, who is responsible to maintain or remove it. So we relied on the notes from the prior open book and the adjustments that were made. We looked at those as reliable from that appraiser.
I think we've talked about this subject.
Pardon, I'm sorry, I'm beating it to death.
Yep.
But just a question to the homeowner.
Is it his turn to?
I've got one other question. Do you mind if I cut in with a question, Gary?
And
Okay,
could I
I'll
just-
withhold my question to the
Yeah.
homeowner then.
And
if we're
could
still-
I just clarify, which may or may not help? I'd be shocked if the city did not have information about this, because we have information that goes back a long time. I'd need to talk with our planner. We're throwing out a lot of words. If it's a true abandonment, we would know that, we would have that documentation. And my guess at that point, the city would not be responsible anymore. It would fall on the homeowner. If it's not an abandonment, then at that point, the city would be responsible. These answers are available. I don't have them for you because I didn't know this was coming up, but they are available they would be available at the city.
So it's just a question of whether or not somebody went and got them.
That's correct.
Yep. Good, all right. My question to the assessor is on comparison one, looking at the cost approach, that is a 0.26 acre lot, same as the subject property. It's listed as 60 effective frontage compared to the 50 effective frontage, and yet the land value is listed as $45,000 less than the subject property for the cost approach. Can you speak to that?
This is comparable number one that you're referring to?
Comparable number one, yes.
Yes, comparable number one is in a different neighborhood, which would have a different land rate applied. I cannot tell you if that is a lakefront lot or if it's a non-lake lot.
All right, well,
I have one other question for the assessor. I'm looking at, again, the dwelling computations. I note that you have that addition, which confused me. It doesn't appear that when this math was done, any of the C and D factor or the percent good was applied to the addition. Why is that?
So if I understand you correctly, we're applying the depreciation only to the initial base cost and not the addition?
Well, when I do the math, you take the subtotal of 240, 390, 70% of that, and then you take 95% of that, and you add the full amount of the addition, and you get to the 209 that you have listed there. So I'm trying to figure out why we're not applying the percent good and the C and D factor to the addition amount.
Give me just a moment, please.
no, it's the opposite thing.
I have a calculator.
So I am doing the math and I'm coming up with the same number. I see the question, and I agree with you that I cannot explain why the depreciation is not on the additions. I believe that the additions are considered. Give me just a moment here. So there, are the additions going to be just the porches themselves, or are we, because I'm looking at the base value here, and we've got the square feet living area. So that's something we're going to are the additions just the porches, and that they are not depreciated because they're not as primary improvement? Porches and garage. So I understand the question. I cannot answer without referring to the process that we're going through. I could look at the WPAM manual, or I could look at the system to see the breakdown of how that is. I do see that the math adds up, but I'm still at a question of like you, why is the depreciation not being applied to the additions as well? So I don't have an answer at this point in time.
And you would agree, though, that if the depreciation was applied to the addition, it would result in a $17,000 less in assessment approximately for the dwelling?
Through the cost approach, it would decrease the value, yes.
Any further questions for the assessor? All right, we can have secretary's testimony from, or further evidence from Brian.
I'm sorry, could you repeat
You can present further testimony or evidence.
I don't think I have any further evidence, just appreciating the dialogue back and forth from the board members, and appreciating also that I think there are a number of issues here with respect to the property card, the property record, the data points. The final comment that I'll make is that when I did meet as part of the open door process, that discussion was quite extensive. It included a share of some pictures on my phone, but the reality is that the easement, 15-foot easement, which I think is important to also consider in light of the comments shared here about whether the homeowner would be accountable for removing this culvert pipe. That easement runs the entire length of the lot, would have to be excavated out in addition to that 40-foot spillway. So that's considerable cost, and I appreciate the clarification by the board members and council about that. So I don't have any further exhibits or things to share, so I await the board's determination.
Any questions from the assessor to the property owner?
No questions.
Gary?
Just, you heard the assessor speak of the information that was provided to them regarding the spillway and the concrete. Was his testimony correct in terms of what was presented to him, or do you have a position that more was presented than was actually represented by the assessor?
As part of this most recent conversation, as part of the open door conversation?
Talking about the open book.
I spent a fair amount of time talking with the assessor's agent, so I believe that there was more information shared. That individual did take notes, but as the assessor did testify, those notes are summary notes. As far as prior documentation with respect to the spillway and the easements, I know that there have been repeated conversations over the years, comments made by legal counsel indicating that there must be some awareness at the city level about the deterioration of this, as well as conversations about removal. I wasn't privy to all of those, but anecdotally, from my mother and stepfather, I know that those have occurred over successive administrations here at City Hall.
So would it be your position that somewhere along the line is these concrete blocks on that spillway were brought up at open book?
I'm sorry, I didn't catch that.
These concrete spillways, and regardless of whose responsibility it is, that they were brought up in terms of arguing your assessment?
Oh, yes. Oh, yes. Both the spillway as well as the deterioration of the piping that is underground and the seepage.
Any further testimony from the assessor?
We have nothing further.
All right, thank you. Would you like to summarize your position any further?
I think, as I said, I think there is a body of evidence here, photographic as well as testimony, indicating that the assessor's documentation and information was not complete, that there were some perhaps errors made in calculations, as pointed out by board members. I appreciate the clarifications that were made, but I think that fundamentally both the value of the property, land, as well as the condition of the home and dwelling and the comparables should provide sufficient evidence to rule in favor of the reduction in the assessment.
Thank you. From the assessor?
Just to summarize, the assessment was completed with the information that we had. The information provided today would have been more beneficial if we had copies or photographs whenever we were doing the review of the open book session. We still are relying on the information that we have, even though we may have some data discrepancies, and that is how we arrived at the current value. Currently using the cost approach due to consideration of the condition of the subject improvements, and that is all that we have.
All right, thank you. We will close testimony and we will deliberate.
Go ahead.
Both the issues that Mara raised in respect to the additions that were not referenced or calculated or undeducted, as well as I'm going to say that over the years that something must have been brought up regarding these culverts, and that the information was readily available in order to reach a calculation, and I don't think it was done. And as a result, I'd say this may be one of the, and again, it's surprising to me that we're only talking a $50,000 difference between the city's, roughly a $50,000 difference between the city's assessment and what the homeowner is claiming the value is. Given those discussions and regarding that whatever it is, that drainage thing, as well as what Mara brought up in the calculations, would lead me to believe that we may be able to go with section 2 of our decision.
For me, the biggest stuff is related to the Gold Drive, which is on the lake. It's on the opposite side of the lake, but as far as I know, Gold Drive and Landon Drive are similar desirability. I mean, that just lends itself to suggest that the land value is overvalued in the cost approach, and also that if we need to or want to incorporate removal costs, we were just told that any sort of removal costs can be used in assessing or determining a value on there, which also sends me towards the land value. I'm thinking what we adjust. I feel like we may adjust both because Mara's pointed out there's a reasoning to adjust the property value down, the building value down. I think there's also reasonings to adjust the building value down to match what the property owner has requested.
I did the math to figure out if we applied the depreciation factors to that addition, and then that's about, with the garage added back in, it's about 205, which would bring the 156 to be exact. And then if you subtract from what the homeowner is requesting, it would make the land 311,729, which is a little bit less than 10% reduction. So it's still counting more than 2/3 of the land, of the property frontage. And I mean, I think that's reasonable based on everything we've heard today.
Question in general, as I've seen in general that we're rounding to the hundreds, it seems like, in the world of.
Yeah, I mean, he has 516, 885. That's the only reason why I used his number.
Right. Okay, question for Jeff. The owner asked for 516, 885, but I think it's appropriate to round to the hundreds because that seems to be how it's done.
Yeah, that's not a problem.
Okay.
If you were to do a major difference, but you're just rounding based on so that's not a problem. That's a very minor change.
All right. I think we'll go through our determinations of finding in fact. We have the property owner's agent here. The property is listed. There was timely notice of intent to file an objection. There was no recent sale of the property presented by the property owner. There was no recent sale of comparable properties provided by the property owner. There were other factors, namely related to, we'll use his term, the spillway and loss of frontage. Anything else to add? I think it sums it up, but any other ways to say it?
I would also put the depreciation factor on the addition.
All right, there you go. Thank you. The estimated level of assessment for the current year is 100%. There was no recent sale of property presented by the assessor, but there was comparable properties. There are 5 total. Other factors presented were, yes, that the cost basis approach was used, which is atypical, so you pointed that out. I don't think any other summary factors were really presented. We are finding then that there was no recent sale of the property. The property owner did not present testimony of recent sales. The assessor presented testimony of recent sales of comparable properties, but we believe the attributes were not satisfactorily adjusted. Also that the assessment should be based on other factors, namely the spillway and loss of frontage and the depreciation factor of the addition, which would also be the most credible evidence of those same three items. And then I'll move that exercising its judgment and discretion pursuant to Wisconsin Statute 70.479A, the Board of Review by majority and roll call vote hereby determines that the assessor's valuation is incorrect, that the property owner has presented sufficient evidence to rebut the presumption of correctness created by law to the assessor, and that the property owner's valuation is reasonable in light of relevant evidence, as well as that the full value of the property is listed at $311,700. Let me do my math again. We'll find out. Don't write this in pen yet. $311,700 with improvements at $205,200. That's rounding to the hundredths, which should get to $516,900, which is the rounded version. How's that sound, Mara?
Good.
All right. So now you can write in pen. $516,900 is the total. $205,200 is the improvements. $311,700 is the land.
Thank you.
And you can roll call us.
Gary Boysetts.
Aye.
Jeremy Kyle.
Yes.
Henry Posberg.
Aye.
Cindy Schmier. Mara Spring.
Aye.
All right. It passes. The assessment will be set to $516,900. Thank you to all for that hearing. We're still in our meeting, so let me find the agenda. Well, there's one other thing, correct? Right?
I don't know. What?
On our agenda it says act on any other legally allowed or required Board of Review matters, which there are none. No other matters, so I'll take a motion to
I'll move to adjourn.
Adjourn?
Second.
All right. All in favor, aye?
Aye.
All opposed, nay? We are adjourned. Sign and die. What do I have to say? Hold on. What do I have to say?
Thanks, guys.
Adjourn, sign and die.
Thank you.
We meant that.
And what time? I'm sorry. 12:45.
12:45, yeah.